Court officer? Court officer? Hello? Court officer? Court officer? Court officer?
No, court officer. Court officer.
ಫೈನಲ್ ಇಯರಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್? ಫಸ್ಟ್ ಲಿಸ್ಟು 1 ಆಗಬೇಕಲ್ಲ ಮೇಡಮ್?
ಸರ್ ಕೋರ್ಟ್ ಹಾಲ್ ಡಿಸ್ಪ್ಲೇನೆ ಬರ್ತಾ ಇಲ್ಲ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಬರುತ್ತೆ
ಸರ್. ಓಕೆ
ಬರುತ್ತೆ ನೋಡಿ. ಬಂತ ಸರ್? ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಆಗ್ಬೇಕು ಮೇಡಮ್, ಪ್ಲೀಸ್. ಲಿಸ್ಟ್ 1 ಆಗ್ದಿರ ನಾವು ಹೆಂಗೆ ಮೇಡಮ್? ಅಯ್ಯೋ ಕಂಪ್ಯೂಟರ್ ಇದೆ ಲಿಸ್ಟ್ ಆಗ್ತದೆ. ಹೌದಾ, ಹೋಗ್ಲಿ ಬಿಡಿ, ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋಣ. ಏನೋ ತಗೊಂಡು ಮೇಡಮ್.
ಸರ್ ಯಾವ ಲಿಸ್ಟ್ ತಗೋತೀರಾ ಫಸ್ಟ್? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್.
ಯಾವ ಲಿಸ್ಟ್ ತಗೋತೀರಾ ಫಸ್ಟ್?
ಮಾಮೂಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಮೇಡಮ್.
ಓಕೆ.
ಇಲ್ಲ ಸರ್ 27.
You must be knowing. Sorry, sir. Oh, oh, that must be. I tell master me. Gopal Vishnu Suri. That I'll be more than first. The first is line over. Yeah, sure. Just to cherish the feeling, having the first man.
Okay, thank you, sir. ಇವತ್ತು ಕಳಿಸ್ತೀರಾ ಅಥವಾ 27 ಬರುತ್ತಲ್ಲ? ಓಕೆ, ನಾವು ಫಾಲೋ ಅಪ್ ಮಾಡಿ. ಅಲ್ಲ ರೀ ಇರಿಂಗ ನಾಯಿ ಕೊಡ್ಲಾ ಬರುತ್ತಾ? ಅರ್ಲಿ ಇರಿಂಗು ಕೇಳ್ಬೇಕಾ? ಸರ್ ಸಂಜೆ ಟಿಫನ್ ಆಯ್ತಾ? ಆಯ್ತು ಟಿಫನ್. ಅರ್ಲಿ ಇರಿಂಗ್ ಕೇಳ್ಬೇಕಾ?
ತೊಗೊಳಲ್ಲ ಸರ್.
ತೊಗೊಳಲ್ಲ
ಎಲ್ಲರೂ ಟ್ರೈ ಮಾಡ್ಬಿಟ್ರೆ
ಏನ್ ಮಾಡೋದು ಬರೋದೇ ಇಲ್ಲ ಮ್ಯಾಟ್ರ್.
ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ.
2023 ಅಪಾಯಿಂಟ್ಮೆಂಟ್
2021-22 ಅವರೇ ತಗೊಳ್ತಾ ಇದ್ರು.
ಯಾರು ಅರ್ಜೆಂಟ್ ಐತೆ ಅವ್ರು ತಗೋಬೇಕಪ್ಪ.
ಮೇಡಮ್ ಎಲ್ಲಿದ್ದೀರಿ? ಮೇಡಮ್ ಬನ್ನಿ ಮೇಡಮ್, ಕೆಲಸ ಇದೆ.
ಏನ್ ಮಾಡೋಲ್ಲ ಸಿಟಿಂಗ್ ಅಂತ ಮತ್ತು
ಇಲ್ಲ ಬಹಳ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಮಹಿಳೆ ಕೊಡಕ್ಕಿಲ್ಲ ಬರ್ತಾರೆ.
ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ? ಅಯ್ಯ ಹಾಕಿದ ಸೀನಿಯರ್
ಮೇಡಮ್ ಅವರೇ ಫೈಲ್ ಇಲ್ಲ ಮತ್ತೆ ಈ ಫೈಲ್ ಇಲ್ಲ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇದೊಂದು ಫೈಲ್ ಆದ್ರೂ ಕೊಟ್ರೆ ಈ ಭಾಷೆ
Let's say one minute. B group matter 2015, it is partly heard also earlier. This one. 30th kindly.
ಫ್ರೆಶ್ ಮೇಡಮ್
ಯಾವ್ದು ಬಿ ಗ್ರೂಪ್ ಅಂದ ಬ್ಯಾಂಕ್ ದ
No, this it's a heard
is it regarding that bank matter?
bank matter, right? DCP D matter.
ಅದ ಬ್ಯಾಂಕ್ ಮೊನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದ
No, different.
ಆಯ್ತು
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ
This is transfer matter yesterday moved, but some reason it was not.
ನೋಡಿ ಅದೇನ್ ಚೆಕ್ ಮಾಡಿ ಯಾಕೆ ಬಂದಿಲ್ಲ
Enter the list below.
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್
That's from Chamarajanagar Institute.
ಯಾಕೆ ಅದು ಬರ್ತಲ್ಲ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರೆ ಯಾಕೆ ಬರಲ್ಲ
ಮಾಡಿದೆ, but they office
Huh?
delayed. Fresh matter,
Your Honor,
ಅವ್ರು ಯಾರು ಹಾ
fresh
ಕಳ್ಸಿ
matter.
ಯಾಕೆ ಅದು ಕರೀರಿ ಅದು ಯಾಕೆ ಬರಲ್ಲ
Your Honor,
ಕರೀರಿ ಅವ್ರು ಯಾರು
May I make one submission, my lord?
ನೋಡಿ ಮೆಮೊ
Your Honor, I have a small submission.
ಯಾರು ಕರ್ಸಿಯೋದು ಯಾರು ಇವರು ಹಾ ಆಯ್ತು 2:30ಗೆ ಅದು ಯಾರು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಯಾಕೆ ಬಂದಿಲ್ಲ ಕರ್ಸಿಯವ್ರು
The reason is, they said that there is a caveat, but caveat, they, by the time they traced the caveat, it was 4 o'clock, then they said it is already closed the board list. Therefore, you can move it tomorrow. That's what they answered before.
Your Honor, it's a fresh matter. It's wrongly posted in photo number 12, Your Honor. ಅದು ಬ್ರೀ ಗ್ರೂಪ್ ಗೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಕೂಡ ಮಾಡಿ ಮತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಬಟ್ ಆದ್ರೂ ಪೋಸ್ಟ್
ಏನಕ್ಕೆ ಬರ್ಬೇಕಪ್ಪ ಬಿ ಗ್ರೂಪ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್, Your Honor.
ಫಾರ್ ವಾಟ್ಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾಕೆ ಬಿ ಗ್ರೂಪ್ ಬರುತ್ತೆ
ಅದು ಬಿ ಗ್ರೂಪ್ ಗೆ ಅವರು ರಾಂಗ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು
ನೋಡಿ,
ಫೋಟೋ ನಂಬರ್ 12 ಮಾಡಿದ್ದಾರೆ.
ಚೆಕ್ ಮಾಡಿ
May I make one submission, my lord?
ಮ್ಯಾಟರ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಹಾ ಆಯ್ತು
For being spoken.
ಆರ್ಡರ್ಸ್ ಗಳು
Appeal came to Bangalore, Malad. The respondent
ಏನ್ ಹೇಳ್ತೀರಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲಪ್ಪ
The respondent, Malad, have not complied order of this honorable court for the reason that, Malad, there is no specific direction or order for regarding apportionment of award, and as well as there is no direction to release the amount, Malad, in favor of the claimants, Malad. That's why, Malad,
ಅಲೋಡ್
please, Malad.
ಆಯ್ತು ಆರ್ಡರ್ಸ್ ಹಾಕಿದೇನು
For admission, service matter, Malad.
ಪ್ಲೀಸ್ ವೆಯ್ಟ್ ಮಿಸ್ಟರ್ ಎಸ್
Lord, there are applications pending in these two petitions, not for
Ah.
direction. Any convenient date, my lord.
ಆಯ್ತು ಆರ್ಡರ್ಸ್ ಹಾಕಿ ಎರಡೆರಡು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ
ಅದೇ ಎರಡಿದೆ,
ಎರಡು ಅದೇನಾ
ಎರಡು ಇದೆ.
For early hearing application, 2023 matter, and seeking appointment and Malad and round of handicapped capacity, Malad.
ಆಯ್ತು
Oh, may I make one submission?
ಪ್ಲೀಸ್ ವೆಯ್ಟ್ ಎಸ್
Fresh matter, Malad, for admission, Malad.
ನೋಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಡೋಂಟ್ ಇವನ್ ಆಸ್ಕ್ ಮೀ ಬಂದ್ ಮೆಮೊ ಕೊಟ್ಟು ಹೋಗ್ಬಿಡಿ
May I make one submission, my lord? It's a lordship's permission.
ಪ್ಲೀಸ್ ವೆಯ್ಟ್
Adjournments, list number 1, page wise, page number 6, serial number 25 to 28. Page number 7, serial number 29 to 34.
Millets,
8,
serial 34 millets. I request for 2 weeks time, millets. Engaging council is suffering from throat infection, millets.
ನೋ ಐ ಕ್ಯಾನ್ ಗ್ರಾಂಟ್ ಯು ಟೈಮ್ ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ಕಾಸ್ಟ್
Millets, he is suffering from throat infection, millets. Fast for
do whatever you want, but you
Yes,
have to
millets.
pay cost. Sorry.
A
Cost
week.
ಕಟ್ಟಿ ಟೈಮ್ ತಗೊಳ್ಳಿ
Millets, in the last date of hearing, I only moved the memo and requested for
ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ದು
millets.
ಎಷ್ಟು ವೆನ್ ಡು ಯು ವಾಂಟ್ ಇಟ್
My lords, 2 weeks time, my lords.
2 weeks ಅಂದ್ರೆ 10,000 ಆಗುತ್ತೆ.
My lords,
On 2 weeks it is 10,000.
he is suffering from throat infection, my lords.
Somebody has to argue. If you want 2 weeks, 10,000, 1 week, 5,000. How much you want?
My lords, at least next Tuesday, my lords.
2,000.
My lords, please.
Work out. Learned counsel for the petitioner seeks time. The request for time is not justified as the petition is pending since CS 2013. And however, as a last chance, time is granted up to Tuesday, subject to payment of cost to rupees 2,000 payable to the Advocates Association Library. Yes, list on Tuesday. 2,000 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕು ಲೈಬ್ರರಿಗೆ.
Much.
Page number 8, serial number 35 to 35 and 36. Page number 9, serial number 37. Page number 10, serial number 38 and 39. Page number 11, serial number 40 to 43. Page number 12, serial number 44 to 50.
Lordship, serial number 46, Lordship. The government has issued the notification. I pray for days accommodation to produce the.
Is that
Yes,
Vera?
Lord. Please, Lordship.
Paper little. Some yaru Rakesh Singh
Rakesh,
is appointed as the
please, Lordship.
chairperson.
Please, Lordship.
The learned age counsel for respondent number 3 seeks time to place on record the notification appointing the chairperson of K. Rera. List on Tuesday. List on Tuesday.
Number 13, serial number 51 to 54. List number 2. Page number 5, serial number 3 to 11.
My lord, I am serial number 4. It is in the stage for the final hearing. My opponent advocate called and he will not able to come. So I am seeking next week time.
5,000. 1 week is 5,000, 2 weeks is 10,000, 3 days is 2,000.
By Monday to Wednesday, any day I can.
Wednesday,
Wednesday,
2,000.
I have to pay for that.
You have to pay to the Advocates Association Library.
Okay.
2,000. List on Wednesday, Friday, 30th.
30th.
Hangire
Still it is
5,000 ಮಾಡಿ.
5,000. Okay.
2,000.
Next.
Page number 6,
Oblast.
serial number 12 to 18. Page number 7, serial number 19.
Sorry.
List number 1 for order, serial number 1. Somsekhar.
Pay for the petitioner, madam.
ಯಾರು ಕಟ್ಟಬೇಕು 5,000?
I have
Respondent.
Ready ಇದೀರಾ?
Yes.
Then we'll take it up immediately after this first round. First round ಆದ್ಮೇಲೆ ತಗೊಳ್ಳೋಣ. Please. Pass over. ಹೇಳಿ ಕಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಎಲ್ಲ ಡೌಟ್ ಮಾಡಕ್ಕೆ.
Serial number 2, Parthasarthi MS.
I pay for the petition.
ಯಾರು ಮಿಸ್ಟರ್ MP ಶ್ರೀಕಾಂತ್?
Serial number 2,
Pass over. ರೆಡಿನಾ?
ಇದ್ರಲ್ಲಿ ಒಂದು ಫಸ್ಟ್ 2014 ಅಲ್ಲಿ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಅದು
ರೆಡಿನಾ ಇಲ್ವಾ ಹೇಳ್ರಿ.
ಲಾರ್ಡ್ಶಿಪ್ ರೆಡಿ ಇದೀವಿ ಸ್ವಾಮಿ. ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು ನಾವು.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್.
serial number 3, Girish V. Bhatt.
1 week time is granted to rectify the office objections. ಅದೇನು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ನೋಡಿ ಅದ್ರಲ್ಲಿ serial number 3 ನಲ್ಲಿ. Failing which, comma, the interim order granted on so and so shall stand vacated automatically. Yes. Serial number 4.
Number 4.
My lord,
Ravishankar A.
I request
academic grade pay, which my learned friend.
my lord, I request this matter to be had on
ಏನ್ matter ಇದು?
28th.
With grade pay, there is
I have
also
to
a
get some
notification.
response.
I'm a tutor in a medical college.
Learned seeks time to secure the
They-
approval of
they are
finance
seeking
grant
time.
of AGP.
ಅದೇ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ತಮ್ಮಂದಕ್ಕೆ.
Kindly have it on 28th, my lord, I will get it.
Your instructions to comply the order 2024. List on 29th. 29th.
Please.
28th or 29th?
29.
29th.
Serial number 5, Ranganath S. Joyce.
One week time is granted to do the needful.
In fact, last occasion, your lordship order
respondent.
notice to, they have already represented, my lord, the government is
ಏನೋ
also
ಗೊತ್ತಿಲ್ಲ,
represented.
IA 1/24 ಏನೋ
Adu
ಹಾಕಿದ್ದೀರಿ.
impleading the government, my lord, earlier, that government also taken notice already, my lord.
ಅಲೋ ಆಗಿದ್ಯಾ?
Notice ಆಗಿದೆ, allow ಆಗುತ್ತೆ. Already notice of the order.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಬಟ್ ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ನೀವು?
ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಪ್ರೋಸೆಸ್ ಕಾಪಿ ಸರ್, ಪ್ರೈವೇಟ್ ಯೂನಿವರ್ಸಿಟಿ ಲಾಯರ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಾಗಿದೆ, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೂ ಅಷ್ಟೇ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗಿದೆ, ಕಾಪಿ ಸರ್ವ್ಡ್ ಮೈ ಲಾರ್ಡ್ ಆಲ್ರೆಡಿ. ಅದು ಅರ್ಲಿಯರ್ 22/7 ಅಲ್ಲೇ ನೋಟಿಸ್ ಆಗಿದೆ, ಕಾಪೀಸ್ ಕೊಟ್ಟಾಗಿದೆ. ಆಮೇಲೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ಯೂನಿವರ್ಸಿಟಿ ಫೈಲ್ಡ್ ಎ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಸಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೇಯಿಂಗ್ ದಟ್ ದಿ ಫಾದರ್ ಆಫ್ ದಿ petitioner was a government servant. But the petitioner is seeking for family pension because
ಬರ್ಕೊಳ್ಳಿ IA 1/24. He is filed to implead the state government as respondent number 3 in this writ petition.
If I may be permitted, state government is already this thing, the accountant general na party ಮಾಡ್ಬೇಕಂತ previous justice before justice Shyam Prasad, because
Order, you can't
Lordship,
call him as Shyam Prasad, Mr.
sorry, justice. Before that, he had mentioned that accountant general had to be made part. Because the office of accountant general is the one which will
Order. ಯಾವತ್ತಾಗಿತ್ತು ಆರ್ಡರ್ ಅದು?
ಅದು 22/7 ಗೆ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ I had mentioned that office of accountant general has to be made a party.
It says the answering respondents will have to be government and its appropriate officers.
appropriate officer ಅಂದ್ರೆ ಅವ್ರ ಅಕೌಂಟೆಂಟ್ ಜನರಲ್.
Accountant general ಅಂತ because I had filed.
Impleaded government, I will accountant general also I will.
ಮತ್ತೆ ಅದ್ ಮಾಡಿ ಹೆಂಗಿದ್ರೆ?
ಮಾಡ್ತೀನಿ.
Learn counsel for the ಇದು IA 1/24 is filed by the petitioner to implead the state government as respondent number 3 na? 3 or 4?
3 minutes, because 2 already there was.
Respondent number 3. So in view of the order passed by this court dated
22/7.
24/6/2024. The application filed by the petitioner deserves to be allowed. Consequently, IA 1/24 is allowed and the proposed respondent is ordered to be brought on record as respondent number 3. Counsel for the petitioner is directed to amend the writ petition and also serve a copy of the writ petition to the learned AGA. Full stop. Next, for learned counsel for the petitioner seeks time to implead the accountant general
Additional.
as respondent number 4. Full stop. Hence list on date.
My apologies.
Huh?
Apologize, a mistake.
Then don't repeat that mistake.
I apologize.
He has earned it, Mr.
My apologies.
He has earned that. Don't call him by your.
Justice
As if he's your.
Sorry, my lord.
Bumper.
Apologize, sorry. My sincere apologies.
Subramani, what?
In this case,
Serial number 6, my lord, my statement of objections are ready, but I not file it, my lord.
Now, my lord, kindly turn to the, I request your lordship to kindly have a look at the last order. Lord, my grievance my grievance is that, Lord, even though I had retired from services on 31/5/2023, my pension proposal has not been forwarded by my employer to the government. So in that time, Lord, the Honorable Court was pleased to issue directions to file the response. No doubt, Lord, R4 has filed its response, but there is not even a whisper regarding my pension proposal.
Who has to answer?
Now, my lord, fourth respondent has to forward the pension papers to the second respondent, who in turn, my lord, is required to sanction the pension. So far, my lord, even after lapse of 2 months, not even an inch, my lord, the matter is.
2 months ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಈ ದೇಶದಲ್ಲಿ?
I represent the R4. Lordship,
Is there any specific reason for not sending?
Specific reason, he was not produced his experience certificate and insurance certificate. Therefore, he is not eligible to get those.
Mr. is retired from service.
Please, Lordship.
Experience certificate in bantu. Under what provision of law you're asking that?
There the third respondent direction to us to get those document and forward. Then same we have
Who is third respondent?
Third respondent is the director, joint director.
joint director. I think my statement of objection not
Elli the third respondent ಎಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ? Where is the document?
ಅದು ನಾನು ಹಾಕಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ನು ಪುಟಪ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತದೆ.
ಇದು ಯಾವ್ದೋ ಒಂದು ಆಗಿದೆಯಲ್ಲ.
21st ಹಾಕಿದೀನಿ.
ಹೌದಾ?
R414 ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ಬಂದಿದೆಯಲ್ಲ.
ಇದರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ. R14 your lordship kindly take the R14. ಪೇಜ್ ನಂಬರ್ 34 ಅದರಲ್ಲಿ 35 ಲಾಸ್ಟ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ. ಈ ಥಾಮಸ್ ವರದಿ ಜಾರಿಗೊಳಿಸಲು ಕೋರಲಾಗಿದೆ. ಸಿಬ್ಬಂದಿಗಳು ನೇಮಕಾತಿ ಪೂರ್ವದಲ್ಲಿ ಸೇವಾ ಅನುಭವ ದಾಖಲೆಗಳನ್ನು ಸಂಸ್ಥೆಗೆ ನೀಡಿರುವುದಿಲ್ಲ.
ಥಾಮಸ್ ವರದಿ ಅಂದ್ರೇನು? PSS ಥಾಮಸ್ ವರದಿ ಅನುಷ್ಠಾನಕ್ಕಾಗಿ ಆಯುಕ್ತಾಲಯದಿಂದ ನೀಡಿರುವ ಮಾರ್ಗಸೂಚಿ ಆದೇಶದಂತೆ ದಿನಾಂಕ 1/4/2006 ಮೊದಲು ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಿರಬೇಕು. ದಿನಾಂಕ 1/12/2014 ಅನುದಾನಿತ ಸಿಬ್ಬಂದಿಯಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರಬೇಕು. ಅನುದಾನಿತ ಸಂಹಿತೆ 97 ನಿಯಮ ಆಚಾರ್ಯ ತರಬೇತಿಗೆ ಪ್ರಾಯೋಗಿಕ ಅನುಭವ ಮತ್ತು ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿರಬೇಕು. ಮೂಲ ವೇತನ ಕನಿಷ್ಠ 6.25 ಪ್ರೀಮಿಯಂಗೆ ಜೀವ ವಿಮೆ ಹೊಂದಿರಬೇಕು. ಕನ್ನಡ ಭಾಷೆ ಏನ್ ಥಾಮಸ್ ವರದಿ ಅಂದ್ರೆ ಏನಿದು?
Lord Thomas, Lord, one man committee was formed to examine the service conditions, my lord, of the employees working in the private ITIs. My lord, that committee submitted report saying that, my lord, the employees working in the ITI, they are entitled for all the service conditions, my lord, which are applicable to the private aided educational institutions. So consequently, my lord, the employees working in the ITIs, private aided ITIs are also entitled for all service benefits.
As per the report of Thomas.
Yes, my lord.
ಮತ್ತೆ ಅದರ ಪ್ರಕಾರ ಕೊಡಬೇಕು ಅಂದ್ರೆ ಕೊಡಿ.
ಇಲ್ಲ, everything is with the management. Now the management has to forward a proposal. That, my lord, the management is not doing.
We have given request them to produce that two certificates.
What
one is the experience certificate, one is the insurance one.
ಅಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ನಿಮ್ಮ ಹತ್ರ ಇರಲ್ವಾ?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು.
ಅಲ್ರಿ ನಿಮ್ಮ ಹತ್ರ ತಾನೇ ಕೆಲಸ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಅರ್ಲಿಯರ್ ವೆನ್ ಜಾಯಿನ್ ಆಗೋದಕ್ಕೆ ಮುಂಚೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ 2 years ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದ್ರೆ ತಗೊಳ್ತೀವಿ ಅಂದ್ರೆ 2 years ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ ಅಂತ ಇದನ್ ಮಾಡಿದ್ದಾರೆ, ತಗೊಂಡಿದ್ದಾರೆ. ಆ ಸರ್ಟಿಫಿಕೇಟ್ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ. ಇದು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹತ್ರನೂ ಇಲ್ಲ.
ನಿಮ್ಮ ಹತ್ರ ಎಲ್ಲೋ ಇರ್ತದ?
ನಮ್ಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ. ಅದು ಕೊಡ್ತೀವಿ ಅಂದ್ರು ಹಂಗೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅವರು ಯಾರು
ಹೆಂಗ್ ಸೇರಿಸ್ಕೊಂಡ್ರಿ ನೀವು ಕೆಲಸಕ್ಕೆ?
ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು, ಒರಿಜಿನಲ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತಾ ಇದೆ. ಆಮೇಲೆ ಇನ್ಸೂರೆನ್ಸ್ನು ಮಾಡ್ಲಿಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ. ಅದು 2 ಕೊಟ್ರೆ ಥಾಮಸ್ ಇದು ಪ್ರಕಾರ ಅನುಷ್ಠಾನ ಪ್ರಕಾರ ಈಸ್ ಎಲಿಜಿಬಲ್ ಟು ಗೆಟ್. ಅದು 2 ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರೆ ವಿ ರೆಕಮೆಂಡ್.
ಯು ಹೆಲ್ಪ್ ಟು ಹೆಲ್ಪ್ ಯುವರ್ ಸೆಲ್ಫ್. ಏನೋ ಒಂದು ಮಾಡಿ.
I will put a word to my client.
This is going to only protract. ಇವ್ರು ಕೊಡಲ್ಲ, ಅವ್ರು ಬಿಡಲ್ಲ.
ಇಲ್ಲ, ಗೊತ್ತಿಲ್ಲ, ನನ್ನ ಕ್ಲೈಂಟ್ ಹತ್ರ ಇದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. I'll just
ಯಾವಾಗ ಹೇಳ್ತೀರಿ?
by 1 week, Lord, next week, Lord.
AGS seeks time to file statement of objections. List on date. Is Anusha L.
This is the reduction of salary during the COVID time.
Pardon?
Reduction of salary during COVID time. The relief is sought for.
Yes, Mr.
I appear for respondent number 4 and 5, my lords. I seek for a week's accommodation, my lords. I'm yet to receive any instructions with respect to this aspect. After a week, I shall do so, my lords.
I to take some time and pay the salary. You can't deny.
But I should receive some instructions, my lord. That is why.
Learn counsel for the respondent number 4 and 5 seeks time. List on Yavat.
Any date, my lords.
AICT, my lord, UTU. Both universities, my lord, directed during the COVID time, nothing should be done.
Please, I asked him with Kodakian problem.
Much obliged.
Behalf of respondent number 3 and 4, my lords, copies.
What is IA 1/24?
Copies have not been served.
ಈ WP ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ?
ಹೌದು, ಡಿಸ್ಪೋಸ್ ಆಗಿದಾವೆ ಸ್ವಾಮಿ. ಬೇರೆವೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದಾವೆ.
ಏನಿದು?
I sought for regularization, my lord.
No, what is this IA 1/24?
The committee has been formed and regularized the services of the petitioners.
You want the petition to be disposed of in the same terms.
How the house?
19588 ಪ್ರಕಾರ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದೀರಾ?
ಮಾಡಿ ಅಂತ ಕಳ್ಸೇನೆ ಲೋಕೇಶ್.
ಎಲ್ಲಿದೆ ಕಾಪಿ ಅದು 19588? Where is the copy of the order, sir?
ಹಾಜರ್ ಪಡಿಸಿಲ್ಲ.
ಹಾಜರ್ ಪಡಿಸ್ಬೇಕಲ್ವಾ?
ಅವ್ರಿಗೂ ಗೊತ್ತು ಲೋಕೇಶ್ ಅಂತ ಅವ್ರದ್ದು ಹತ್ರ.
Lords, copies have not been served. However, my lords, the prayer that is sought against the respondent number 3 and 4. with
Madam,
not
is it
pres-
covered by the judgment of this court in WP number? Please note it down. 19588 of 23 dated 9/5/24. Please check it whether it is covered or not, whether it relates to the same department.
Please, my lords. However, my lords, one more submission is with respect to the prayer that they've sought against respondent number 3 and 4, not to precipitate with the final selection list, my lords. Selections have already been made and appointment orders have already been given, my lords. The petitioners are the contractual workers under respondent number 3 and 4.
No, the persons who sought to be appointed are also contract employees.
No, my lords.
Huh?
Now the ones who are appointed by virtue of the final selection list are the departmental workers, my lords.
Are they contractual employees or is it a regular recruitment?
Regular recruitment. my
What is there to show that?
My lords, I'll produce along with
Learned
the
counsel for the
document.
respondent seeks time to place on record documents to indicate that the respondent 3 and 4 have taken out publication for, have regularly recruited candidates for the posts of the petitioners. List on,
Lords, on 30th, my lords.
list on 30th.
Please.
Serial number 9, Shruti ST.
List after note, service of notice to respondent number 7.
For 10,
The IA 1 of 24 is allowed on the money. Yes. Serial number 10, same order, R5.
Interim order may be extended.
Interim order is extended to the next date.
number 11, Narsim Raju.
Same order. Huh?
Order has been recalled. I filed. a
Transfer
memo.
order, impugned order has been recalled.
The impugned order is recalled. Then what remains?
As far as the petitioner and fourth respondent is concerned, recalled.
At the end, what remains?
Nothing.
Barcode.
Already filed a memo.
The learned counsel for the petitioner submits that the order challenged in the present writ petition is already recalled by the respondent number
3 and 4.
3 and 4. 2 and 3 now.
That-
Or 2 and 3.
2 and 3. Full stop. The learned counsel for the respondent 2 and 3 submits that a memo to that effect is already filed before the court and therefore this writ petition has become infructuous.
Please,
In view of the aforesaid submission, this petition is dismissed as having become infructuous.
please.
For 12, Samartha Prakash. Samartha Prakash.
Steps have been taken, my lord, with respect to R2.
Why you not taken out, paid the process?
Process was, I mean, my lord, what had happened, by inadvertence, they had paid for R1 instead of R2, my lord. R2 has been taken now, my lord.
What is there to show that you paid for R1?
R1 they have paid, my lord, my colleague had informed me. that he had paid.
R1 ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
R1 ಕಟ್ಟಿದಾರಂತೆ ಸ್ವಾಮಿ. ಅದು.
ಎಲ್ಲಿ? ಕೊಡಿ ತೋರ್ಸಿ.
ಅಲ್ಲ, ಇವತ್ತು R2 ಕಟ್ಟಿದೀನಿ.
R1 ಗೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೊಡಿ.
What I was,
R1 ಗೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? You said R1 ಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
that's what I was informed, my lord. I asked him, ಅದೇನೋ misplace ಮಾಡ್ಕೊಂಡಿದಾರಂತೆ. But I have,
I'll vacate the interim order.
my lord.
ಈ transfer matters ಅಲ್ಲಿ, I know that this is the
No, my lord, it was bona fide error, my lord.
You don't pay the process and notify the
Bona fide error, my
respondent.
lord.
Sorry.
My lord, a date may be fixed, my lord. It's a bona fide error, my lord.
No, no, no.
My lord, my humble request, my lord.
The bona fide error, it is you explain to your client.
My lord, my humble request, my lord.
No, sorry,
My
if you
lord,
don't,
my lord,
how did you get the copy, mister? How did you get the copy of the interim order when you not paid the process?
No, my lord, I took steps. I served it upon R1, my lord. R1 I
So
served.
how did you get the certified copy?
I haven't taken the certified copy yet, my lord.
Order copy ಇನ್ನ ತಗೊಂಡಿಲ್ಲ.
So,
7ನೇ ತಾರೀಕು ಆಗಿರೋದು ಆರ್ಡರ್.
ಹೌದು, ಅಲ್ಲ ಆನ್ಲೈನ್ ಅಪ್ಲೋಡ್ ಆಗಿತ್ತು ಅಷ್ಟೇ ಸ್ವಾಮಿ. I haven't taken that.
ಬರ್ಕೊಳ್ಳಿ.
My lord, please, my lord, my lord,
No, no.
my lord. My humble request, my lord, party will be put to
Court had
great
granted-
inconvenience, my lord.
This
Lord,
court had
party will
granted
be,
an
my lord, my
interim
humble
order
request, my lord, my
on
sincere
7
apologies, my lord.
2024.
My lord, my lord, my lord,
However,
please, my lord,
process to issue notice to respondent number 2
my
is
lord,
not furnished from 7/8/2024.
my lord, as last, I've taken steps today, my lord.
As a result,
My lord, My lord,
The
he'll be
notice to
put
the
to great
respondent number
inconvenience, my
two.
lord.
As a result, a notice to the respondent number 2 is not served.
My lord,
Full stop.
my humble
Hence,
request, my lord.
1 week time is granted.
I've taken steps, my lord, today. Steps
and
are
full
done.
stop.
Needful is done, my lord.
Therefore, the interim order granted on 7/8/2024
My lord,
is modified.
my lord,
Is recalled.
my lord, please, my lord.
Full stop. Yes. No,
My
sorry.
lord, my lord,
So
please, my
don't
lord.
pay the process.
My lord, I've taken steps today, my lord. He'll be put to great inconvenience, my lord.
No,
my lord,
sorry.
My lord,
Transfer matters.
my lord, he has only 1 year to.
Transfer
I
matters
completely
ಅಲ್ಲಿ
understand.
transfer matters ಅಲ್ಲಿ
Also,
ಇದೇ ತರ ಮಾಡೋದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, I have no legs.
Process ಕೊಡಲ್ಲ. Sorry.
I have no legs to stand, my lord. My lord, I may just be heard for a minute, my lord. He has less than a year. He has one year service, my lord, left,
Whatever
and he's
it
been transferred, my lord. That's why,
Whatever it is.
my lord, please, my lord. Next week, any date, my lord. I've taken steps, my lord.
Sorry.
My lord, please, my lord.
Sorry, Mr.
My lord, I'll be put.
Next.
Party will be put to great inconvenience, my lord. My lord, my humble request, my lord.
Without batting an eyelid, I grant an interim order.
My lord,
and
no, my
two
lord. I
people-
completely understand, my lord. Yes, my lord. I am at fault, my lord. My lord, please, my lord. I request your lordship to
Fault again. Fault again ಮಾಡ್ತೀರಿ.
My lord,
For the fault that you have committed, what?
cost may be imposed, my
ಎಷ್ಟು?
lord. 2,000 rupees, my lord.
5,000 to the advocates library.
Please, my lord.
ಇದ್ ಮಾಡಿ. 1 week time is granted to pay the process.
My lord, I've needful is done.
The learned counsel for the petitioner submits that the process is paid. Office is directed to check and verify and proceed to issue notice to respondent number 2. Since the process is not paid, to issue notice to the respondent number 2 from 7/8/2024 till date, cost of rupees
2,000, my lord.
2,000 is
Much
payable by the petitioner to the advocates library fund. Don't do this, Mr.
No, my sincere apologies, my lord. In fact,
ಕಷ್ಟಪಟ್ಟು interim order ತಗೊಂಡ್ರೆ ನೀವು ಇಷ್ಟು ನೆಗ್ಲಿಜೆಂಟ್
in fact, my colleague also, but I have no, I will not comment, my lord. My
Don't put
sincere
it on your
apologies.
colleague. Who should take the responsibility.
Please, my lord. Yes, my lord.
Number 13.
Sorry, my lord.
Want to see
R7.
that we represented by the government, my lord, R7, my lord, I served the copy and I also
Yes, sir.
produced the acknowledgement to the court, my lord, on 7/8/2024, my lord.
Yes, madam. Process, sir?
Process is the government, my lord, we have served the copy and the filing.
R1 to R6. Yeah, R1 to R6.
State, first respondent is the state, my lord, second joint director, my lord, of women and child welfare.
ನೀವು ಯಾಕೆ
department.
ಪ್ರೋಸೆಸ್ ಯಾಕೆ ಕೊಡಲ್ಲ ಅಂತ ಕೇಳೋದು.
ಇಲ್ಲ ಇದು ಪ್ರೋಸೆಸ್ ಏನು ಬರಲ್ಲ
ಹಾ?
ಇದು ಪ್ರೋಸೆಸ್ when government is representing my lord.
ಗವರ್ಮೆಂಟ್ ಇರ್ಲಿ, ಬಟ್ ವಿ ಆರ್ ನಾಟ್ ಇಶ್ಯೂಡ್ ನೋಟಿಸ್ ಟು ದಿಸ್.
ನೋಟಿಸ್ ಅಂತಾನು ಮಾಡಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗಾಗಿ ನಾನು ಕೊಟ್ಟಿಲ್ಲ, ಮಾಡಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. AGS director accept notice for respond number 1, 2, 3,
1 to 6.
5, 6. What about chief executive officer 4?
Chief on behalf of the deputy secretary of Jilla Panchayat.
Huh?
Notice has to be.
Issue notice to respondent number 4. You 7 ga?
7. So my
Seven.
only submission is that last hearing, lordship has granted the interim order. She's working there, ಅಲ್ಲಿ work ಮಾಡಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ. She's ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಬರಬೇಡ ಅಂತ. My only submission, Swami. Kindly look into their petition.
My lord, my.
ಅಲ್ಲಲ್ಲ ಅವ್ರ petition ಅಲ್ಲಿ ಸ್ವಾಮಿ ಪ್ಯಾರಾ ನಂಬರ್.
Is also.
ನೀವ್ ಯಾರು?
I appear for 7. I am presently working.
How are you related to the deceased? How are you related to the deceased?
I am the wife.
First wife?
ಅಲ್ಲಲ್ಲ not first wife ಸ್ವಾಮಿ.
ಮತ್ತೆ ಇದನ್ನ ಇವ್ರು wife ಅಂತ
ಅಲ್ಲಲ್ಲ ಅದು ಬೇರೆ ಸ್ವಾಮಿ. See initial.
My lord, my claim, my lord, before this petition, before this honorable court is, my lord, I am a widow at the time of filing the applications, my lord. When I was appointed, my lord, on 29/2022. That was challenged by the respondent number 7 before this honorable.
7 ಯಾರು?
Ivre, Shivamma.
ಅಲ್ಲ ಅವರೇನೆ, ಅವ್ರು ಯಾರು?
I was also a candidate.
Applicant, madam.
Madam, how is she related to the deceased, madam? ಅವರು ಅಂದ್ರೆ how is she related to the deceased?
She is not related to the.
At least ಏನಂತ claim ಮಾಡ್ತಾರೆ ಅದನ್ನಾದ್ರೂ ಹೇಳಿ.
Our Anganwadi worker, my lord, they filed an application for appointment of Anganwadi worker. I also filed an appointment of Anganwadi worker, my lord. I has been selected, my lord. On 29/2022. That was challenged by this seventh respondent herein, my lord.
ಹಾ
That-
ಆಯ್ತು ಅವ್ರು ಕೆಲಸ ಮಾಡಿ ಕೇಸ್ ಗೆದ್ರೆ ನಿಮ್ಗೆ ಆ ಕೆಲಸ ಕೊಡ್ತಾರೆ. ವೈ ಆರ್ ಯು ಡಿಸ್ಟರ್ಬಿಂಗ್ ಹರ್?
Well, I am not disturbing, my lord.
Status
I
quo
was
can be-
continued, my lord. Kindly see annexure
ನೀವು
H,
ಕೆಲಸ
my lord.
ಮಾಡ್ತಿದ್ದೀರಾ?
ನಾನ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ನಾವು
ಮಾಡ್ತಿದ್ದೀರಾ?
ಮಾಡ್ತಾ ಇದ್ದೆ ಸ್ವಾಮಿ. ಈಗ
ಈಗ ಮಾಡ್ತಿದ್ದೀರಾ?
1 month ಇಂದ they have terminated, my lord.
ಯಾವಾಗ?
For 1 month.
ವಾಟ್ ಇಸ್ ದ ಡೇಟ್ ಆಫ್ annexure K?
Annexure K is 5/7/2024, my lord.
5/7?
My lord.
They have appointed me after that one.
5/7/20.
Now I am I'm holding that post.
My lord, she has been appointed.
When was the
annexure
writ petition filed? 5/8. After 1 month.
5/8, my lord.
After 1 month you have filed. So she is already working.
I'm working.
My lord, I have not given any charges, my lord. I have not given
Charges
charges, my
ilva-
lord.
ತೆಗೆದಾಕ-
Because since, my lord, I was
Hold.
been working, my lord.
We'll consider that. The learned counsel for the Kevita respondent number 7 submits. ಇದು ನಿಮ್ಗೆ ಹಿಯರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಲ್ರಿ ಇದು?
ಇಲ್ಲ ಸರ್, ನಾನು ಹಿಯರ್ ಅಂದ್ರೆ ಅವ್ರು ಹಿಯರ್ ಮಾಡಿದ್ರು, ನಾನು ಬಂದು
Hear ಮಾಡಿ
ನನಗೆ ಅಲ್ಲಲ್ಲ
Learned counsel for respondent number 7
They
seeks time to file
an
objection.
ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಗೆ ರೆಕಾರ್ಡ್ಸ್ ಗೆ ಸ್ವಾಮಿ ಐ ಫೈಲ್ ಮೈ ಅಬ್ಜೆಕ್ಷನ್.
Objection ಹಾಕಿಲ್ಲ?
ಇನ್ನು ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ ಶಾರ್ಟ್ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಕೈಂಡ್ಲಿ ಅವಿಲ್ಲ.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎನಿ ಡೇಟ್ ಸ್ವಾಮಿ.
ನೀವ್ ಹೇಳಿ ಯಾವತ್ತು ಬೇಕು ಅಂತ.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಸ್ವಾಮಿ.
ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೆನ್ಸ್ಡೇ.
ಇದುವರೆಗೂ ಬಟ್
Entry wanted to be
ಅಲ್ಲ
continued.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ನಂಗೆ ಜಾಬ್ ಹೋಗಕ್ಕೂ ಬಿಡೋದಿಲ್ಲ.
8/8/2024.
ನಾನು ಜಾಬ್ಗಳಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಲ್ವೇನ್ರಿ?
ಆಯ್ತು ಸ್ವಾಮಿ, ಹಾಕ್ತೀನಿ.
For hearing on IS, serial number 14, Abu Bakr Shafi.
Abubakar Shafi. There is no representation for the petitioner. Yes, list on ಕೊಡಿ. ಸೆಪ್ಟೆಂಬರ್ ಆದ್ಮೇಲೆ ಸೆಪ್ಟೆಂಬರ್ ಎಂಡ್ ಕೊಡಿ.
September. Serial number 15, Narendra Gowda.
Yeah. List this petition on 23/8. Hi, ಏನ್?
This case, my lord, the petitioner is seeking to fix the higher pay scale of AAO from the service period of
Seeking for?
higher pay scale of AAO for the service period of 14 years from 29/4/1983 to
29/4?
1983 to 24/9/1997. He made a representation as per Annexure B. That has been rejected by the authority as per Annexure C.
ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ?
Annexure C ನ ಸ್ವಾಮಿ.
ಓದಿ.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವೆಂಕಟರಮಣಯ್ಯ ನಿವೃತ್ತಿ ಸಹಾಯಕ ಹಿರಿಯ ಸಹಾಯಕರು ಉನ್ನತ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಸೌಲಭ್ಯ ನಿಗದಿಪಡಿಸಲು ಮನವಿ ಸಲ್ಲಿಸಲು ಸರಿಯಷ್ಟೇ. ಸದರಿ ನೌಕರರು ದಿನಾಂಕ 11/12/61 ಎರಡನೇ ದರ್ಜೆ ಗುಮಾಸ್ತರಾಗಿ ಸೇವೆಗೆ ಸೇರಿರುತ್ತಾರೆ. ಜನವರಿ 1972 ಮಿನಿಸ್ಟ್ರಿಯಲ್ ಹೈಯರ್ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾದ ಪ್ರಯುಕ್ತ ಮೊದಲನೇ ದರ್ಜೆ ಗುಮಾಸ್ತ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ನೀಡಿ ಗುಲ್ಬರ್ಗಾ ವಿಭಾಗದಲ್ಲಿ ದಿನಾಂಕ ರಲ್ಲಿ ಕರ್ತವ್ಯ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಮುಂದುವರಿದು ಸದರಿ ನೌಕರರು ಒಂದೇ ಹುದ್ದೆಯಲ್ಲಿ 10 ವರ್ಷ ಸೇವೆ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಉನ್ನತ ವೇತನ ಶ್ರೇಣಿಯ ಅಧೀಕ್ಷಕ ನಿರೀಕ್ಷಕರು ಮೈಸೂರವರು ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ 26/2/2083 ಪತ್ರದನ್ವಯ ಮುಂದಿನ ಉನ್ನತ ಶ್ರೇಣಿಯನ್ನು ದಿನಾಂಕ 25/11/82 ನೀಡಲಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 29/4/83 ಹಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ಹೊಂದಿ ಬೇಲೂರು ವಿಭಾಗಕ್ಕೆ ಉಪವಿಭಾಗಕ್ಕೆ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಸದರಿ ಅವರು ಈಗಾಗಲೇ ಉನ್ನತ ವೇತನ ಶ್ರೇಣಿಯ ನೀಡಿರುವ ಕಾರಣ ಮುಂದಿನ ಉನ್ನತ ಶ್ರೇಣಿಯಲ್ಲಿ ಸೌಲಭ್ಯವನ್ನು ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಶ್ರೇಣಿಯ ದಿನಾಂಕ 29/4/97 14 ವರ್ಷ ಸೇವಾವಧಿ ಮಂಜೂರು ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲವಾದ್ದರಿಂದ ಹಾಗೂ ಉನ್ನತ ಶ್ರೇಣಿಯನ್ನು ಹಿಂಪಡೆದು ನಿಗದಿಪಡಿಸಲು ಅವಕಾಶವಿಲ್ಲವಾದ್ದರಿಂದ ಸದರಿ ನಿವೃತ್ತಿ ನೌಕರ ಉನ್ನತ ಶ್ರೇಣಿಯ ಸೌಲಭ್ಯವನ್ನು ನಿಗದಿಪಡಿಸಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ವಿವರವನ್ನು ತಮ್ಮ ಅವಗಣನೆಗೆ
ನಲ್ಲಿ 29/4/83 ಹಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ಹೊಂದಿ.
That is optional, my lord. They have passed an order independently. It is an optional. They have to seek my opinion. They have not sought any opinion on that.
From 83, what were you doing then?
I have made a request in the year 1983 itself.
ಎಲ್ಲಿದೆ ಅದು?
I have stated in my representation
ಎಲ್ಲಿ?
as per annexure B.
Annexure?
B. B.
ಹಾ. ಓದ್ ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
ಪ್ಯಾರಾ ಸೆಕೆಂಡ್ ಮೇಲ ನನಗೆ ಪ್ಯಾರಾ 1 ನನಗೆ ಹಿರಿಯ ಸಹಾಯಕರ ಪ್ರಮೋಷನ್ ಬಡ್ತಿ ಆದೇಶ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ KEB ಬೆಂಗಳೂರು ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 83ರಲ್ಲಿ ಮತ್ತು 29/4/83ರಲ್ಲಿ ಕೆಲಸಕ್ಕೆ ಹಾಜರಾಗಿರುತ್ತೇನೆ. ಸದರಿ ಅಧೀಕ್ಷಕ ಇಂಜಿನಿಯರ್ ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಮಂಡಳಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 26/2/83ರಲ್ಲಿ ಉನ್ನತ ಶ್ರೇಣಿಯ ಸೌಲಭ್ಯ ಇರುವುದ ಈವರೆಗೆ 10 ವರ್ಷ ಸೇವಾವಧಿ ಮಂಜೂರು ನೀಡಿರುವುದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ಇದಕ್ಕೆ ಲೆಕ್ಕಾಧಿಕಾರಿ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಮಂಡಳಿ ವಿಭಾಗದ ದಿನಾಂಕ 5/4/83ರಲ್ಲಿ ನನ್ನ ಸೇವಾ ಪುಸ್ತಕದಲ್ಲಿ ಸಹಿ ಮಾಡಿ ಆದೇಶವನ್ನು ಕಾರ್ಯರೂಪಕ್ಕೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಇದನ್ನು ಮುಂದುವರಿಸಿ ವೇತನ ನಿಗದಿಪಡಿಸುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅದು ಆದ ಕಾರಣ ನಾನು 10 ವರ್ಷ ಸೇವಾವಧಿ ಬಡ್ತಿ ನನ್ನ ಆಯ್ಕೆ ಮತ್ತು ಒಪ್ಪಿಗೆ ಪತ್ರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಮತ್ತು ಆದೇಶದಲ್ಲಿ ಏಕಪಕ್ಷೀಯವಾಗಿ ದಿನಾಂಕ 5/4/83ರಲ್ಲಿ ಕಾರ್ಯಾದೇಶ ಜಾರಿ ಮಾಡಿರುತ್ತಾರೆ.
83ನೇ ಇಸ್ವಿನಲ್ಲಿ ಕೇಳಿದ್ರಿ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ?
ಅದೇ ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದೆ, ಅದನ್ನು ಕೈ ಬಿಡ.
ಆದ ಕಾರಣ
ಪ್ಲೀಸ್,
ನಾನು 10 ವರ್ಷಗಳ ಸೇವಾ ಅವಧಿಗೆ ಬಡ್ತಿಗೆ
ನನ್ನ ಆಯ್ಕೆ ಮತ್ತು ಒಪ್ಪಿಗೆ ಪತ್ರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಇಟ್ ಇಸ್ ಆಪ್ಷನಲ್.
ಇಟ್ ಇಸ್ ಆಪ್ಷನಲ್.
ಪ್ಲೀಸ್.
ಬಟ್ ನೀವು ರಿಟೈರ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ. ರಿಟೈರ್ ನೀವು ಬಡ್ತಿ ಎಲ್ಲ ತಕೊಂಡು ಎಲ್ಲ ಮಾಡಿ ನನಗೆ NOC ತಕೊಂಡಿಲ್ಲ ನೀವು.
ಅನ್ನೆಕ್ಷರ್ B ಕೆಳಗಡೆ ಹೇಳಿದ್ದೇನೆ ಸ್ವಾಮಿ. ನಾನು ಅದೇ ಇದು 2 ಆದೇಶ ನಂತರ ಕೇವಲ 8 ದಿನಗಳ ಮಾತ್ರದಲ್ಲಿ ನಾನು ಕೇಳಿದ್ದೀನಿ. ಬಟ್ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲೇ ಇಲ್ಲ. ಅದು
ಪ್ಲೀಸ್ ಟೆಲ್ ಅಸ್.
ಪ್ಲೀಸ್.
ನಿಮ್ಗೆ 83ನೇ ಇಸ್ವಿಯಿಂದ ನಿಮಗೆ ಕೊಟ್ಟಿರುವಂತ ಪ್ರಮೋಷನ್ ವಿತೌಟ್ ಯುವರ್ ಎಕ್ಸರ್ಸೈಸಿಂಗ್ ಆಪ್ಷನ್ ಅಂತ ನೀವು ಹೇಳ್ತಿದ್ದೀರಿ.
ಪ್ಲೀಸ್.
ಯಾವಾಗ ರಿಟೈರ್ ಆಗಿದ್ ನೀವು?
97ನಲ್ಲಿ.
97. ನೀವು ಅರ್ಜಿ ಕೊಟ್ಟಿರೋದು ಯಾವಾಗ? 2009 ಅಲ್ಲಿ. 97ನೇ ಇಸ್ವಿಲಿ ರಿಟೈರ್ ಆದ್ರಿ. 2009 ಅಲ್ಲಿ ಅರ್ಜಿ ಕೊಟ್ರಿ. ಏನಂತ? 83ನೇ ಇಸ್ವಿಲಿ ನಾನು ಆಪ್ಷನ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ, ಆದ್ರೂ ನನ್ನನ್ನ ಪ್ರಮೋಟ್ ಮಾಡಿದ್ರಿ.
ಪ್ರಮೋಟ್ ಮಾಡಿ
ನೆಕ್ಸ್ಟ್ ಸ್ಕೇಲ್
ಹೈಯರ್ ಪೇ ಸ್ಕೇಲ್ ಡೇಟ್ ಆಫ್ ಪ್ರಮೋಷನ್
ಹೈಯರ್ ಪೇ ಸ್ಕೇಲ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಿ ಅಂತ ನೀವು 2009ನೇ ಇಸ್ವಿಲಿ ಕೇಳ್ತೀರಾ. 97ರಲ್ಲಿ ರಿಟೈರ್ ಆಗಿ 12 ವರ್ಷದ ನಂತರ ಅಂಡ್ 3 ವರ್ಷದ ನಂತರ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ತೀರ. ಹೌ ಇಸ್ ಇಟ್ ಪಾಸಿಬಲ್? Now, having taken the benefit of a promotion, can you now say that I did not exercise my option then in 83?
I have requested, but consider ಮಾಡಲಿಲ್ಲ.
ಏನಾದ್ರು ನಾವು ಆಪ್ಷನ್ ನಾನು ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡಿಲ್ಲ, ನಾನು ಕೊಡಬೇಡಿ ಅಂತೆಲ್ಲ ಕೊಟ್ಟಿದ್ರ ಅರ್ಜಿ? ಆಪ್ಷನ್ ಕೇಳಲಿಲ್ಲ. ನೀವು ಲೆಟರ್ ಕೊಡ್ಬೇಕಾಗಿದೆ, ಇಲ್ಲಪ್ಪ ನಂಗೆ ಬೇಡ, ಇದು ನಂಗೆ ಸ್ಕೇಲೇ ಕೊಟ್ಕೊಂಡು ಹೋಗಿ, ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಅಂತ ಕೇಳ್ಬೇಕಾಗಿತ್ತು. ನೀವು ಕೊಟ್ಟ ಮೇಲೆ ಸುಮ್ಮನೆ ಇದ್ಬಿಟ್ಟು
ಅಲ್ಲ, ಇವರು ಊರಲ್ಲೇ 1983ನಲ್ಲಿ ಆಫ್ಟರ್ ಗಿವಿಂಗ್ ಪ್ರಮೋಷನ್ ಟು
ಕರೆಕ್ಟ್. ನೀವು ಕೇಕ್ ತಿಂದ್ಮೇಲೆ ನಾನು ಕೇಕ್ ಕೇಳಲೇ ಇಲ್ಲ ಅಂದ್ರೆ, ತಿಂದ್ಬಿಟ್ರಿ ನೀವು, ತಿಂದ್ಬಿಟ್ಟು ಮೇಲೆ ನಾನು ಕೇಕ್ ಕೇಳಲೇ ಇಲ್ಲ ಅಂದ್ರೆ, ಹೌ ಇಸ್ ಇಟ್ ಪಾಸಿಬಲ್? ದಟ್ ಟು ಆಫ್ಟರ್ ಸೋ ಮೆನಿ ಇಯರ್ಸ್. ಬರ್ಕೊಡಿ. ದಿ petitioner has challenged an order dated 30th of October 2009 passed by the respondent number 2, refusing to grant the higher scale of pay for the term for the period 29/4/1983 to 24/4/1997. Next para. Petitioner has also sought for a writ in the nature of mandamus to direct the respondent to consider his representation dated 21/7/2009. Next para. The petitioner contends that he was appointed in as a second division assistant and continued as such till the year 1972. Full stop. He was promoted as a first division clerk on 25/11/1972. Full stop. After he passed the ministerial higher examination, comma, he was granted an increment, granted a promotion, granted an increment and continued as the first division clerk. Full stop. After completing 10 years of service, comma, he was granted a stagnation increment. He was granted the higher pay scale. Full stop. The petitioner contends that the higher scale of pay was given to him without he even opting for it. Full stop. The petitioner was then promoted to the post of senior assistant on 29/4/1983. Full stop. The petitioner purportedly submitted his requisition on 17/5/1983, exercising his option to seek modification of the order dated 26/2/1983. And to extend the benefit of the higher pay scale from the date of his appointment his promotion as a senior assistant, that is from 29/4/1983. The petitioner contends that the respondent number 1 did not consider the request. Full stop. The petitioner retired during the year 1998 and thereafter on 21/7/2009 submitted a request to fix his pay scale in the higher scale of Assistant Accounts Officer for the period 29/4/1983 and 29/4/1997. Full stop. The respondent, however, rejected the request of the petitioner by way of the impugned order. Next para. The learned counsel, being agreed with the said order, the present writ petition is filed. Next para. The petitioner, learned counsel for the petitioner contends that it was incumbent upon the respondents to have obtained the option from the petitioner before granting him the time-bound promotion to the post of into the assistant, senior assistant on 29/4/1983. Full stop. He submits that in the absence of his option, the petitioner was entitled for the higher scale of pay, and therefore the respondents were bound to undo the mistake committed by considering the representation filed by him. Per contra, the learned counsel for the respondents submitted that the petitioner continued as a senior assistant from the date of his promotion but from the date of his promotion, but did not challenge it till he retired in the year 1998. Full stop. He submits that the petitioner thereafter submitted a representation dated 21/7/2009 seeking to correct the anomaly, which was highly belated and no explanation is offered for the delay. Even otherwise, he contends that once a petitioner had served as once a petitioner had availed the benefit of a senior assistant from the year 1983 till he retired, he cannot now turn around and claim that the promotion granted to him was without he opting for it. Full stop. He thus contends that the petitioner cannot blow hot and cold and claim additional benefit on the ground that he did not exercise his option to be promoted. Next, I have considered submissions of the learned counsel for the petitioner as well as the learned counsel for the respondents. Next, it is not in dispute that after the petitioner completed his 10 years of service as FDA, as a first division clerk, he was granted the promotion as well as a higher scale of pay with effect from 29/4/1980. Sorry.
5/4/1980.
5/4 or 26/2 na?
26/2/1983.
Full stop. The petitioner therefore cannot now turn around and claim that he was entitled to a higher scale of pay after being promoted to the post of senior assistant on 29/4/1983. Full stop. The petitioner, having enjoyed the benefit from the year 1983 till he retired, cannot now make a claim that he did not exercise his option for a higher scale of pay in the year 1983. Full stop. Thus, there is no error committed by the respondents in rejecting the request of the petitioner for claiming the benefit of a higher pay scale from the date of he working as the senior assistant, that is from 29/4/1983. Consequently, this petition lacks merit and is dismissed.
See, Mukanappa SB.
SB Mukanappa.
Petition is matter.
In this case.
The respondents may not has filed the
Appear is
statement of
a
objection.
AAG. The appear is a AAG. Once case you have to file the replay. The connected case have ready to be.
Yeah, I for disposal and then
Because since my lord that the matter is covered.
Here,
by
what
the-
is the matter about?
The matter is, my lord, all these petitioners, my lord, the employees of the Karnataka Dairy Development Corporation and my lord, they have continued. Pension what they have claimed. The coordinate bench of this court has allowed the petition, directed the state government, my lord, to consider their case for sanctioning the pension. This is the other second batch of the case, where my lord, other side has, now the objection has been filed, the same stand has been taken by the respondent.
Pension scheme ilva nimmalli?
The pension scheme illa Swami. Because what had happened was because your lordship kindly see the order passed, earlier order passed by this honorable court. Earlier order tavu notice.
Ellide?
Haudu. Matter coordinate bench has already allowed the repetition.
Ellide adu?
Koti repetition ಮಾಡಿ disposal ಅಂತ ಒಂದು ಹಾಕಿದ್ದೇನೆ ಅದ್ರ ಜೊತೆನೆಲ್ಲ ಹಾಕಿದ್ದೇನೆ.
Yes, Mr. If it's considered already, then ಆಗ್ಲೇ ತೀರ್ಮಾನ ಆಗಿದ್ಯಾ?
So we have filed the replay of the state.
Correct, but if it's already covered by a judgment of coordinate bench of this court, then what remains? In the light of the fact that KMF has already provided for sanction of pension to employees who had earlier taken the benefit, PF idiyalla illi. It would be necessary.
That condition, my lord, that
it would be necessary to direct the state government to apply to the same principles to and pay the pension to the petitioners, and after deducting the provident fund and other benefits, as has been done in the case of 7 other employees under the government order dated. ಅಲ್ಲ ಬಟ್ ಏನೋ ಇದು ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಸ್ಕೀಮ್ ಇದೆಯಾ ಪೆನ್ಷನ್ ಫಂಡ್
ಇದೆ ಅದರಲ್ಲೂ ಸಹ ಬೇರೆ ಅರ್ಲಿಯರ್ ಎಲ್ಲ ಅವರೇನ ಸರ್ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ವಾಟ್ ಹ್ಯಾಡ್ ಹ್ಯಾಪನ್ಡ್ ವಾಸ್ that was adjusted. They have calculated it, they have adjusted. If there is any excess payment, they were asked to pay back that amount. We are ready to pay it if there is any excess payment.
No, but
that's what the nursing judge has.
If you subscribe to a pension fund, where's the question of government extending the benefit?
The similar cases also the same thing has been happened. That is the same order has been extracted by the coordinate bench of this court. This is the government order. This has been extracted. Now you will watch me kindly see, the page 30, the government order dated 26/2015, paragraph 16, it clarifies. They have already taken a decision in other cases, how things has to be, this PF has to be, that has to be adjusted and other things. They have not filed any appeal as against this order. And on the other hand, my lord, that I have learned saying that, my lord, this matter is, my lord, this is likely to be implemented. Now the matter is under progress for
I
implementation.
don't know how this pension is applicable to, you're not even a government servant.
My lord, that's how, my lord, how things has been considered, my lord, is that's why am I permitted to read the entire order, my lord. How the nursing judge has
Correct,
considered.
ಅದೊಂದು ಸಿಲ್ಕ್ ಇಂಡಸ್ಟ್ರಿ
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
ಸಿಲ್ಕ್ ಎಂತದು
Yes,
ಸಿಲ್ಕ್ ಬೋರ್ಡ್
Karnataka Silk Industries Corporation. That has been considered even in this division bench judgment also, my lord. The same argument has advanced even earlier also in this case. That has been considered by this court.
ಏನಂತ
ಅದ್ರ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಪ್ಯಾರಾದಲ್ಲಿ ಇಲ್ಲೇ ಹೇಳಿದೆ. Para 13. Para 13 of this, the learned additional advocate general sought to place reliance on the judgment rendered by the division bench in WP number so and so, so and so, disposed of on 22/2, contended that the claim of the petitioner would be untenable. It has to be stated that that in WP number 8906 of 2021, connected with WP number 8030 of 20, the division bench was considered the situation where the petitioner therein had been appointed by the Karnataka Silk Industries Corporation, had opted to be governed by the Karnataka Silk Industries Corporation rules, and has chosen not to govern by the rules applicable to the government center. However, in this case, as noticed above, in respect of the employees of the Karnataka Dairy, all the rules applicable to the government centers were expressly made applicable by way of a circular, and therefore the reliance placed on the decision rendered above would be of no effect.
Please taken a view that once you are subscribed to a provident fund, madak barodilla anta
The
ಮಾಡಿ.
1960 Supreme Court judgment is also there, but even but that will never disentitle the employee if they are entitled to claim the pension. Like, why should you want me to argue, my lord? I will place all those judgments. My only submission is this, my lord.
You have to convince me
This
that I am wrong.
similar stand, my lord, they cannot take a different stand. The same stand been taken even in this.
No, I have taken a stand that once you subscribe to a PF fund or a pension fund, then you cannot go back and say that we will refund that money that we have contributed in the government.
The government has already taken a decision in other cases, my lord, where, my lord, that the Bangalore Dairy employees are concerned, my lord. The similar situation. Where, my lord, earlier batch, when they have also approached the Karnataka State Administrative Tribunal. Matter also, my lord, came up before this honorable matter went to Supreme Court also in other cases. Where, my lord, thereafter, when they was directed to pay the pension, then, my lord, the state government, my lord, formulated the scheme ultimately, my lord, in the order. How this has to be adjusted, my lord, that has been done. That same thing. In 2015 al matter adene son.
ಯಾವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಇಲ್ಲ ಇದನ್ನೇನೋ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಸಂಗಿದ್ರೆ ಮಾಡಿಸಿ.
ಅಲ್ಲ ಅವರು
they were appointed 1975 before appointed the government if it is eligible for the pension. After that have to the board is appointment of the
ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು?
Class 36 of the memorandum of association.
ಯಾವತ್ತು ಮಾಡ್ತೀರಿ ಹೇಳ್ರಿ?
next week.
They learned AJ 6 time. List on date put.
ಅಲ್ಲ
ಯಾವತ್ತು ಬೇಕು?
next week ಅಲ್ಲಿ ಯಾವತ್ತಾದ್ರೂ ಮಾಡಕ್ ready.
Yes.
Rashman, give me a date, we'll argue the matter.
Serial number 70.
Srinivas, IA one of disposal. ಏನಿದು IA one of disposal ಅಂತ ಹಾಕಿದ್ರು?
Name is not found in the eligibility list.
ಅಲ್ಲ IA disposal is covered by judgment ಏನಿದು?
Judge similar this honorable court in similar case has passed an order thereby directing the corporation to consider the case. I will pass on the judgment.
Yes, why don't you serve a copy to him? ಅವ್ರು ಯಾವಾಗ ನೋಡೋದು ಯಾವಾಗ?
ಅಲ್ಲ, they have appeared in the other case. In that case also they have appeared before the Sambu court and the matter
There's
is
some settlement that has happened.
settlement was entered into between union and the management.
Prayer, my lord, it is for mandamus. And moreover, my lord, the petitioner, my lord, is appointed in 2001.
So what is the relief sought for? What is the relief sought?
Relief is sought for mandamus, my lord, to consider the representation. Kindly see at page, sorry, my lord, para 20. There for,
But this issue is covered along. Probationary Mazdoor ಎಲ್ಲ cover ಆಗಿದೆಯಲ್ಲ?
Yes, my lord, but here, my lord, what has happened, my lord, is he is appointed in 2001. And moreover, my lord, kindly see annexure A at page 3, my lord, the terms of settlement. He had to complete 6 years of service.
That is all, my lord, decided by the Sambu court. There are several employees who have, my lord, observed, my lord, who have rendered less than 6 years of service and have produced the list before the Sambu court at annexure L, which indicates, my lord, even the employees who have worked for 4 years, my lord, they have observed into the permanent cadre. The petitioner has also rendered 5 years of service from 2001 to 2005. Lord, his name is forthcoming in the very list prepared by the respondent.
Still employed?
No, he is removed from service, my lord, in 2005.
And you filed the writ petition 2021.
What has happened, my lord? In 2016, board has decided, my lord, kindly see annexure D.
2005 will remove 2021.
True, my lord. What has happened? Board, my lord, has reinstated all the terminated employees in 2016.
So all those employees who were terminated.
Terminated have been
2005
reinstated.
ಅಲ್ರಿ ಕೇಳ್ರಿ ಸ್ವಲ್ಪ ನಾನು ಹೇಳದೆ.
Yes.
2005 ಅಲ್ಲಿ ಟರ್ಮಿನೇಟ್ ಆಗಿರೋರ್ನ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿದಾರಾ?
ಹೌದು.
ಎಲ್ಲಿದೆ?
Kindly see, my lord, annexure, the board resolution, my lord, annexure D, page number 25. The board has, my lord, resolved to absorb all the terminated employees.
ಎಲ್ಲಿ ಓದ್
26/2020, my lord, 9/2016, my lord, is the annexure D, page 25. I have produced, my lord, the typed copy at page 30.
ಓದ್.
Yes. My lord, kindly, my lord, come to page 34, my lord, in page number 34. Is the decision taken by the, my lord, in the next page, my lord, sorry, page number 35, resolved that for the reasons explained, approval B and E is hereby accorded for conversion of 350 numbers of bill delivery boys as probationary modules who were originally engaged for the duties of gangmen and subsequently deployed for all the bill delivery works and who were left out till date for the benefit of conversion. The approval is subject to fulfilling the following conditions. The reinstatement of probationary modules shall be without any back wages and benefit of continuity of service from 2006, where they were disengaged. My lord, the 315 the temporary employees were disengaged, my lord, in 2005 and 6. Decision was taken by the respondent board in 2016.
The list of 315 workmen with names shall be authenticated by the law officer.
Yes, my lord. I produced the list, my lord, at annexure L, my lord.
Annexure?
Annexure L, page number 47.
ಅದ್ರಲ್ಲಿ ನೀವು ಇದ್ದೀರಾ?
My lord, in that, my lord, my name has been left out. In the provisional list, my lord, prepared by the respondents, which I have placed it along with the, my lord, interim IA, my lord, annexure M. The lordship may kindly see, my
But now,
lord.
my lord, this judgment, my lord, what my learned senior.
But then you find out whether this man.
I will
was-
find out, my lord, if this man is entitled for this, my lord, because
How
there is
is
no
it?
endorsement next week, my lord.
Learned counsel for the respondent seeks time to secure instructions. The learned counsel for the petitioner submits that this issue is no longer res integra in view of the order passed by a learned court, by a coordinate bench of this court in WP number 10863 of 2020. Full stop. This list on.
First August.
Okay, watch out.
Number 18, Shivraju MK.
Shivraju MK.
Board in a bench passed an order, my lord.
Huh?
Board bench in on passed an order in same similar matter, my lord. As a guest petitioner, as a guest teacher is to appoint a relief.
Yeah, other side.
That side ಅವ್ರು ನಾಗಯ್ಯ ಅಂತ. Actually, in
ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕಲ್ಲ.
coordinate bench ಅಲ್ಲಿ ಅವರು ಇದ್ದಾರೆ. ಈ ಆರ್ಡರ್ ಇದೆ.
ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕಲ್ರಿ ಅವ್ರನ್ನ ಏನೋ ಮಾಡಿ ಏನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಕರ್ಕೊಂಡ್ಬಂದಿ.
ಅಲ್ಲ same similar matter, they are also appear.
I will not dispose it off unless he comes and says. 2022 matter. Mr. Nagaya.
ಅವ್ರು Wednesday ಹಾಕೊಂಡು ಅಂದ್ರೆ Tuesday
ಇಲ್ಲಿ ನಾಗಯ್ಯ ವಕಾಲತ್ ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
R2.
Is also similar matter he has appeared.
ಇದು BR Ambedkar ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸ್ಕೂಲ್ ಬೇರೆ ಇದು. ಆ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸ್ಕೂಲ್ಗೂ ಅವರೇ ಅಪಿಯರ್ ಆಗ್ತಾರಾ?
ಗೊತ್ತಿಲ್ಲ ಅವ್ರು ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಅವರು ಓನ್ಲಿ ಇದಕ್ಕೆ ಕ್ರೈಸ್ಟ್ ಮಾತ್ರ ಅಪಿಯರ್
ಇಲ್ಲ ಕ್ರೈಸ್ ಅಂದ್ರೆ BR ಅಂಬೇಡ್ಕರ್ಗೂ ಬರ್ತಾರಲ್ಲ ಅವರು.
ಅವ್ರು ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ.
What is relief short for?
To writ of mandamus to represent a consider request of the applicant petitioner and to regularize our service.
Password no. Andre password.
Number 19.
And Tuesday, otherwise Tuesday.
Password ಅಂತೀನಿ Tuesday ಅಂತೀರಾ ಏನ್? Password.
ಅವರು ಬರ್ಬೇಕಲ್ಲ. In this I appear for petition, but I have filed this application for direction.
ಏನ್ ಡೈರೆಕ್ಷನ್?
The petitioner was appointed as an Anganwadi handicapped person, lady, was appointed as an Anganwadi worker, which was challenged, my lord, by the respondent number 5, which was set aside by the Honorable Court to reconsider the matter afresh, your lordship. May kindly see the order, page 58, your lordship.
Page
58. Page 50, before that page. Page 58, para 6, your lordship. It is also made clear that since the respondent number 5 is working as Anganwadi worker in Kurubara Alli Anganwadi Center, the service of the respondent 5 shall not be disturbed before taking any decision in the matter. Now they have taken, she was not disturbed. She continued to work, my lord, pursuant to the order of this honorable court, my lord.
Yes.
Then, my lord, the decision was taken by now, my lord, by recording a wrong finding that I did not produce the document.
ಏನ್ document?
That's what they say. Lordship may kindly see the observation made by the Honorable High Court itself, my lord, this Honorable Court. Para 5 of the order, which I have extracted in the grounds, your lordship. Page 7, my lord, page 7, para 7, my lord, page 8.
Where's the impugned order?
Impugned order, my lord, is page 53, 57 only, your lordship. It is made clear, it is para 5, your lordship, which I have extracted in the ground, your lordship.
Page 57.
Yes, sir.
Adalla sir, which
Yes.
is the impugned order which is.
Impugned order at annexure H and H1, your lordship. H and H1. Kindly see H, my lord, page 59. ಪ್ರಸ್ತಾವನೆ ಕೆಆರ್ಪೇಟೆ ತಾಲೂಕು ಶಿಶು ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ವ್ಯಾಪ್ತಿಯ ಕುರುಬರಹಳ್ಳಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಲ್ಲಿ ಹಾಲಿ ಇದ್ದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಯ ನೇಮಕಾತಿಗಾಗಿ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಲಾಗಿತ್ತು. ಈ ಪ್ರಕಟಣೆ ಮೇರೆಗೆ ಕುಮಾರಿ ತೇಜಾವತಿ KS ಬಿನ್ ಸಣ್ಣ ಸೋಮಾಚಾರಿ ಸೋನ್ಸೋ ಆಯ್ಕೆ ಮಾಡಲಾಗಿದ್ದು. ದಟ್ ಈಸ್ ದಿ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಸದರಿಯವರು 23/7/21 ಆದೇಶದಂತೆ ಕುರುಬರಹಳ್ಳಿ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. ಇವರ ಆಯ್ಕೆಯನ್ನು ಪ್ರಶ್ನಿಸಿ ಬಿ ರಮ್ಯಾ ಹಾಗೂ ಯೋಗೇಶ್ ಸೋನ್ಸೋ ರವರು ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿದ್ದು. ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಕುಮಾರಿ ತೇಜಾವತಿ KS ಸಣ್ಣ ಸೋಮಾಚಾರಿ ಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮ ಇವರ ಆಯ್ಕೆ ಕುರಿತು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸುವಂತೆ ಆದೇಶಿಸಿರುತ್ತದೆ. ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಮೇರೆಗೆ ಸದರಿಯವರು ನೇಮಕಾತಿ ಪ್ರಕಟಣೆ ಸಂದರ್ಭದಲ್ಲಿ ಸಲ್ಲಿಸಿದ್ದ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳ ಮೂಲ ಪ್ರತಿಗಳನ್ನು ಪರಿಶೀಲಿಸುವಂತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 16/7/23 ನಡೆದ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಕುಮಾರಿ ತೇಜಾವತಿ KS ಇವರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಅಗತ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲನೆಗೆ ಒದಗಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. There is no direction issued by this honorable court to produce the document, your lordship. Therefore, my lord may kindly see para 5 now. That is a wrong finding which has been recorded. It is made clear that the respondent number 2 and 3 are directed not to consider any documents uploaded or produced by the candidate subsequent to the last date for receipt of applications, that is 31st December 2018, in view of the law declared by the Honorable Affairs Court in the case of so and so. When this is this direction issued by this Honorable Court, the question of issuing notice to me, question of I producing any document, my lord, does not arise.
But if the
Now, my lord,
respondents are of the opinion that you did not produce the necessary document.
that's why, my lord, I need not produce any document. All documents are already there as per the direction of this honorable court. It is to be reconsidered. That's all, my lord. They are wrong finding. This honorable court granted an interim order to not to give effect to these 2 orders. In spite of it, I was not given a service, your lordship.
Right.
Interim order is there, your lordship, that I have, therefore I have filed application seeking directions, my lord.
Yes.
Kindly come to my lord, my statement of objection, annexure R4, my lord. Well, adikene. Kindly come to my lord, annexure R4, page number 14, my statement of objection. Typed copy next page ಅಲ್ಲಿ ಇದೆ. ತೇಜಾವತಿ ಪಿಟಿಷನರ್ ಹಿಯರಿನ್ ಬಿನ್ ಸಣ್ಣ ಸಮಾಚಾರಿ ಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮ ಬೂಕನಕೆರೆ ಹೋಬಳಿ ಇವರಿಗೆ ಅಂಗವಿಕಲ ವೇತನವನ್ನು R4 ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 15 ಟೈಪ್ಡ್ ಕಾಪಿ ದಿನಾಂಕ 27/7/2001 ಅಂಗವಿಕಲ ವೇತನ ಮಂಜೂರು ಮಾಡಲಾಗಿದ್ದು ಈಗ ಪಿಂಚಣಿ ಅಂಗವಿಕಲತೆ ಶೇಕಡ 75ಕ್ಕೆ ಹೆಚ್ಚಾಗಿರುವುದರಿಂದ ಅಂಗವಿಕಲತೆಯು they have got my lord 75% disability. My lord, there is a condition in my lord while uploading application. They have to say, my lord, within 60% idire matra they are eligible anta.
75 ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
25%.
ಎಲ್ಲಿದೆ?
Who has given the certificate?
15, page number 15. Ada page number 14, my lord, of my statement of annexure R4.
ಇದನ್ನು ಕೊಡಿ.
ನಂದ್ರಲ್ಲಿ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್.
ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡ್ತೀರಾ? ಅನ್ನೆಕ್ಷರ್ R3 ನೋ R4? R4 is
page number 14 ಮೇಲೆ
26/10/2023 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳದ.
ಹೌದು, ಅಲ್ಲ ಅನ್ನೆಕ್ಷರ್
ಅಂಗವಿಕಲರ ಘೋಷಣಾ ಭತ್ಯೆ ಪರಿಷ್ಕೃತ ಆದೇಶ ಅನ್ನೋದು
15/4/2015.
15/4/2015. Who can ತಹಸೀಲ್ದಾರ್ ಸರ್ಟಿಫೈ ದಿ
ಅದಲ್ಲ ಹೇಳ್ತೀನಿ, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೇ ಬರ್ತಿದ್ದಾರೆ, ಅವ್ರ ಪಿಟಿಷನ್ ಅಲ್ಲೇ
that is wrong ಅಂತ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ಕೊಡಿ ಇದನ್ನು. Mentioning of a percentage in the application which is contrary to the original record will not take away
ಹೇಳ್ತೀನಿ why it has happened ಅಂತ.
ಏನೋ ಒಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದು.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅನ್ನೆಕ್ಷರ್ R4 ಮೇಲೆ
annexure R4
ಓದಿ.
annexure R4 ಮೇಡ ಟೈಪ್ ಕಾಪೀಸ್ ಪೇಜ್ ತೇಜಾವತಿ ಬಿನ್ ಸಣ್ಣ ಸಾಮಚರಿ ಕುರುಬ್ರಳ್ಳಿ ಗ್ರಾಮ ಬುಕ್ಕಿನಕೆರೆ ಹೋಬಳಿರವರಿಗೆ ಅಂಗವಿಕಲತೆ ವೇತನವನ್ನು 2ರಂತೆ ದಿನಾಂಕ 27/7/2002 ಅಂಗವಿಕಲ ಮಂಜೂರು ಮಾಡಲಾಗಿತ್ತು. ಈಗ ಪಿಂಚಣಿದಾರರಿಗೆ ಅಂಗವಿಕಲತೆ ಶೇಕಡ 75ಕ್ಕೆ ಹಂಚಿಕೆ ಆಗಿರುವುದರಿಂದ ಈ ಆದೇಶದ ದಿನಾಂಕದಿಂದ ಪ್ರತಿ ತಿಂಗಳು 2,100 ಮಾತ್ರ ಅಂಗವಿಕಲತೆ ನೀಡಲಾಗಿದೆ ಎಂದು ಮಂಜೂರಾತಿ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. Milord, she has got Milord more than 75% of disability, Milord. This is the certificate issued by the Tahsildar while Milord granting Milord pension to the petitioner, Milord. And then next come to Milord annexure R5. ಎಲ್ಲಾವುದು ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡ್ತಾರೆ. R5 ಅಲ್ಲಿ ಎಲ್ಲ ಇಡೀ ಕ್ಯಾರ್ಪೇಟೆ ತಾಲೂಕು ಒಟ್ಟಿಗೆ ಕರೀತಾರೆ. ಕರೆದು ಇದನ್ನ ಮಾತ್ರ ಬಿಟ್ಬಿಟ್ಟು ಕುರುಬ್ರಳ್ಳಿ ಮಾತ್ರ ಬಿಟ್ಟು ಎಲ್ಲಾವುದನ್ನು ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಏನಕ್ಕೆ ಅಂತ ಇರೋದು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕಾದ್ರು 75% ಅಂತಾನೆ ಹಾಕಿದ್ದಾರೆ. ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲೂ 75% ಅಂತಿದೆ. ಈಗ ಹೇಳ್ತಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ವಿಸಿಬಲ್ ಇಲ್ಲ, ಇವ್ರು ಅಪ್ಲೋಡ್ ಮಾಡಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ಫೋರ್ my lord, at first instance I approached this honorable court but annexure R8 page number 24 ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂತ. ಈ ಕೋರ್ಟ್ 4 weeks ಒಳಗಡೆ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತು. 2 years ಆದ್ರೂ ಮಾಡ್ಲಿಲ್ಲ. 2 years ಆದ್ಮೇಲೆ ಇವ್ರನ್ನ ಸೆಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಂತ ತೋರಿಸ್ತಾರೆ. ಅದರಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ, ಇವ್ರು ಅಪ್ಲೋಡ್ ಮಾಡಿರೋದು ಡಾಕ್ಯುಮೆಂಟ್ ಸರಿಯಾಗಿ ಕಾಣಿಸ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡು ಮಾಡ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ಫೋರ್ my lord, annexure R10 my lord, kindly come to page number 31. Para 3 ಇಂದ ಓದ್ತೀನಿ. Page number 33 ಇಂದ. I may be permitted to read my lord, from page number 33. Having heard the learned counsel appearing for the parties, it is not dispute that the petitioner as well as the respondent number 5 herein have made application for the appointment of Anganwadi worker of Kurubralli village, Karpete Taluk, Mandya district. It is the grievance of the petitioner that the respondent number 5 herein has been appointed to the said post despite the fact that respondent number 5 is having disability beyond 60%, and therefore it is contended that the appointment of the respondent 5 is contrary to law. As per notification dated 5 December 2018, annexure A, applicant are required to upload the documents through online. In view of the matter, taking into consideration the
government say, government or you have filed the statement. What do you say in the statement?
ಇದರಲ್ಲಿ
ಇನ್ನೊಂದು ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ I have produced, your lordship may kindly see my lord.
ಅವ್ರು ಮುಗಿಸ್ಲಿ
ಅಲ್ಲ, ಇನ್ನೊಂದು R12 ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ಅದೊಂದು ಓದ್ಬಿಡ್ತೇನೆ.
ಓದ್
ಅನ್ನಕ್ಷರ R12 my lord. ಪೇಜ್ ನಂಬರ್ ರಿಲೆವೆಂಟ್ is para.
ಡಿಸ್ಪೋಸಲ್ ಬೇಕು ಅಂದ್ರೆ within 5 minutes you should conclude your argument. ಇಲ್ಲ ಅಂದ್ರೆ we'll hear it at leisure. ಅಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಬೇಕು ಅಂದ್ರೆ
ಆಯ್ತು, ಅವ್ರು ಹೇಳಿ ಸ್ವಾಮಿ, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ.
On the basis of the documents, my lord, which was produced by the selection committee, which is produced in along with the statement of objection, my lord. Annexure R4 of my statement of objection, 16.
No, what was the document which was uploaded by her?
He had not produced uploaded the original.
Then how was she allowed for an interview?
That's my.
Then application must have been rejected. Like handicapped certificate produce ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ she is not eligible. How did you allow her to participate in the recruitment?
ಅದಕ್ಕೆ ಪೇಜ್ ನಂಬರ್ 42 ಬಂದ್ರೆ ಅವರು ಸುಳ್ಳು ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ 42 ನಲ್ಲಿ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ 42 ಬಂದ್ರೆ ಅವ್ರು ಬೇಕು ಅಂತ ಅವ್ರು ಫೇವರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡಿರ್ತಿದೆಲ್ಲ. 42 ನಲ್ಲಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಇದೆ ಅವ್ರದ್ದು ರೆಸೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಅಂತಿದೆಯಲ್ಲ, ಅಲ್ಲಿಂದ ಓದ್ತೀನಿ. ಕುರುಬ್ರಳ್ಳಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಆನ್ಲೈನ್ ಒಟ್ಟು 19 ಅರ್ಜಿಗಳನ್ನು ಸ್ವೀಕೃತಗೊಂಡಿದ್ದು, ಸ್ಥಳೀಯ 7 ಅರ್ಜಿಗಳಲ್ಲಿ ಅಂಗವಿಕಲತೆ ಅಭ್ಯರ್ಥಿಯಾದ ತೇಜಸ್ವಿನಿ ಎನ್ಕೆಆರ್ ಇವರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಇವರು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದ ಗುರುತಿನ ಚೀಟಿಯಲ್ಲಿ ಅಂಗವಿಕಲತೆ ಪ್ರಮಾಣ ಅಸ್ಪಷ್ಟವಾಗಿದ್ದ ಕಾರಣ ಅಭ್ಯರ್ಥಿ ಅಂಗವಿಕಲತೆ ಬಗ್ಗೆ ಪುನರ್ ಪರಿಶೀಲಿಸಿದ ದಿನಾಂಕ ಆಯ್ಕೆ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನ ಸೂಚಿಸಿದ ಮೇರೆಗೆ ಪರಿಶೀಲನೆಯಾಗಿ 50% ಅಂಗವಿಕಲತೆ ಅಂತ ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಕೊಟ್ಟಾಗ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಮೇಲೆ ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ, ಇದರಲ್ಲಿ 60% ಅಂತ ಕೊಡ್ತಾರೆ. ಇವರು ಯಾವಾಗ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗಂತ ಡಾಕ್ಯುಮೆಂಟ್ಗಳನ್ನ ಅವಾಗ ಕೊಡ್ತಾರೆ. ಅನ್ನಕ್ಷರ R2 ಬನ್ನಿ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 11.
ಇವಾಗ ಎಲ್ಲಿ ಅಸೆಸ್ಮೆಂಟ್ ಮಾಡ್ಸೇ ಬಿಡೋಣ.
As on the date of application, my lord, they have to upload December report at earlier point of time.
ವಿಕಲತೆ ಅದೇನ್ ಜಾಸ್ತಿ ಇಂಪ್ರೂವ್ ಏನ್ ಆಗಲ್ವಲ್ಲ.
ಇಂಪ್ರೂವ್ ಆಗೋದು ಬೈ
ಆಲ್ರೆಡಿ ಅವರು ಪೆನ್ಷನ್ ತಗೋತಾ ಇದ್ದಾರೆ, 75% ಆಗಿದೆ ಅಂತ
ಕೊಡಿ ಸರ್ಟಿಫಿಕೇಟ್.
Want you will get it verified again.
ಅದು ಕೊಡಿ ಸರ್.
ಯಾಕಂದ್ರೆ 75% ಅಲ್ಲಿ ಅವ್ರು ಆಲ್ರೆಡಿ ತಗೋತಿದ್ದಾರೆ. ಕೆಲಸಕ್ಕೋಸ್ಕರ
ಕರೆಕ್ಟ್.
ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ತಪ್ಪಾಗಿರ್ಬೇಕು.
ಓನ್ಲಿ ಮಿಸ್ಟೇಕ್ ಕಮಿಟೆಡ್ ಬೈ ದಿಸ್ ಲೇಡಿ my lord, that while furnishing the, while mentioning in the application
ಅಲ್ಲ,
form, 75% ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Government ಗೆ ಅವ್ರು
Record
ಹಾಕಿರೋ-
by birth, it is shows that 50%. Mere non-mentioning in the application regarding the percentage of disability excess than the notified condition.
upload ಆಗಿರೋ
will not take
document
away my
ಪ್ರತಿಯೊಂದು
right.
ಆಗೋಗುತ್ತೆ.
50% by birth ಇಂದ ಇರೋದು. Left leg complete foot ಪೂರ್ತಿ ಬೆಂಡ್ ಆಗಿರೋದು. ಬೈ ಬರ್ತ್ ಅದ್ರಲ್ಲಿ ಇಂಪ್ರೂವ್ ಆಗೋ ಪ್ರಶ್ನೆನೂ ಇಲ್ಲ, ಡಿಕ್ರೀಸ್ ಆಗೋ ಪ್ರಶ್ನೆನೂ ಬರುದಿಲ್ಲ ಅದರಲ್ಲಿ.
50% ಅಂತ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲಿದೆ ಅಲ್ಲಿ. ಅದನ್ನ ಇವರು ಬರೆಯುವಾಗ 75% ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಬೈ ಮಿಸ್ಟೇಕ್ ಅಪ್ಲಿಕೇಶನ್ ಅಪ್ಲೋಡ್ ಮಾಡುವಾಗ. ದಟ್ ಇಸ್ ಆಲ್ ದಿ ಮಿಸ್ಟೇಕ್. ಇಟ್ ಈಸ್ ರೆಕಾರ್ಡ್ ಸೇಸ್
50% ಅಂತ ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ರು. ಆಮೇಲೆ ಅವರೇನೆ ತಹಸೀಲ್ದಾರ್ಗೆ ಅರ್ಜಿ ಕೊಟ್ಟು ಬರೋ ಕಾಂಪನ್ಸೇಷನ್ ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಕಾಲು ಇದೆ ಕಣ್ರಿ, 2 ಕಾಲಿದೆ, ಒಂದು ಸೊಟ್ಟಗಾಗಿದೆ ಅಷ್ಟೇ.
ಒಂದ್ ಕಾಲು ಈ ತರ ಇದೆ,
ಗೊತ್ತಾಯ್ತು.
ಬೆಂಡಿದೆ ಫುಲ್.
75% ಡಿಸಬಿಲಿಟಿ ಅಂದ್ರೆ ಏನಾಗಿರ್ಬೇಕು? ಕೈಯ ಕಾಲ ಇರಬಾರ್ದು.
ಅಲ್ಲಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್. ನಾನು ಹೇಳ್ತಾರೆ ಅನಕ್ಷರ R4 ಅವ್ರದೇನೆ, ನಂದಲ್ಲ ಅದು ಡಾಕ್ಯುಮೆಂಟ್.
ಇಟ್ ಕುಡ್ ಬಿ ದ ಪರ್ಪಸ್ ಈಸ್ ಅಂಗನವಾಡಿನಲ್ಲಿ 75% ಡಿಸಬಿಲಿಟಿ ಇದ್ರೆ ಕೆಲಸ ಮಾಡಕ್ಕಾಗಲ್ಲ,
ಆಗಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ ಇರೋದು. ವಾಟ್ ಇಸ್ ದ ಫ್ಯಾಕ್ಟ್?
ಅಲ್ಲ ಬೇಕಾದ್ರೆ ಅಸೆಸ್ ಮಾಡಿದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಇದಕ್ಕೆ ರೆಫರ್ ಮಾಡಿ.
ಆಯ್ತು, ಎಲ್ಲಿ ಕಳಿಸ್ಬೇಕು ಹೇಳಿ? ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ಟ್ ಎಲ್ಲಿ ಕಳಿಸ್ಬೇಕು?
ಮೆಡಿಕಲ್ ಬೋರ್ಡ್. ಮೆಡಿಕಲ್ ಬೋರ್ಡ್
ಎಲ್ಲಿ?
ಮೆಡಿಕಲ್ ಬೋರ್ಡ್
ಎಲ್ಲಿ? ಮೈಸೂರ, ಮಂಡ್ಯನ, ಬೆಂಗಳೂರ?
ಮೈಸೂರು
ಕಳಿಸು.
ಮಂಡ್ಯ ಅಂತಿದೆ ಇದು.
ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಇದು.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ.
ಇಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟಿಲ್ ದೆನ್ ಐ ಮೇ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ಕಂಟಿನ್ಯೂ.
in this petition relates to
ಆಲ್ರೆಡಿ ಬೇರೆಯವರು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ
the question whether the petitioner is suffering from any physical disability which disentitles her to hold the post of Anganwadi worker. Full stop. While the petitioner claims that the petitioner suffers from disability of 50%, the respondent number 5 contends that the petitioner has claimed
75%. 75% ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದೀನಿ, ಅದಕ್ಕೆ ನಾನು
75% for the purpose of claiming disability pension. Full stop. Since the question relates to appointment to the post of Anganwadi worker.
Honorary worker.
Honorary ಏನು ಬಂತು?
ಆನರರಿ ಗೌರವ
ಸಂಬಳ ಕೊಡಲ್ವ? 6,000 7,000 ಕೊಡ್ತಾರಲ್ಲ
ಅಷ್ಟೇ. ಅದನ್ನೇ ಆನರರಿ ಅಂತ ಅಷ್ಟೇ.
Anganwadi worker, the disability suffered by the petitioner deserves to be assessed properly. Consequently, the petitioner is full stop. The learned counsel for the petitioner submits that the petitioner had suffered disability of 50%, but by mistake, she had mentioned that as 75% while filing the application. Therefore, in order to assess the disability suffered by the petitioner, it is appropriate to refer the petitioner to appear before the medical board for assessment of her disability. Full stop. In that way of the matter, petitioner is directed to appear before the medical board.
ಮಂಡ್ಯ ಆದ್ರೆ ಸರಿ, ಮೈಸೂರು ಆದ್ರೆ ಎರಡು ಹತ್ರ ಇದೆ.
ಎಲ್ಲಿ ಹೇಳಿ ನಿಮ್ಗೆ ಎಲ್ಲಿ ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲಿ ಕಳಿಸ್ತೀವಿ.
ಮೈಸೂರು ಮಾಡಿ,
ಅವ್ರು ಹೇಳಿದ ಕಡೆನೆ ಕಳಿಸ್ಕೊಡಿ.
ಮೈಸೂರು ಮೆಡಿಕಲ್
ಹತ್ರ ಇದೆ.
ಮೈಸೂರು ಜನರಲ್ ಹಾಸ್ಪಿಟಲ್.
ಮೈಸೂರು
ಜನರಲ್ ಹಾಸ್ಪಿಟಲ್ which
KR ಹಾಸ್ಪಿಟಲ್.
Medical board of the Mysore General Hospital. ಅದೇನು ಹಾಸ್ಪಿಟಲ್ ಹೆಸರು ಏನೋ ಇದೆಯಾ?
KR ಹಾಸ್ಪಿಟಲ್ ಅಂತ. ಕೃಷ್ಣರಾಜೇಂದ್ರ ಮೆಡಿಕಲ್.
Before the medical board, Krishnarajendra Hospital, Mysore, which shall assess the disability suffered by the petitioner and submit a report to this court here before 23rd September 2024. The petitioner shall appear before the medical board along with a copy of this order on 10th September 2024.
This copy may be forwarded to them.
Office is directed to issue appropriate communication to the medical board, Krishnarajendra Hospital, Mysore.
In the meantime, Lord, the interim order has been
a copy of this order.
Interim order has been granted by this honorable court, your lordship, not to give effect to these two orders.
Already
I should continue in the service.
Incharge ಇದಾರಲ್ಲ,
ಇನ್ಚಾರ್ಜ್ ಇದಾರೆ.
Incharge ಯಾರು ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು.
ಹೇಳಿದ್ದಾರೆ. Yes, next.
ಅಲ್ಲ, ಇನ್ಚಾರ್ಜ್ ಇದಾರೆ, ಅವ್ರು ಬೇರೆ ಊರಿಂದ ಬರ್ಬೇಕು ಅವರು.
ಅಲ್ಲ ಅವ್ರು
ಯಾಕೆ ಮೇಡಮ್ ಬರೋದಿಲ್ಲ? ಮೆಮೊ ಮೂವ್ ಮಾಡಿದೆ. ಅಲ್ಲ, ಇಟ್ಟು ಮೆಮೊ ಬಂದಾಗ don't take it casually. Court ಇಂದ ಬಂದಾಗ don't take it casually, please. Yes.
Serial number 20, Ashwini Kumar S.
I appear for. Last time your lordship directed the government advocate. Whether the respondent, private respondent. Or can be accommodated in another college.
My lord, we have initiated a search in this matter, my lord, 3 days time. Kindly have it.
Any post of lecturers vacant in any of the aided institutions where the respondent number 4 can be accommodated.
Can you kindly have it on 29th, my lord?
And AG again seeks time to comply the order dated 7/8/2024. List on
29.
yes, 29.
21, Janardhan G.
The G Janardhan. The G Janardhan. AG.
The reason is that the petitioners are all retired from service. Madam. They are all working as a lecturers in aided college. And after their retirement, Madam, pending this honorable court Madam, has earlier Madam, has allowed the writ petitions of the aided lecturers to take into consideration of non-grant period also. Madam. Then this court, the act has been brought in Madam, 2014 with effect and retrospective from 96. Now exclude the non-grant period. But that has been quashed by this court. Madam, annexure. That order is produced, annexure D, Madam, page 41. Constitutional validity, not against which they prefer an appeal and appeal in the appeal, the interim order has been passed, not page 162. Lordship get the interim order passed in the writ appeal. Now, since we are retired from service, the 164 page, that portion of the order would apply to us.
No, but then the.
Then what happened is we filed a contempt petition for not complying with this order. Now they undertaken to settle it. Kindly see Madam, annexure J, P, sorry, Madam, annexure and my IA. Right. Request order to kindly come to
174.
annexure J, Madam. Annexure J, that they have said that they are ready to do it. But if the proposal is given and similarly in contempt petition, Madam, the detailed order passed in contempt one, similar order has been passed. That also I have placed before this court, Madam, kindly see. Page 174. Kindly similar. Mahendra so and so government for state submit that with regard to proposal sent by the institution for the aided and unaided service period, the government is prepared to pay terminal benefits over the aided service concern. But now they are not doing that. I am afraid of it.
My lord, I take instructions. I am having a misplacement.
But they have retired and suffering from any.
Next week.
The Lord AG seeks time to file statement.
Statement.
List on date. September end.
This may request one. Because this is, but as per the, at least for
2024.
ಗೊತ್ತಾಯ್ತು ಅಲ್ಲ pensionary benefits ಅವ್ರು settle ಆಗಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ. That is the reason.
You are asking for pension benefits of the past previous period.
ಅಲ್ಲ,
You are
from the
getting
rate of
pension.
retirement.
You are not
ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವ್ರಿಗೆ ಏನು. ಅದು they are suffering, that is.
some money is paid to you.
No, my lord. That is the reason, because.
September kudi.
ಅಲ್ಲ, September, lordship may little early. Because, problem is, some benefit, my lord, if they are given, they could have, there are survival question. That is the reason.
2 weeks on date put it up. Yes, Mr. Manjana. Manjana Girija Patil.
Number 22, Manjana MS.
Petitioner, let's.
Girija Patil.
Time may be granted, I will file objection.
Objection ಇದೆಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಹಂಗೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆದಂಗಿಲ್ಲ. ಕೇಳಿ ಏನು ಏನು where did you
I
go,
will
where
get the
did you come?
information, I will get the information. I have
ಹೇಳಿ,
challenged,
ಏನ್ ಕೇಸ್ ಹೇಳಿ.
I have challenged the transfer order annexure C, lordship.
Annexure
C. Transfer order. Dated 4/9/2024. Lordship, subsequently we made a.
Where are you transferred to?
Transfer to Hyderabad.
From?
Bangalore to Hyderabad. Lordship.
ಇಲ್ಲಿ ಬೆಂಗಳೂರು ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದೀರಾ?
ಬೆಂಗಳೂರಲ್ಲಿ from 2019 ಇಂದ working in Bangalore.
ಎಷ್ಟು ವರ್ಷ ಇರಬೇಕು?
Lordship, actually going to retire 2026. As per the service guidelines, last tenure has to be retained in our home sector. That is
2026 ಅಲ್ಲಿ ನಿಮ್ದು ರಿಟೈರ್ಮೆಂಟ್.
ರಿಟೈರ್ಮೆಂಟ್ ಇದೆ.
My lord, it is a annexure C is a general transfer, my lord. And now,
Correct, madam, if he's,
my lord,
he
Hyderabad
has
is
got an
also-
option alwa.
Yes, my lord. But since from 11 years, he was working in the home sector, my lord.
Illi?
5 years Mysore and 5.5 years Bangalore, my lord.
Ah.
And now he has transferred to Hyderabad. Hyderabad is also a metropolitan city, having
is
same
right.
medical facilities which are having in Bangalore, my lord.
Ah.
And due to administrative reasons, he was transferred.
Madam, he has an option in his entire career
Yes, my lord.
to stay in one, in the home district
It
or
is
home
also-
state.
Hyderabad is also home sector, my lord.
Home
Kindly
sector
see-
ಹೆಂಗಾಗುತ್ತೆ?
Kindly see this guidelines, my lord.
ಇದೆ.
Page number 16 of statement of objections. There are 8 sectors have been distinguished as per this guidelines, my lord.
Both.
And he is,
Please point out a man who's on the verge of retirement, ಅವ್ರನ್ನ transfer ಮಾಡೋದ್ರ ಬಗ್ಗೆ
yes,
ಎಲ್ಲಿದೆ?
my lord, because he has served for 21 years in home sector. And whereas he was served in out of home sector for only 16 years. And it is, the transfer is also within the home sector, my lord. It is a
Please point out, man on the verge of retirement, what is that should be done?
kindly see guidelines 16C, my lord. Page number
Page that your lordship.
17 of statement of objections, my lord.
Yes.
16C. As clarified above, a person can be considered for home sector in his last tenure, provided vacancies are available. And criterion for that will be net out of home sector posting is equal to net out of home sector is equal to first out of home sector months plus second out of home sector months minus first home sector months. Persons with more net out of home sector posting will be given priority, subject to
Persons with more net out of
home sector.
home sector posting will be given priority subject to operation. or
Administrative requirement.
ಆಯ್ತು, ಔಟ್ ಆಫ್ ಹೋಮ್ ಸೆಕ್ಟರ್ ಎಷ್ಟು ವರ್ಷ ಇದಾರೆ ಇವರು?
16, my lord. 16 years he was out of home sector and 21 years in home sector. And moreover, my lord, Hyderabad is also home sector as per this guidelines, that is page number 16, my lord. Hyderabad, Bangalore, Andhra Pradesh, Karnataka, Kerala, Telangana, Tamil Nadu, Puducherry and Lakshadweep. These are all in south sector. Now,
Lakshadweep is also in south sector, huh?
yes, my lord. Page number 16, kindly see statement of objection, page number 16, my lord. The present working place is also south sector and Hyderabad is also south sector, my lord.
ಆಯ್ತು, please point out what about a person on the verge of retirement, how he should be dealt with?
My lord, this as per 16C, he has worked more than 21 years in home sector and another person which is transferred to this place is also retiring in within 1 year, my lord. And moreover, he sought for transfer to URSC Bangalore. URSC Bangalore, there is no availability of post, my lord.
There is no post available now.
Yes, my lord.
What about the post that
Another
was?
person is working in URSC. URSC is another branch. And in that place, another person is working and there is no vacancy, my lord.
ಇದು ಯಾವ್ದು CSF?
Yes.
Yes.
Yes, Mr.
Lordship, kindly appreciate page number 14 ಅಲ್ಲಿ ನಮ್ಮ ಪೆಟಿಷನ್ ಪೇಜ್ ನಂಬರ್ 14 ಗೈಡ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ 12 ಟೆನ್ಯೂರ್ ಆಫ್ ಪೋಸ್ಟಿಂಗ್ಸ್ ನಲ್ಲಿ ಅದರಲ್ಲಿ ಬೇಸಿಕ್ ಟ್ರೈನಿಂಗ್ ಪೀರಿಯಡ್ ದೆನ್ ಅದರಲ್ಲಿ ಏನೇ ಫಸ್ಟ್ ಟೆನ್ಯೂರ್ 7 years in out units in out of home sector, second tenure 12 years in units in out home sector, third tenure 6 years in out of home sector, fourth tenure remaining service home sector. Lordship, these conditions clearly applicable to the petitioner. He is entitled to carry his remaining service in Bengaluru. Moreover, Lordship, kindly appreciate the petitioner mother, 92 years old woman. She is bedridden. is the petitioner is the sole son.
Olson.
Sole son.
Hmm.
No one is take care about his mother. At a time, he has been transferred to the Hyderabad. We lose his mother lordship. It is a very critical situation. Now under the guideline also, he is entitled to carry the service in.
Yes, my last leg, he should be in the home sector.
Yes, my lord, it is Hyderabad is also, it is home sector transfer, my lord. It is not out of home sector, my lord.
What is home sector as per the
Home sector means,
Hey, what- home sector and the illegal? For the purpose of this policy, there shall be following sectors.
and also in guidelines 13, it is clearly stated that, my lord, however, the area under sectors
The
can be.
purpose of this policy, home sector means a sector under which the home address of personnel declared at the time of appointment falls. All other sectors shall be treated as OHS. However, the proposed NCR and so on is one sector. Yes, Mr.
Let's.
ಇದು ಹೋಮ್ ಸೆಕ್ಟರ್ ಆಂಧ್ರನು ಬರುತ್ತಲ್ಲ.
Andhra Bharutte lordship, home sector Bharutte, but
And,
really
next
mother, I have produced the page number 32 lordship, kindly appreciate.
And all medical
page
facilities are available in Hyderabad.
Atmosphere
as
is
same
different
as
lordship.
Bangalore, my lord.
Medical facility available idruno, atmosphere is very important. Now lordship, idರಲ್ಲಿ
And,
doctor opinion to that
As per Annexure C, one.
Let him
allow-
complete, madam. Let him complete.
as memory
ಎಲ್ಲಿ ಓದಿ ಏನ್ ಬೇಗ ಹೇಳಿ.
lordship, ಅದರಲ್ಲಿ doctor last ಅಲ್ಲಿ opinion ಕೆಳಗಡೆ bottom.
Page number
Page number 32 lordship.
32 is crediting of CWF.
Annexure E, 31 is Annexure E ನಲ್ಲಿ, ಅದಾದ್ಮೇಲೆ page number 32 some. Doctor opinion to that as memory disturbance or worsening and diabetes, multiples hypertensions and hyperthorium and breast operated.
Correct, somebody needs, she needs constant monitoring with the
Yes, yes.
caregiver beside. ನೀವೆಲ್ಲಿ ಕೆಲ್ಸಕ್ಕೆ ಹೋದ್ಮೇಲೆ ಎಲ್ಲಿರ್ತೀರ?
ಅಲ್ಲ ಅಲ್ಲೇನಾಗುತ್ತೆ ಕೆಲಸ ಅಂದ್ರೆ ನಮ್ಗೆ ಶಿಫ್ಟ್ ಇರುತ್ತೆ lordship. ಬೆಳಿಗ್ಗೆ ಶಿಫ್ಟ್ ಆಫ್ಟರ್ನೂನ್ ಶಿಫ್ಟ್ ಅಂತ ಇರುತ್ತೆ. When immediately I can attended the needs.
ಅಲ್ಲೂ ಶಿಫ್ಟ್ ಇರುತ್ತಲ್ಲ.
ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಇರುತ್ತೆ, ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ, ಇವ್ರು ಶಿಫ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಹೈದರಾಬಾದ್ಗೆ.
ಹೈದರಾಬಾದ್ ಶಿಫ್ಟ್
ಶಿಫ್ಟ್
ಇರುತ್ತಲ್ಲ.
ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅಲ್ಲ ಹೈದರಾಬಾದ್ ನಿಂದ ಇಲ್ಲಿಗೆ ಬರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
What are you? You're an inspector.
ಹೌದು ಸ್ವಾಮಿ, ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಇನ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸರ್. ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಇನ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸೆಕ್ಷನ್, ಇನ್ಸ್ಪೆಕ್ಟರ್.
ಯಾವ್ದು ಬೇರೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಜಾಬ್ ಯಾವ್ದು ಇಲ್ವಾ? ನಾನ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್.
No, my lord.
Put him in some non-executive cadre here.
There is no availability of.
You point out, is there any vacancy?
I will
ಯಾವಾಗ?
on 2 weeks time.
2 weeks ಎಲ್ಲ ಇಲ್ಲ. ಟ್ಯೂಸ್ಡೇ ಒಳಗೆ ಹೇಳ್ಬೇಕು. Just on Tuesday. ನೀವು ಬೇಗ ಹೋಗ್ಬೇಕಲ್ಲ ಹೈದರಾಬಾದ್ಗೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಕ್ರಿಟಿಕಲ್ ಇದೆ lordship.
So therefore you please point to if there's any vacancy in Bangalore. ಈ 2 weeks ಅಂತ ತಿರ್ಗಿ ಅದು fill up ಆದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
Another person is waiting for this place.
If there's a vacancy, madam, please consider him.
23.
So Rangna Joyce, IA 3 of 24 impleading, ಏನಿದೆ?
Notice has to go. Both.
Issue notice on IA 3 of 24. Huh? They should be emergency. ಅದೇ IMLA. Issue notice on IA 3 of 24. To the proposed respondents.
Date me.
The process ಕೊಟ್ಟಿ first.
ಅದು ಕರ್ದು.
Yes, next.
24.
Yesterday I have taken time and not based on record.
Yes, please.
Judgment of this honorable court.
Huh?
The judgment of my lord,
Kodi.
this honorable court in coordinate bench.
ಅವ್ರು ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಅವ್ರಿಗೆ.
ಆಯ್ತು, ಕಾಪಿ ಕೊಡಿ ಇನ್ನೊಂದು ಏನು?
ಅಲ್ಲ ಕೊಡು, ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. But this is the issue has come up for consideration regarding my lord, the deployment and the transfer. The lordship will find at para 2 of the
the rival, the rival submission are within a narrow compass, so and so the learned senior counsel for it submit that indeed the guidelines of transfer of government servants in short transfer are issued, cancelling the earlier guidelines for transfer of government servant dated 7/6/23 and making the distinction between the transfer and deployment, defining the deployment.
Page number?
Page number 4, my lord, internal page 4, para number 2.
That is your argument.
Please, my lord, just
Please come to the findings, sir. Please come
finding,
to-
I will come to the
Issue
findings.
is at page para 8.
Para 7, your lords.
Hmm.
It starts from para 7.
Hmm.
Para 7, page 7. In rejoinder so and so, reiterate the transfer guidelines 24 applies both to transfer and deployment. Before that, my lord, the please, my lord, transfer and deployment and the learned council while proposing to argue that there is a transfer and not deployment, points out that if a government servant is to be transferred either before or after the minimum period, it should be only for any of the reasons mentioned in the 7(1) of the guidelines. This court must at the very outset observe that there cannot be any quarrel about the proportion canvassed by so and so as regards the modified use and hardship before this court. But the question for consideration in the light of the rival contention, whether the terms of the transfer guidelines 24 would be enforced if there is a violation of the terms thereof. B, whether the second respondent in replacing petitioner with the third respondent by so and so has acted in breach of the guidelines. Insofar as the enforcement of transfer guidelines, this court must refer the decision of the full bench in so and so Chandru versus State of Karnataka, wherein it has held as follows, while opining that though the provisions of the Karnataka Civil Service Act 1978 provides for regularization of recruitment and the condition of service of the provisions of so and so rules, define transfer rules, but they do not provide the regulation of transfer. Para 12, in view of the decisions of the Honorable Supreme Court and admitted facts, and there is no rule providing for regulating the transfer and providing guidelines therein, the executive order issued in excess of around Article 162 of the Constitution of India will have a statutory force and can be enforced as the extent of executive power of the state to make laws is subject to the provisions of the Constitution, and the executive power of state shall be extended to the matters in respect to which legislature has the power to make laws. These transfer guidelines 24, as is stated in the preamble, are notified superseding the 2013 and revising the guidelines as contained in these
2013 guidelines ನೋಡಿ ಯಾಕಂದ್ರೆ ನಿಮ್ದು ಹಳೇದಾಗಿ 2013
guidelines
ಅಲ್ಲಿ
ಅಲ್ಲಿ ಇಲ್ಲ ಅದಿಲ್ಲ, there is no such.
2013
That has been culled out, your lordships, my lord.
2013 guidelines ಇದೆಯಾ?
ಇದರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಅದ್ರ ಪ್ಯಾರಾ 11 ನಲ್ಲಿ.
ಹ್ಮ್.
ಪ್ಯಾರಾ 11 ನಲ್ಲಿ the comparison, my lord.
ಒಂದು ನಿಮಿಷ ತಾಳಿ ಪ್ಲೀಸ್. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಮೀನಿಂಗ್ ನೋಡಿ. 2013 guidelines ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮೀನಿಂಗ್ ನೋಡಿ. Means the posting of a government servant from one headquarters to another headquarters or from one office to another within the same headquarters to take up the duties of a new post or in consequence of a change of headquarters. Note, movement of a government servant within the same office unit from one post to another one or desk compilation to another one shall not be treated as transfer. So therefore, within one headquarters, if you are posted from one office to another, it amounts to a transfer. So ನಿಮ್ದು ಇದು ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ 2013 guidelines ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ it is
2013 guidelines, so lordship was the word transfer only. There was no, my lord, the word deployment.
I am arguing in your favor.
Please.
The 2013 guidelines ನಿಮ್ಗೆ ಅಪ್ಲೈ ಆದ್ರೆ the first posting and the second posting should be treated as a transfer. So the last posting was in 2023. So therefore it can't be, you can't be transferred out before you complete the minimum tenure. ಅದನ್ನ ಹೇಳಿ. Yes, what is the answer for that?
My lord, so far as this judgment, my lord, relied on by my learned friend.
I'm not relying on this. ಇವಾಗ ಇವ್ರದ್ದು ಫಸ್ಟ್ ಆಗಿದ್ದು ಎಷ್ಟನೇ ಇಸ್ವಿನಲ್ಲಿ? 2021.
Please, 2020, my lord. Please,
Then 2023.
Please,
2023 is obviously based on this transfer.
Please.
Within the headquarters to a different office.
Please.
So it's a transfer. 2024 ಅಲ್ಲಿ deployment ಬರ್ತದೆ.
Please.
We are not looking at 2024 because it was not there when he was posted in 2023.
In 2013 guidelines, my lords, there is no use of the word deployment at all.
So therefore, it should be treated as a case of
But the
transfer.
2024 guidelines, my lords, supersedes the 2013 transfer guidelines. So the transfer guidelines of 24 has to be read as if
2023 ನಲ್ಲಿ ಇನ್ನೊಂದು ಆಫೀಸ್ ಮೈಸೂರಲ್ಲಿ ಇನ್ನೊಂದು ಆಫೀಸ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ within the same headquarters, it is a transfer under this guidelines.
Please.
If it's a transfer under this guidelines, for the purpose of 2024 guidelines, it should be treated as a transfer only. It can't become deployment.
may make one request, my lords. In so far as the judgment relied on by my learned friend, my lords, apparently that is under challenge and it is for dictation of orders at serial number 6 in court 1 today. May I request for either Wednesday or Thursday?
Counsel for the respondent seeks time. List on Wednesday, na?
Wednesday. Wednesday.
Wednesday better, Friday.
Whichever date.
Friday.
Friday.
I'm grateful.
Interim order to continue.
Interim order granted release extended to the next date. Very good.
Serial number 1, Bhagwan.
List number 2.
Here for the respondent, Lord, High Court
Obtained to adopt
Administration.
the written statement. 1.1.
Matter may not survive because, my lord, the question that is raised in these petitions are the reckoning the date of seniority of fast track court judges.
It's
ಅದು
abolished.
ಅವ್ರ ಫಾಸ್ಟ್ ಟ್ರ್ಯಾಕ್ ಕೋರ್ಟು ಇಲ್ಲ ಮತ್ತೆ ಇವರೆಲ್ಲ ರಿಟೈರ್ ಆಗ್ಬಿಡಿ.
Hmm.
All the petitioners, my lord, there are in 2 petitions, all of them have retired.
We have engaged PS Rajgopal sir. He's held up at court all 3. He'll be here, my lords. Kindly pass over.
ಪಾಸ್ವರ್ಡ್ ಮಾಡೋದಾ ಬೇಡವಾ?
ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲ ಅವ್ರು ಬಂದು ಹೇಳ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳೋದು.
ಯಾರು?
PS
ಪಾಸ್ವರ್ಡ್.
Serial number 2. Not called later in the afternoon or sometime, not should I wait?
230.
Please.
Representing petitioner, my lord.
Kishan GS.
But the petitioner is 90% disabled, my lord. Kindly pass over. The other side is not here, my lord.
90%?
90% disabled, my lord. Even after 5 years of his retirement, my lord.
Sister, what is the writ petition? Petitioner might be 90%. What is the writ petition about?
Lord, the petitioner has worked as a manager in a respondent warehousing corporation and has retired on 31st 10th 2019. Annexure C, my lord.
25? When did he retire?
On 30th 10th month 2019.
2019.
30/10/2019, my lord. Almost 5 years is completing, my lord.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
Lord, his service retirement benefits has not been given.
Why?
Lordship,
Is there any inquiry against you?
no inquiry, departmental inquiry is held, my lord. And my lord, after 4 years of retirement, my lord, no inquiry can also be initiated in respect of.
That is okay, but any inquiry as it.
No, my lord, no departmental inquiry has been ever initiated or ever pending. Without any blemish, he has retired from his service, my lord. There is already an order passed by this honorable court.
Answering respondent. MS Devaraju.
Ms. Devar. Kindly pass over, my lord. He was present in the morning, my lord. And it is also covered by judgment, my lord.
It covered in retirement benefits ki covered in bantu.
Yes, my lord.
Service
Kindly pass over, my lord.
pension ಕೊಡ್ಬೇಕು ಅದನ್ನ covered in. Pass over.
Grateful, my lord.
Number 1 for press mat, serial number 25.
Prithvish.
Let's.
Yeah, IFO production of certified and legible copy ಎರಡು allow ಮಾಡಪ್ಪ. Yes.
Let's,
I hope it is legible.
yes.
Let's, I have filed, seeking for quashing, of the endorsement at Annexure G.
Annexure?
G, the endorsement, would essentially reject my case, on the ground that, the university with which, I have completed my masters in business administration is no more recognized, and therefore we will not consider your MBA degree, the notification calling for application, is at page 29. I'm only taking your lordship to the relevant serial number 4. Manager marketing must put Fourth column, must possess a degree in MBA marketing awarded by an university established by law in India or equivalent qualification, and Malad, the other work experience. Accordingly, Annexure B, Malad, I have made my application. Page number 32, Malad, are the documents that I have annexed. 32 bottom, Malad. SSLC, PUC, BBM, MBA, so on and so forth. That's also not in dispute, Malad. Then, Malad, the Annexure C, Malad. Those who are held to be eligible, Malad, notification is issued with the list of names. Page 33. Relevant portion, Malad, would be at page number 38.
Document verification yavagagidu.
Document verification agate page number 38 alle not having required qualification and bantu. 38 serial number 10, Malad. Not having required qualification. Then, Malad, I made representations pursuant to which, Malad, the letter was written to the Karnataka state, page 47, Malad. They would admit, KSOU would admit that yes, he has completed the course. But today I can't verify because, Malad, it's no more recognized, that college. And therefore, Malad, I will not verify the marks. May I just read the first paragraph. With reference to the above, you are hereby informed that the verification of Master of Business at bearing number so-and-so pertaining to Shri so-and-so is corroborates with the office records for the exam section of this university. Further, the incumbent student has pursued the said Masters of Business Administration degree under the erstwhile so on and so forth. Therefore, Malad, admitted cases have pursued the degree.
No, but it says
yes,
they are not obtained recognition.
Yes, Malad. Subsequently, Malad, that recognition now, Malad, is not available. Therefore, Malad, what
everything goes, it's quite a big issue.
Malad, what would apply, Malad, is page number 14. I have referred to a judgment of the Supreme Court, Malad. Malad, when I take up the admission, Malad, it is recognized. Subsequently, Malad, if it gets de-recognized, Malad, in fact, Malad, the
Supreme Court was only saved those candidates who are pursuing the course.
Malad, may I just have your Lordship's attention at page 14, Malad, of my pleading. I've quoted the relevant portion of the judgment. Page 14. Suresh Pal versus State of Haryana reported in so and so. Paragraph. We are of the view that since at the time when the petitioners joined the course, it was recognized by the government of Haryana and it was on the basis of this recognition that the petitioners joined the course. It would be unjust to tell the petitioners now that though at the time of the joining the course it was recognized, yet they cannot be given the benefit of such recognition and the certificates obtained by them would be futile. Because during the pendency of the course, it was de-recognized by the state government on so and so. We would therefore allow the appeal and direct the state government to recognize the certificate obtained by the petitioners and similarly situate as a result of completing the certificate course in Shri so and so, for the purpose of appointment as physical training instructors in
But there's nothing to show that it was recognized. Degree recognize
when we joined the course, Malad, that's why KSOU would say yes, they have pursued the course. Now, Malad, subsequent.
It is the course itself was not recognized.
Yes.
They could not have awarded the course.
May I make the submission, Malad? I understand, Malad.
Notice, but emergent notice.
Malad, my submission is.
No entry mark.
Malad, I'm only seeking for permission to participate.
No.
Your Lordship may clarify that no appointment will be given to me.
We can't block the appointment just in
Malad,
case if you are selected, then what should happen?
Malad, your Lordship may say that I will undergo the process.
To notice. Any appointment that may be made shall be subject to the result of
Very
the
well.
petition.
Grateful.
Lords, in 2011, the petitioner came to be appointed as junior engineer. At the time of his application for the job, he had only possessed diploma degree. Subsequently, at the time in 2008, he finished his engineering degree. But in 2011, his appointment order came, but he was classified as a non-graduate holder. Subsequently, my lord, in 2000,
take out notice. PWSSPR. PWSSP. EL Sanjeev MS Narayan. Mr. MS Narayan is directed to accept notice for the respondents.
may I request for subject to result of his seniority? I've challenged the seniority list. Subject to result.
Nothing is going to happen. Unnecessary ಕೇಳಬೇಡಿ.
Great.
ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ.
And
You sought for a mandamus and you want an interim order. You only sought for a mandamus to consider seniority and you want interim order.
I've also challenged the seniority.
It's all right. So therefore, it's virtually like allowing your writ petition. If you grant a stay. Yes, madam.
Appellant, my lord, this is regarding reinstatement of the respondent. She was working as an assistant professor in Vivekananda Institute of Technology in Civil Engineering, my lord. Due to her misconduct, there was a disciplinary action taken against her and she was removed from this service.
Yes.
And after removal, she's filed.
What is the charge against you?
My lord, it is basically to spread the rumors against the principal of the college. There was a WhatsApp group which was created where students have sent lot of false information regarding the principal, telling that he has circulated the question paper and he is involved in malpractices. And this came to the respondent's WhatsApp, and she also subsequently circulated these particular messages. That was the charges. However, they have not given her an opportunity for hearing, my lord, in this particular case.
Take out
And
notice, madam.
my lord, their notice was served. However, my lord, they
That
filed
was,
execution petition.
In
We
fact,
have,
lords, I appear, my lords, for the respondent. My lords, the clear finding, my lords, of the court below, is the tribunal is no inquiry is held. When not section 94, my lords, when it is mandatory that before terminating the services, my lords, it is required to.
Inquiry madilla.
ಏನು ಮಾಡಿಲ್ಲ.
my lord,
What they
however,
say is, my lords, what the documents they are relying upon in this petition is that we interrogated the employee concerned.
Where's the finding of the tribunal? What is the finding of the tribunal?
Tribunal is no inquiries.
Where does it say?
If I'm permitted, my lords, paragraph 13 of the judgment at page number 20.
my lord, however, we have issued a reinstatement letter to her, my lord. Now we have issued a reinstatement letter and also calculated her arrears. In
No, that
spite
is not the issue. If she is guilty of any misconduct, you have to conduct an inquiry, whether
Yes,
that
sir.
is done.
Lord,
But,
the
sir,
inquiry was
come to
not
lords,
done, my
page
lord.
number 20,
But
my lords of.
inquiry was
petition.
not done. Subsequent,
Inquiry is not done, then what is the mistake in the order?
my lord, the mistake in the order was basically that we are ready to do the inquiry. Subsequently, after looking into all those, my lord, we have reinstated her. And we have also intimated to her that we have reinstated you, come and join. And also because during the time when she was revealed from the service, we have also calculated her arrears, my lord. And that arrears of that also we have intimated to her. And this particular around 25 lakhs, we have also deposited in the execution proceedings, my lord. In spite of that, we issued the reinstatement order on 26/2/24. We have sent 2 reminders to her telling come and join immediately with immediate effect. Still, she is not come and join, my lord.
When will
And
she
we
join?
also knew that.
If lordships kindly say, lords, the submission that they are entitled to hold an inquiry after reinstatement, lords, is not correct. Lord, in Golden Valley's case, lord, this honorable court said, it is for the KAT, my lords, that is EAT to hold an
I
inquiry.
think pending
otherwise.
consideration of this appeal,
Lords,
petition, why
lords,
don't
I
you-
would submit, if lordships kindly come to lords, page number 22. The my lord's decree is that I'll be reinstated subject to payment of back wages. My lord, that back wages, my lord, is to the extent of, my lords, about 90 lakhs. Now, what the other side says, my lords, initially they said we'll reinstate you. I said I'm ready to be, my lords, ready to get reinstated, but after going there, now, how about my back wages? I said that needs to be paid. The educational appellate tribunal.
Then from the date this order is passed,
Lords, I am
you will say
entitled.
that you are not entitled for salary.
My lord, unfortunately, my lords, that is not the case. My lord,
No,
fact
from-
remains that, my lords, I was kept out of, my lords, the employment.
when will you join? When will you join?
My lords, that I have to take instructions, my lords, and.
Look on it.
My lord, till then.
Can't be gagging the
No,
management.
no, definitely not. My
one
lords,
was
my lords, I
Go
appreciate.
tell somebody, if you have any difficulty, we'll protect
Well,
you.
my lord, what the executing court said is, yes, you have said you are going to reinstate her, but what about the back wages?
Back
Let them
wages, you
say that we'll
execute
pay.
it, mister, you execute it.
My lord, in execution itself that is
My lord, in
happening.
execution,
I
we have.
said, this is the amount I am asking for, and.
Please report to work. Otherwise, from the date the court has passed an order,
Please.
we will say that you will not be entitled to back wages until you report.
Your lords may have it on Wednesday. my
Ilandre,
lords.
you want to take some money and get out, please just tell us how much you need.
My lord, we are totally according to our calculation, she is entitled for around 50 lakhs, my lord. And that we have also produced before the.
How much are you willing to pay her?
Already paid 25 lakhs before the.
He says 90 lakhs.
90 lakhs.
It's not
lords,
the
as per
correct calculation. My lord, apart from that, after she was revealed from the service here,
Please
she's
find out
also
what-
working in other institution, my lord.
Town council for the respondent seeks
Lord,
time to
kindly-
secure instructions whether the respondent would report to work, would rejoin the work in view of the offer made by the petitioner to reinstate her services. List on yavat.
My lord, kindly till then, stay the execution proceedings, my lord.
And
We
if you
got-
want to stay, deposit the entire
we have
thing.
deposit 25 lakhs, my lord. We will deposit. my
Deposit
lord.
the remaining 25.
Give us some
according to you.
time, my lord. Support,
Yavattu.
my lord, around 4 to 5 weeks time, but till kindly stay the execution proceeding.
No, we'll stay, but you have to deposit the remaining.
We have already
remaining.
deposited 25 lakhs, my lord,
I
according
do
to.
not know how much is the remaining.
According
Deposit
to
the
our
remaining.
calculations, 50
In
lakhs,
fact,
my lord.
what the executing court said, that they are claiming about 90 lakhs. According to it is 50 lakhs. Deposit 50 lakhs will.
ಅದನ್ನ ನಾನು ಕೇಳ್ತಿರೋದು.
That is what not is happening in the
My
execution.
lord, kindly
In the
give it 2
meanwhile,
months' time,
in the
I will
meanwhile,
deposit.
the execution of the order dated so and so passed by the so and so in MAE80 number so and so is stayed subject to the petitioner depositing a sum of rupees 25 lakhs.
Additional
25
sum
lakhs,
of-
yes,
Sum of rupees 25 lakhs apart from what is already deposited
Please.
within a period of 4 weeks.
2 months, my lord. I'll pay a half, my
Yes,
lord. It's
madam.
like too much, my lord. for
If
the
you do
institution.
not want, I'll recall this order
No.
within 4
Lord.
weeks.
Petitioner for the respondent. My lords, respondents has filed statement of objections, my lords. Request for 2 weeks time to file rejoinder, my lords.
Here, what is this
My
petition
lords, we
about?
have challenged the termination order, my lords. Petitioner was working as permanent lecturer appointed in the year 2012 and
Then he filed
confirmed in
objection file
2014.
ಮಾಡಿದ್ರಿ?
ಮಾಡಿದ್ದಾರೆ.
Town council for the petitioner seeks time to respond to the statement of objections filed by the Town
Respondent
council
number
for
4.
respondent number
4,
List on.
2 weeks.
ಬೇರೆ ಕೇಸಲ್ಲಿ ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀರಾ?
Lords,
ಬೇರೆ ಕೇಸಸ್ ಅಲ್ಲಿ ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀರಾ?
lords, instructions.
You have an interim order in this case.
No, my lords.
This next.
Lords, date.
What is the petition about?
Page 33 is my prayer.
33 now.
Yes. Let the,
And co-warrant.
let I understand the consequences of the prayer, considering the institute that is the respondent. My only prayer is this today before your lordship. Prayer number C, I'm only seeking for a direction to appoint a regular registrar who is competent to hold the post, my lords, in Nimans. My lords,
But
if
how are
I-
you challenging, seeking for writ of co-warrant to?
my lord, because the present registrar, my lords, is only an in
So
charge.
who are you? You are only an employees association.
Association.
How can you challenge?
My lords, then, my lords, it's a writ of co-warrant. Since
Correct.
he's
How can you
ineligible,
challenge?
my lords, only in
How
so
can
far as
you
co-warrant, my lords, there are 3 things that will go against me, my lord. Your lordships may kindly bear this. My lord, let me, before I state what is in my favor, may I state what is against me, my lord. Your lordships, my lords, 3 things can be said. One, my lords, writ of co-warranto may not lie against an in-charge registrar.
Yes.
Second, my lord, your lordships may say, my lords, that it's insofar as delay is concerned. Because for over, my lords, a decade, there is no regular registrar in Nimans. Third, my lords, that it will have to go to Central Administrative Tribunal. Because, my lords, Nimans would fall. My lords, my answer to all 3 would be this, my lords. Insofar as, my lords, jurisdiction, since it does not involve any condition of service of the petitioner, writ of co-warranto, my lords, would lie only before your lordships. Now, my lords, insofar as delay and, my lords, writ of co-warranto, my lords, it is
Not considered. Purple IA 2 of 24 is filed for early hearing.
Let may I make this
The
request, my
petition
lords.
is not admitted, and older matters are awaiting consideration. IA 2 of 24 is rejected. List the petition for preliminary hearing in B group as per seniority. Yes.
Let may I make this request, my lords, for over
The
a
government take a call, Mr.
my lords, that's all. Your lordships may direct them and, my lords, close the writ petition itself. That's all that I'm seeking for, my lords.
Yes.
to take a decision to appoint a regular registrar. That's all.
As far as central government is already notified.
Let's,
on deputation.
why should you continue an in-charge registrar
At
of a,
Nimans has to answer matters as far as notification is concerned, we have issued to the Nimans.
Nee
Calling
where again?
upon- I am for central government.
central government?
Yes.
Ah.
We have issued already notification calling upon the persons who are interested to be on deputation. for
ಆಯ್ತು,
the
ಯಾವಾಗ
post.
ಮಾಡ್ತಿರೋದು?
May seek a week's time, I will place it on record.
ಲಿಸ್ಟ್ ಆನ್ ಅದು IA 2/24 ಹಂಗೆ ಇರ್ಲಿ ಮಾಡ್ರಿ, ಹೊಡೆದಾಕಿ ಅದನ್ನು. The learned counsel for the respondent number 2 submits that the issue in this petition is regarding appointment of a regular registrar and full stop. The learned appointment of a regular registrar. He submits that proceedings are on
No,
for appointment of a
no, not that one. They have issued the notification. I don't know what transfer. later after
Notification is
take
al-
instruction.
a notification is already invited, issued, sorry, published, inviting applications from eligible persons for the post of,
Annexure M.
for the post of registrar.
Registrar. Annexure M
So,
and
he therefore
annexure M1.
submits that he would seek instructions about the present position. Hence list on yavat
29th, sorry, 30th.
30th,
30th.
yes.
Grateful.
Prashant HS.
Assistant Sub-Inspector of
40 comments.
CSF Department,
Huh?
who is on the verge of retirement, an Assistant Sub-Inspector of the CSF Department, who is on the verge of retirement, seeking for a request transfer from Mysore to Bangalore. My lord, may kindly see the order dated 7/8/24. The previous directions by my lord.
Huh?
Order dated 7/8/24.
Since the petition of the verge of retirement, request will be considered. Yes, madam.
Lord, we spoke to the concerned people that they just gave us the representation. If agreed, I can.
Kodi,
just-
then.
Can I, the presentation form ಎಲ್ಲ ಹಾಕಿಲ್ಲ.
ಆಯ್ತು,
I
ತೊಂದ್ರೆ ಇಲ್ಲ,
apologize for
ಕೊಡಿ.
that.
What are your instructions?
They have said like he has worked. As per posting of the profile, the petitioner belongs to Tamil Nadu, which comes under South sector, which consists of Andhra Pradesh, Karnataka, Telangana, Tamil, Pondicherry and Lakshadweep. He has completed 13.6 years in the out of home sector and 22.11 years in home sector. He is due for home sector presently and is serving at CISF unit RMP Mysore with reference from 1622. And the petitioner earmarked posting IUT 22 issued by DAE and DOS headquarters Delhi from URSC Bangalore to DAE Zone 1 headquarters Hyderabad, while IG DAE and DOS headquarters service order number 66 of 22 dated 28/4/22. Further, DAE Zone 1 headquarters Hyderabad allotted him CISF unit HMT Mangaluru. So ಅವರು ಎಲ್ಲ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಂಡ್ ಬರ್ತಾನೆ ಇದ್ರು ಸ್ವಾಮಿ. He was
I
taking
just say,
transfer.
if there's a place of posting in Bangalore, why don't you give it to him?
No, there is place of posting in Bangalore. As per annexure R8, he has given like these places only he has to be transferred. Like he has requested for posting to CISF unit, Electronic City, Infosys and URSC. So as he.
ಅದೆಲ್ಲ ಇಲ್ಲ,
No,
ಬೆಂಗಳೂರು
no, any place.
other place you find out,
So apart from
Madam,
this, there is no other. place.
any other place in Bangalore. ಅದ್ರ non-executive ಸುಮ್ನೆ ಟೇಬಲ್ ಜಾಬ್ ಇದ್ರು ಕೊಡಿ ಅವ್ರು.
The representative has come actually.
No, he says that he has got some difficulty,
Yeah,
ಮಗ,
he has, like, but
his son is studying or something
as
like
per
that.
annexure R12, it is not considered Swami.
Yeah,
As per annexure R12, which we have produced in the statement of objections. So really, they can't consider.
no, he cannot choose the posting.
He can't choose the posting.
So you please,
Likewise, in one nimission.
please give him a posting of any post in Bangalore, any post.
They are not accepting actually,
ಯಾರು?
commander, because atra rules illa, it will affect us.
Madam,
because
rules is there.
opening ಮಾಡಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಆಗತ್ತೆ ಅಂತ ಸ್ವಾಮಿ.
Yes.
Then it will be like very difficult for them because he is like even now asking the
Okay,
same
please
places.
tell us where is, if there's any vacant post, it will be an order of the court. They let them not take the blame. The court will take the blame.
Because
He
he's.
is on the verge of retirement.
Yes, we agree that.
Now you want to send him to which place?
Mysore Swami. Mysore is like not too far of idu anta. They have given like it's only 1 hour, 2 hour journey. ಅವ್ರು ಹೋಗ್ ಬರಕ್ಕೆಲ್ಲ ಅವ್ರ ಫೆಸಿಲಿಟಿ ಮಾಡ್ಕೊಡ್ತೀವಿ. Let him be there next October ವರ್ಗು ಅಲ್ವಾ ಅಂತ.
Next October he is going to retire.
He will be retired.
Yes, next October, I'll be retiring.
Yeah.
My lord, at the time of my lord transfer, if I were to make a request, my lord, they would have continued me in Bangalore. I did not make any request because there was no
So
problem.
opted for Mysore.
And my lord, there is a direction, my lord, by this honorable court, and even the superiors, my lord, have recommended, my lord, page 30. There is a specific recommendation, my lord, by the superiors. Page 30, my lord, annexure K. DAE zone 1, my lord, recommended and forwarded, please, my lord. That is the third column, my lord. This was the recommendation. And there was a clear direction, my lord. That is the annexure, my lord, O, page 52, my lord. By this honorable court, my lord, to consider, my lord, it compassionately.
Yeah, or compassion illa anta ಅವ್ರು ಹೇಳೋದು. CISF ಗೆ compassion ಇಲ್ಲ ಅಂತ.
That's right. That too, my lord, without TADA, I'm asking for. I'll bear, my lord, the TA and DA. That would save, my lord, almost, my lord, 1 lakh rupee, my lord, for the department. Without TADA, my lord, I'm requesting.
Yes.
No, my lord, they won't agree.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has sought for, has challenged the office memorandum dated 12/3/2024, bearing number so and so issued by the respondent number 4. And consequently has sought for a written the nature of mandamus to transfer the petitioner to any CISF unit in Bangalore. Next paragraph. The petitioner contends that he joined the respondent, he joined the industrial security force as a constable and has worked at various places across the country in both the home zone and out of the home zone. Full stop. After completing the out of home zone posting and during his last stint before his retirement, he was entitled to be posted at the home zone. Full stop. The petitioner made a request for posting at CISF unit RMP Mysore. And accordingly, he was posted at CISF unit RMP Mysore. Full stop. The petitioner contends that he is due to retire on 30th of October 2025. Full stop. Petitioner contends that his son is presently pursuing Bachelor of Business Administration at Dayanand Sagar University at Kumaraswamy Layout, Bangalore, and has 1 more year of studies before he completes his degree. Full stop. The petitioner contends that his son is staying in a paying guest accommodation from the date of his transfer to Mysore, and that he is allergic to staying at a paying guest. Full stop. The petitioner therefore full stop. The petitioner contends that his son is therefore not able to concentrate on studies, due to which his education prospects is suffering. He contends that he applied for transfer to any of the CISF units at Bangalore on retirement cum education grounds without claiming TA and DA. Full stop. The said application was rejected in terms of the order rejected by R3 with order dated 6/1/2023. Thereafter, during the general transfer in the year 2023, the petitioner again submitted a fresh representation on 27/3/2023 to the respondent number 3, which again was rejected on, which was rejected. Full stop. The petitioner thereafter approached the respondent number 2 seeking for a request transfer on education cum retirement ground, and also agreed that he would not claim any TA and DA. Full stop. The respondent number 2 accepted the representation of the petition and forwarded to the respondent number 3. Full stop. The director, the DAG of DAE zone, DAE zone 1 Hyderabad had recommended and forwarded the case of the petitioner for appropriate action by the respondent number 3.
Even RIP to Mysore also, madam.
Full stop. However, the respondent number 3 again rejected the request of the petitioner void the impugned order. The petitioner contends that many persons, such as the petitioner, who are not even on the verge of retirement, are permitted to continue in URSC Bengaluru for more than 2 times. The petitioner contends that the respondent number 3 has rejected the request of the petitioner ignoring the directions of the respondent number 2, ignoring the recommendation of the respondent number 2. Full stop. The petitioner therefore had filed WP number 21285 of 2023 before this court for appropriate directions, and the same was disposed of, directing the petitioner to submit a representation to the respondents who were directed to consider the representation and to pass appropriate orders. The petitioner submits that following this order, he submitted a representation dated 1/1/2024, which too was rejected in terms of the order dated 5/3/2024. Full stop. The petitioner is therefore before this court challenging this head order. Next, for learned counsel for the petitioner contended that the petitioner is on the verge of retirement and therefore the respondent number 3 was bound to consider the request of the petitioner for posting at any CSF units in Bangalore. He contends that when the petitioner was earlier posted to the home sector, he was posted at Mysore on his request, and that the petitioner could have conveniently asked for a home posting at Bengaluru instead of Mysore. He therefore submits that the respondent number 3 committed an error in not considering the request transfer of the petitioner to Bengaluru. He also submits that there are several vacant posts in Bengaluru where the petitioner can be accommodated. Having regard to the difficulties faced by the son of the petitioner. Full stop. Per contra, the learned counsel for the respondents is placed on record the instructions obtained from the respondents, which indicate that the petitioner had already served 12.07 years in his home state, that is Tamil Nadu, and 8 years in Bengaluru. Full stop. It is contended that as per the transfer policy, a person can be considered for transfer to in the home sector in his last tenure, provided vacancies are available. It is also contended that as per the posting guidelines, the personnel will be permitted an extension in his or her present unit for 1 year if his or her ward is studying in 10th or 12th class in the current academic year and staying with him at the pace of posting. However, such extension would not be given beyond 1 year. Full stop. It is claimed that since the petitioner's son is pursuing MBA, the same is not covered, BBA, comma, the petitioner is not entitled to claim the benefit under the existing posting guidelines. It's also contended that the petitioner had earlier submitted a representation requesting to change the place of posting from HWP Manuguru to RMP Mysore on retirement ground, and his request was considered by the Inspector General and DAE and TOS headquarters, Delhi, and ordered for posting at RMP Mysore, with order dated 19/5/2022. Therefore, it is contended that the petitioner cannot now seek for a posting at Bangalore. Yes, Mr. Yen Martir. Yen post illa andre yen martir.
1 year left, my lord. There are posts available.
Available, you should point out which is that post.
Mysore is also home sector only, Lord. He
Home
can-
sector, Tamil Nadu, south is home
South is
sector.
home sector.
But which is a vacant, are there any vacant posts, man?
Lord, if it
Yeah,
is-
yeah, first two.
Check ಮಾಡ್ಬೇಕು. But ಅವ್ರು ಕೇಳ್ತಿರೋದು ಈ ಎರಡು ಮಾತ್ರ.
Madam, forget that, ನಾನು ಹೇಳಿದ್ನಲ್ಲ, any post suitable to his cadre. Any post,
Have to check.
cook, non-executive, ಏನಿದ್ರು ಕೊಡಿ. ಕಿಚನ್ ಅಲ್ಲ ಇದ್ರು ಕೊಡಿ, ಎಲ್ಲಿದ್ರು ಕೊಡಿ. ಒಟ್ಟು
ಆಮೇಲೆ ಅವ್ರು ಅದಕ್ಕೂ ಇದ್ ಮಾಡಲ್ಲ, ಮತ್ತೆ ಕೇಸ್ ಹಾಕೊಂಡೇ ಬರ್ತಾರೆ.
ಇಲ್ಲ.
Because
It's
earlier he had
ನೀವು
filed.
ಯಾವ post ಕೊಡ್ತೀರಿ ಹೇಳಿ, suitable to his cadre or matches with his cadre, will compel him to come and serve.
I'll inform.
ಯಾವ Tuesday?
Tuesday.
ಇರ್ಲಿ ಅದು, list on Tuesday. ನೀವು in the meanwhile find out if there's any vacant post.
I'll also. Please.
Obliged.
Tejaswini,
This is the matter. I'm talking to the Anganwadi worker, my lordship, in this case.
huh?
Anganwadi worker.
Huh.
The petitioner appointed in the 2007, my lordship, in this case, as a Anganwadi helper.
Huh.
Now she filed an application before the respondent number 4 for give her a promotion for the Anganwadi helper. This is the case, my lordship, in this case.
Please come again. Petitioner was an Anganwadi worker.
Helper ಆಗಿ appoint ಆಯ್ತು
Huh.
2017 ಅಲ್ಲಿ.
Huh.
Now she given an application to the respondent number 4 CDPO
Huh.
for promoter as a Anganwadi helper.
Huh.
As per the notification, the 2017, my lordship, she is appointed. They took a decision rejecting the my application given an endorsement for 2023 order, government order, my lordship. This is the case. Kindly come to ground 7, my lordship, para 7 of the case. This is only gist of the case. It is simple case. The respondent number 4, as before the mainly relied upon the government order 3/12/22.
ಎಲ್ಲೋತಿದ್ರು paragraph number?
Paragraph number 7, my lordship, page number 8 of the writ petition.
Huh.
Mainly relied upon the government order dated 3/12/22. Same is not applicable to the petitioner. She is been appointed under the government order dated 23/9/2017.
ಎಲ್ಲಿದೆ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್?
ಕೊಟ್ಟಿದೆ. Annexure A is the order.
Annexure A,
Yes,
government order,
yes.
2022 da.
22 ಆರ್ಡರ್ನ ಈಗ ಕೊಡ್ತೀನಿ ಅದು. ನನ್ನ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಅದು ಬಂತು, ಅದು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ದಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಕಿಂಗ್ ಇದೆ.
ನೀವು ನೋಡ್ದಂಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ರೆಡಿ ಮಾಡ್ಬಿಟ್ರಾ?
ಹಂಗಲ್ಲ ಅದು. ಇಟ್ ಇಸ್ ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್, ಇದು ಆರ್ಡರ್ ಆಗಿದೆ ಆಕ್ಚುಲ್ ಆಗಿ.
ಅಲ್ರಿ ನೀವು 2022 ನೋಟಿಫಿಕೇಶನ್ ನೋಡ್ದಂಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ರೆಡಿ ಮಾಡ್ಬಿಟ್ರಾ?
ಅದನ್ನ ಅವಾಗ ಫೈಲ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಸಾಹೇಬ್ ಕೇಳ್ತಿರೋದು ಅಷ್ಟೇ. ಅದೇನ್ ಡಿಸಿಷನ್ ಏನ್ ತಗೊಂಡಿದ್ದಾರೆ ಗೌರ್ಮೆಂಟ್ನವರು ಅಂತ ನಮಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಿದ್ದಾರೆ.
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಐ ವಾಂಟ್ ಟು ಗಿವ್ ದಿ ಕಾಪೀಸ್ ಟು ದಿ ಕೋರ್ಟ್. ಇದನ್ನ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ ಇದು. 23
AG is directed accept notice for response 1 to 4.
Notification
Since it
dated
is
23
contended by the learned counsel for the petitioner that the issue involved in this petition is squarely covered by a judgment of a coordinate bench of this court in WP number 107875 of 2023. The learned AG is directed to secure immediate instructions. List on yavat
ಎನಿ ಡೇಟ್, ನಾಳೆ ನಾಡ್ದು ಯಾವ್ದು ಹಾಕಿದ್ರು ಮಂಡೇ
10 days ಬಿಟ್ಟು ಕೊಡಿ.
ಎನಿ ಡೇಟ್.
32. Sandesh Kumar, yeah.
My lords, in this matter, my lords, the last case, Honorable Court directed, extended the interim order, my lords, but it is not reflected in the order sheet, my lords. Interim order, how soon? Serial number 6 in, and 13/8/2000. ಯಾಕೆ ಇದು extend ಮಾಡಿಲ್ಲ? The learned counsel for the petitioner submits that this court had granted interim order on 37/2024. And the same was extended on 13/8/2024, but inadvertently is not shown in the order sheet. Next, since this court had granted an interim order dated so and so, the same deserved to be extended. At the time, the extended on 13/8/2024 when the matter was listed. Hence, the interim order dated so and so is extended in the next date of hearing. List on date code. Password then ಹೇಳಿದ್ರಲ್ಲ. Mr. Somshekar, huh? List number 2 ನಲ್ಲ. Number 2 ನಲ್ಲಿ ಏನಿದೆ? ಆಯ್ತು ತಾಳಿ. ಹಾ. Somshekar, Vijay Kumar.
Yes, madam.
Yes, sir. What is it? ಎರಡು ಕೇಸ್ ಇದೆ. ಕೊಡಿ ಇನ್ನೊಂದು ಫೋಟೋ ಇದೆ ವಿಜಯ್ ಕುಮಾರ್. ಎಸ್ ಸರ್. ಸರ್ ಶುರು ಮಾಡಿ. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ನೀವು.
ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
My lord, I argued the matter, it was for respondent to argue, my lord. If you last wants, I will repeat, my lord, my arguments.
Sorry.
My lord?
After petitioner, learned for respondent movement WP number. Vijay Kumar. ಏನ್ ಕೇಸ್ ಹೇಳ್ಬಿಡಿ ಸರ್ ಒಂದ್ಸತಿ.
Yes, my lord. My lord, there were 21 charges. A charge sheet was issued, page 17. Containing 21 charges, my lord.
Yes.
Then we appointed page 97, my lord, and appointed the inquiry officer, page 97, in respect of all the 21 charges. Then page 102 may kindly be seen, my lord.
Yes.
Before this honorable court, we stated that out of 21 charges, at page 104, my lord.
Yes, yes.
In the middle, my lord.
Yes, sir. What is
The petition itself has classified 21, of which 8 even according to the petitioner would be covered under sub-rule 2 of rule 28, and it would be competent for the director alone initiate the disciplinary inquiry and would submit it would not be adverse to deleting the said 8 charges, which according to the learned senior advocate would be charges in respect of which a director. Then page 105, para 4, my lord. This is a question which can be addressed by the scope, which cannot be addressed, as it would require findings of fact and an examination of the charges themselves. It is therefore open to the respondent number 4 to raise any such objection before the inquiry officer, who would be competent to examine whether the charges are such that which only the director would be competent to initiate disciplinary proceedings and to pass appropriate order. With this direction, the petition is disposed of while the inquiry officer shall delete the aforesaid 8 charges in respect of which only director can initiate the disciplinary proceedings.
Lord, sorry to interrupt, Lord. May I seek for password, Lord, because my learned friend, my senior friend is arguing the matter. I'm not seeking an adjournment. We are ready in the matter. Lord. Senior is held up in court.
ನೀವಿಲ್ಲ ಅಂತ ಅವ್ರು ತಿರ್ಗಾ ಇನ್ನೊಂದ್ಸತಿ ಶುರು ಮಾಡಿ ಅಂತ ಅಂದೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Only requesting to take back 230 minutes because
230.
ಅಲ್ಲ ನನಗೆ court all 3 ಅಲ್ಲಿ
We'll take up other matters, all parted ಆಗ್ಲಿ.
I am not seeking an adjournment. He's on his legs, Lord, I am requesting.
Password.
Yes, ma'am.
Serial number 2, Parthasarathy MS.
Parthasarathy.
Lords, there are 3 matters.
Narendra Gowda.
Lords, the first matter, my lords, would be, my lords, the petition filed by, my lords, the other side in WP 10811 of 2012. Lords, what happened, Lord?
WP number?
That is 2.1, 10811 of 2012. Lord, the issue is this. I was, my lords, appointed as a teacher, my lords, in the year 91-92 in the, my lords, petitioner institution in 10811. My lords, I discharged the duties for about 4 years. I was, my lords, removed from service, which I challenged before the Education Appellate Tribunal. Tribunal allows my appeal, finding that I am not the temporary employee as contended by the other side. However, my lords, at the time of reinstatement, my lords, according to me, my lords, they take a letter forcibly, my lords, insertion can be seen, my lords, in the letter, saying that you are appointed as a Hangami Shikshaka, that is temporary. My lords, they again, my lords, try to relieve me of my duties. My lords, prefer an appeal before, my lords, I was not relieved, I prefer an appeal before the tribunal. Say they have reduced my ranking from that of a permanent teacher to that of a temporary teacher. My appeal is dismissed, my lords, for certain reasons. I prefer, my lords, writ petition. Writ petition is also dismissed, not in both the cases, my lords, how there is variation, my lords, I would point out. Afterwards, my lord, the management ensures that I am relieved. I prefer an appeal before the, my lords, the director, my lords, the appellate authority. Seek for certain directions because they come with a notification for appointment.
Yes.
Certain directions are issued. One of the directions which is issued was that I should be continued in the institution and I should be paid the salary in accordance with this.
Yes.
That order is challenged, my lords, in 10811. Unfortunately, my lords, stay order was granted, my lord, before, my lords, before issuance of, or I received the notice. On the basis of that, I was relieved. My lords, I appeared before the Zonal Court, contested the matter. And I also said that the observation, what they have been making throughout, that I am a temporary teacher is not correct. And in those circumstances, my lords, I was permitted to file a review of the order, my lords, of the authority. Review was preferred. Review was, my lords, ultimately, my lords, as I had to get the direction issued, not complied, filed a complaint. Ultimately, my lord, the cryptic order was passed saying that no grounds to entertain, review dismissed, my lords, by the authority. In such circumstances, my lord, challenging that order and, my lord, seeking for, my lords, review of a writ petition, my lord, the order of the writ petition passed according to me, my lords, by mistake of law, without, my lords, looking into, my lord, the factual aspects. My lords, I have preferred, my lords, the second writ petition, that is, my lords, WP 28495 of 2014. 28495 of 2014. Thereafter, in the same post, in respect of the post, my lords, where I was working, another candidate was appointed and his appointment, my lords, was admitted to grants. That is, my lords, is in challenge in WP 57103 of 2014. As such, my lord, there are 3 matters. Lord, it's a fact that, my lords, when the matter was before this honorable court, WP 10811 of 2012 was in fact dismissed for default for my lords not complying with the directions issued by this honorable court as well back on 8/1/2021. 2018, I'm sorry. Recall application was made on 8/1/2021, lords, that was considered and accepted, restored to file. Lords, it's a fact that, lords, all along, I was insisting for, lords, a hearing. There was, lords, in the meanwhile, there was a proposal for settlement. I said, these are the, this is the amount which I'll be entitled because I already superannuated as on today. My lords, the fact, my lords, that took time. My lords, they did not respond. I said, I'll go on with the argument. My lords, I have been always, my lords, insisting for argument. Unfortunately, my lords, yesterday, my lords, it appeared, my lords, considering my absence, my lord, this honorable court said, my lords, that I have to pay cost. My lords, I have paid the cost also. Fact remains that, my lord, it is only because of the other side.
Somebody has to argue if.
My lords, I understand. My lords,
2012
that is what I am trying to say. I have been insisting, my lords, during the pendency of writ petition, I am kept out of my employment. Now I have superannuated. My lord, the issue, my lords, is this. My lords, if I am permitted to take, my lords, the first writ petition, my lords, which
anyway, the third writ petition has only become academic now. Because the salary grant which is granted to another person.
That's, my lords, I would say, my lords, that may not be so. My lords, for the reason, my lords, if for any purpose, my lord, that appointment is held to be illegal. Question arises would be whether I'll be entitled for.
See, there's some, the government will have to admit you for salary grant.
That is only that is only when, my lords, the management, my lord, submits my name.
So therefore, because you're retired now, there's no question of granting any sanction.
Lord, according to me, my lords, it can be done. Lords, my lords, I would substantiate, my lords. Let me deal, my lords, with each lords, petitions which are there before the school. My lords, may have a look at, my lords, the writ petition filed by the management, that is 10811. Lord, what the authorities said is, my lords, therefore, my lords, your lordship's consideration.
Not really. And I'm just going to buy an extra thing of the same that.
My lords, page number 27. Annexure E. Annexure E, my lords, page number 27.
29.
I'm sorry. It is Nandrali 27 ಅಂತ. ಅದರಲ್ಲಿ internal page 4 ಬಂದ್ರೆ ತಾವು. What the authority says is, appeal is partially allowed. Memo dated 31/3/2010 passed by the respondent number 2 is set aside. Direct respondent on management to maintain status quo with regard to the services of the appellant. Respondent number 2 management is directed to give pay as per so and so.
The order passed to the appellate director.
Now the order passed by the my lords, director. My lords, certain observations are made, my lords, in the order.
Please read.
Which actually, my lords, is hurting me. If your lordships kindly see, my lords, page number 29, my lords. In that, my lords, the authority, my lords, extracts, my lords, the contentions from the pleadings. Lords, I'll go to the last paragraph. Having these facts and the honorable court's judgments into consideration, the appellant's case has to be viewed. Two questions need to be answered: whether he should be given consequential benefits on salary, which is notional, and secondly, whether his services should be regularized. The consequential benefits on notional salary could not be given because the appointment is temporary and the appellant has worked on a consolidated salary. Lords, I'm hurt, lords, because of this observation being made, lords, by the courts, lords, by the management every time. That's the reason, my lord, the second petition was filed. My lords, I'll substantiate, my lords, how it is, my lords, how I am justified.
No, but where is the order passed for this court?
My lords,
Where is the order?
my lords, if your lordships take, my lord, the second petition, 28495.
What is annexure B in this petition?
Annexure B, my lord. Annexure B, my lords, was, annexure A was my lords, the original order of the tribunal in first appeal. That is EAT number 8 of 1995, which came to be allowed. Lords, what is annexed to, lords, as annexure B is the order passed on, lords, second appeal preferred before the Education Appellate Tribunal. They are not, lords, one and the same. ಮೊದಲು ನಾನು 88 ಹಾಕ್ತೇನೆ
12 or 2002.
Correct. That's what, my lords, I'm trying to say. If lordships kindly take my writ petition 28495 of 2014. ಅದ್ರಲ್ಲಿ 2 ಆರ್ಡರ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. If you lordships kindly come to my lords annexure M, page number 56.
Yes.
My lords, is the first appeal, my lords, I preferred. If you lordships kindly see, my lords, page number 56, first paragraph itself. The appeal filed under section 8 of the Karnataka Private Education Institutions Act is directed against the orders dated 10/4/1995, wherein the second respondent management had passed an order of dismissal on the appellant from services as a teacher, and the appellant urges the following amongst other grounds. That was as on 10/4/1995, because date becomes relevant for the reason notes from 1/6/1995, the Karnataka Education Act, my lords, came into force. The position of law, my lords, after 1/6/1995 is different, my lords, earlier compared to, my lords, what was there earlier. Earlier, my lords, it was in the section 8. In respect of, my lords, service conditions, my lords, I could have approached the Education Appellate Tribunal. Whereas, my lords, after the Education Act came into force.
Anyway, 10/4/1995 is the order passed.
My lords, first order of, my lords, removal, which was challenged.
Yes.
Hearing my lords, my appeal, if lords kindly come to, my lords, page number 61. Para 13, my lords. What the EIT says is, in view of the statutory provisions, it is clear that the appellant had not been appointed for a period of less than 3 months or as a part-time employee, as could be seen from the order of appointment. This document also shows that, as stated earlier, he had been appointed as assistant teacher arts for the year 91-92 and continued so in the said capacity for 3 more subsequent years till 1994-95. As could be seen from the certificate issued by the headmaster on 6/7/1995. From these, it is clear that the appellant had not been appointed either for a period less than 3 months or as a part-time employee, so as to attract Rule 9, in which event the management had all the right to terminate the service without assigning any reasons. This is not the situation in the case on hand. The appellant, who had been working as a teacher for nearly 4 years, has been discharged from service, as could be seen from the order impugned under the appeal dated 10/4/1995, stating that he had been a temporary teacher. The Act or the rules does not make any provision in respect of temporary employee, but Rule 9 states only to the effect that if a person is employed for a period less than 3 months or a part-time employee, his services could be terminated without assigning any reason. Having regard to the facts and circumstances, and in view of the fact that the appellant had served in the capacity as assistant teacher in the respondent institution for 4 years, in my opinion, it cannot be stated that the appellant had been appointed only as a part-time teacher or for a period not exceeding 3 months, so as to attract Rule 9. From these, it is clear that the respondent management cannot take shelter under Rule 9 and substantiate the order impugned. Admittedly, the respondents have not participated in the proceedings and have not resisted the appeal at all. It is needless to say that the respondents have not produced any documents before the tribunal to show the contrary. Moreover, from the material on record, it is seen that nothing has been placed on record by the respondent to show that any inquiry had been preceded before the impeachment. Categorical finding to the effect that I am a regular employee and that, my lords, no inquiry, termination from service. What happened, my lords, after this order was passed? My lord, because, my lords, I sought for, my lords, setting aside the order of termination.
Yes.
The tribunal, my lords, restricted itself to that prayer without, my lords, saying that you will be reinstated or otherwise. My lords, technically or, my lords, legally, when, my lords, an order of termination is set aside, consequent, my lords, has to follow. My lords, I was required to be reinstated. If your lordships kindly see, my lords, what happened thereafter was, my lords, the management takes a letter from me, my lords, which I have produced, my lords, before this honorable court. Annexure R, my lords, page number 99. The original, my lords, type copy is also provided, but original, my lords, requires some consideration.
Yes.
My lords, what I say is Mysuru Jilla Nyayalaya EIT 8/95 ಆದೇಶ. I refer to that. 3/4/2001 ರೀತಿಯ ಸಹಶಿಕ್ಷಕ ಹುದ್ದೆ ನೀಡುವ ಬಗ್ಗೆ ಏನಾಗುತ್ತೆ, I give a representation saying I should be reinstated. But what the my lords, I am asked by the secretary is to add, my lords, what is at the end. Your lords can see, my lords, there is a overrating. What do you mean? It is crashed and lords written again and again.
ಇದು ಯಾರ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆ?
ನನ್ನ ಕೇಸ್ ನನ್ನ ಬಲವಂತ ಬರ್ಸಿದ್ರು ಅಂತಾನೆ.
First of all, ಯಾರ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅಂತ ಹೇಳಿ.
ಅಂತೆ, I mean, there is no dispute. My case is that I was forced to write this. If your lordships kindly see, my lord, the last sentence, ಇಲ್ಲಿ ಪ್ರತಿಸುತ್ತೇನೆ ಅಂತ ಹೇಳಿ, ಇಲ್ಲಿ ನಾನು ಹಂಗಾಮಿ ಶಿಕ್ಷಕನಾಗಿ ಅಂತಾನು ಇನ್ಸರ್ಟ್ ಮಾಡಿಸ್ತಾರೆ. Lords, this letter is taken from me. My lords, I am reinstated, my lords, allowed to work. Again, my lords, they make an effort, my lords, to relieve me, my lords, from my duties. My lords, what happens is, my lords, I file an appeal, another appeal, my lords, before the Education Appellate Tribunal. My lords, which according to me, my lords, as I submitted to your lordships, by then, my lords, the Karnataka Education Act had come into force. Section 8, my lords, of the 75 Act, my lords, said in respect of service conditions. 94 only insofar as dismissal, removal, and reduction rank.
92 or 94?
Section 94 of the 1983 Act. My lord, I say that, my lords, see, there is a reduction in rank insofar as my case is concerned. Since though I was a regular employee, I have been changed as a temporary employee, which is not correct, is the contention taken. My lord, according to me, my lords, with great respects, I should not have preferred this appeal, and this appeal was not maintainable at all, because the change of, in fact, my lords, I'll show, my lord, yes, it is an order which is executable. My lord, there is no different, my lords, dispute about it. The tribunal also says it's an executable. I should have executed the earlier order. My lords, I'll read the order, my lords, and I point out. But what happens is, my lord, the tribunal, my lords, does not say whether that amounts to removal or otherwise. But what the tribunal holds, if your lordships kindly see, my lords, its reasoning starts on, my lords, page number 72. If I'm permitted, my lords.
Yes.
From the middle, my lords.
Let us see what was challenged before the tribunal in this case.
My lords, may have a look at, my lords, the
Section 94.
Section 94, because of the Education Act.
So what was challenged?
The facts relating to the appeal, as stated by the appellant, are as under. The appellant was appointed as a teacher in Gurumaleshwara Sarvajanika High School, which was under the management of Sri Gurumaleshwara Swamiji Vidya Samsthe of Madarahalli, and it was later on taken over by the Grama Vidya Sangha T. Narsipur. As per the orders of the Commissioner of Public Instruction dated 29/12/1994, the permanent staff of Sri Gurumaleshwara Swamiji Vidya Samsthe of Madarahalli are also directed to be absorbed by the Grama Vidya Sangha T. Narsipur. Accordingly, the appellant was also observed.
Then what happened after this?
My lords, if lordships come to, my lords, the reasoning part of the contentions, page number 73, my lord.
Yes.
Documents, my lords, are considered. My lords, if lordships, my lords, in the middle, my lord, it starts with the respondents have not seriously disputed the fact that the appellant had preferred an appeal. Page number 73 nalli. Middle, your lordships would get it, my lords. It starts with, I will not, my lords, trouble the instrument, my lords, quote by reading the entire thing. It starts from, my lord, the respondents have not seriously disputed the fact that the appellant had filed an appeal before this court in 88 of 95 against these very respondents, and the said appeal came to be allowed by an order dated 3/4/2001. A certified copy of the said order is produced at Exhibit P2. As could be seen from Exhibit P2, this court observed that the appellant had been appointed as assistant teacher in arts for the year 91-92 and was directed to report for duty on 25/9/1991. This court also observed that the copy of the letter dated 29/12/94 issued by the Director of Higher Education shows that the second respondent has been taken over by the first respondent. This court has also observed that the appellant has placed on record the certificate issued by the headmaster dated 6/7/1995, stating that the appellant has been working as assistant teacher in arts for the year 91-92 and to 94-95, and that the appellant has also produced the order impugned dated 10/4/1995, issued by the headmaster to the effect that as per the instructions of the secretary of the first respondent institution, temporary teacher of the institution has been removed from services. Perusal of Exhibit P2 further indicates that this court, after considering the evidence placed on record by the parties, held that there is no circumstance to indicate that the appellant was appointed as a temporary teacher, and that the evidence on record establishes that the appellant has worked in the second respondent institution for nearly 4 years, and that the respondents have not produced any materials to show that the appellant was appointed as a part-time teacher or on a temporary basis for 3 months, and therefore this court held that the respondents cannot terminate the services of the appellant except in accordance with Section 6 of the Karnataka Private Education Institutions Act, which was holding the field at time. In that view of the matter, this court held that the order questioning the said appeal issued by the headmaster of the school on 10/4/1995, relieving the appellant from service is illegal and contrary to law, since no inquiry has been held against the appellant as required by law. The finding of this court in 8 of 95 clearly indicates that the appellant was not a temporary teacher and his services could not be terminated without holding inquiry as required by law. In that view of the matter, this court set aside the order passed by the headmaster, relieving the appellant from services. The said order has not been challenged by the respondents before any superior court. There is no dispute that the order question 8 of 95 had been passed after the institution was taken over by the first respondent, pursuant to the order of the Commissioner for Public Instruction dated 29/12/1994. It is not the case of the respondents that they have questioned the correctness of the orders by this court in 8 of 95. Therefore, the order passed in 8 of 95 is binding on the respondent. However, though this court set aside the order passed by the headmaster on 10/4/95, relieving the appellant from services, this court did not grant any further relief of reinstatement or monitor benefit. This court is, in the course of the order, observed that the appellant has not sought for any such relief, and therefore no such relief could be granted. It is not the case of the appellant that pursuant to the order passed by this court in 8 of 95, the appellant was reinstated by the respondent as a permanent teacher. Notes, I'll pass here for a moment. Notes, I showed to your lordships the document. Subject is seeking for reinstatement in pursuance of the directions. Notes. Admittedly, there is an insertion. Lord, that is not.
Insertion is done in your hand.
Milord, that is, Milord, there is no dispute about it. What I'm trying to say is the approach of, Milord, the finding of the tribunal in 8/12 is, Milord's, not, Milord's, correct. To the extent that, Milord's, it is not in pursuance of that.
Correct, Mr.
Milord's, I'll show Milord's.
No, first order, it was still executable.
Yes, Milord, that is what, no, that is what, Milord's, I'm trying to, Milord's, put forth. Milords, I'll skip Milords other things, Milords, if Lords can to Milords, page number 76. Why, Milords, I'm seeking from Milords, Milords, yes, admittedly, this was challenged in the writ petition, which was dismissed by this honorable court. But there also, Milords, Milords, with great respects, mistakes have occurred, Milords.
Correct. Please come to page number 78.
Milords, Milords, I'll read Milords, the next page, 76, Milords, and I'll, Milords, page number 76, if your lordships kindly see, Milords.
I read that 76, 77 ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ನಾನು.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ ಪೇಜ್ ನಂಬರ್ 76 ಏನಕ್ಕೆ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ. What the tribunal code or my lords,
I have read it, Mr. No doubt the appellant has contended that he was supposed to give such letters, however such contentions cannot be accepted.
I'll come to my lord 77, my lord, because I have to say, if your lordships are right, my lords, the same observations here. My lords, fourth sentence from lords from the top. As there was no order passed by the court directing the respondent to reinstate the appellant as a permanent teacher, there was no obligation on the part of the respondent to appoint appellant as a permanent teacher. My lord, this is wrong, contrary, my lords, to the finding. Because there it is clearly said he was a permanent teacher. Under these circumstances, it cannot be said that the appellant was appointed as a permanent teacher against a clear vacancy. If according to the appellant, he is a permanent teacher and he has a right of reinstatement pursuant to the orders passed by this court in 88 of 95, he could have as well execute the said order, and in that event, it is not open for the appellant again to come before this court with another appeal contending that he has been reduced in rank. When this finding is clearly recorded, saying it is executable order, and I should have filed for execution, tribunal proceeds further, which is, according to me, lords, was not correct.
Please go to page number 78. That is what I am requesting.
Yes, my lord. What it says.
Read the fourth sentence.
However, it is necessary to note that if according to the appellant, he has some right flowing from the order passed in so and so, he is at liberty to take any steps as open to him under law. Therefore, I hold that the appellant is not entitled for any relief sought in this appeal.
So therefore, did you execute the order?
Correct, my lord. That is, my lords, what I am trying to say. My lords, thereafter, my lords, my lord, there is, my lords, mistake from my lords, all the sides.
Mistake from all the sides.
Allah,
Mistake is
in
from
fact, my lords, my lords my lords, because there is a finding that I was not
the
appointed.
mistake is upon the lawyer who advised this man.
Correct, my lords.
But
My
he
lords,
should have-
ultimately, my lords, I have to, my lords, take the responsibility because I was the party before the court. But fact is, my lord, the tribunal said you are not the permanent employee. Contrary to my lords, its own observations in Paras earlier, saying that in other appeal, it was observed that you are a permanent employee. Contrary to that, my lords, here statements are made.
ನೋಡಿ ಈಗ ಹಳೆ ಆರ್ಡರ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
That is, my lords, my lords, that's
Neither there ಗೆದ್ದು ಸೋತ್ರಿ ನೀವು.
highly, my lords, very unfortunate situation, my lords, in some
ಗೆದ್ದು
this case is
ಸೋತ್ರಿ
concerned.
ನೀವು.
My lord, that's what, my lords, in fact, my lords, that was, I tried to work out, my lords, earlier. I said, anyway, when things happened. My lords, I have only bleak chance of, my lords, getting my appointment approved with aid. Also for the reason your lordships has pointed out now, that I have superannuated, my lords, apart from the other facts. That's why I said, please come with an offer. You tell me how much you will pay, I'll go out, I will close it.
ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಅದೇ ಅದು ಎಲ್ಲ
Last time
ಸರ್ಕಾರದವರೆಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ನವ್ರು, ನಾನು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರು ಕೇಳಿದೆ, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರು ಉತ್ತರನೇ ಕೊಡ್ಲಿಲ್ಲ ನನಗೆ.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ದೇ ಸೆಡ್ ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ನಮ್ಮ ಹತ್ರ ಏನಿಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ.
Lord, if that is so, my lords, I have to take the order from this court.
Yes.
My lords, according to me, my lords, the finding was correct. My lord, with great respects, my lords, when I preferred a writ petition, this court, my lords, could have said that, my lords, you have to file an execution. Page number 95, my lords, annexure Q. Annexure Q, page number 95, my lords. WP 22560 of 2005. My lords, para 4, reference is made to 88 of 95. My lords, I'll not read, my lords, what is there in page number 97. If lordships come to, my lords, page number 4. In that, my lords, starts with be that as it may. The petitioner admits in the subsequent judgment in 88 of 95, my lords, it is not subsequent. 12 is subsequent. He gave a letter requesting the respondent to appoint him on a temporary basis. Accordingly, the petitioner had been appointed as temporary teacher with effect from 31/12/2001. Thus, the petitioner had accepted the judgment in 8 of 95. Lords, 8 of 95 is where I am said I am a permanent teacher. 12 of 95, my lords, is a different one where it goes, my lord, what I read to your lordship just now. My lord, further it is said, under the circumstances, the petitioner is not entitled for writ of mandamus, directing the response to reinstate him and pay the consequential benefits arising out of judgment in 8 of 95. There, my lords, in fact, I had sought for a direction to the effect that what is the order in the other appeal has to be implemented. The prayer in 80 number 12 of 2002 is to direct the response to appoint the petitioner as a permanent teacher and to pay the salaries applicable to the present post. The tribunal in its judgment in 80/12 of 2002 noticed the fact that very appointment of the petitioner on 31/12/2001 was on temporary basis and on consolidated payment. Further, it is noticed that during the pendency of 80/12 of 2002, the petitioner voluntarily left the services of the respondent. Under these circumstances, the impugned order passed by the tribunal in 80/12 of 2002 is in accordance with it. Notes, with great respects, lords, what was the prayer was that I was seeking for a direction in pursuance of 88 of 90. This court, my lord, said that 88 of 95, no direction for you, and there is no finding that you are a permanent employee. Management never appointed you as a permanent, my lord, completely contrary, my lords, to the material on record, my lords. I would with great respect say that there is a mistake for the reason that further, when I, my lords, though I was continued in the institution, the annexure, yes, my lords, came to be passed, came to issued by the management. Notification calling for appointments in the institution. At that time, my lords, I preferred the appeal before the authority. The authority, my lords, at that juncture, my lords, has passed an order saying that whatever it is, being because there was a finding of my lords, the appeal in 80/12 of my lords, 2002, and that the order of this honorable court that you are a temporary employee and you should be continued. But I will give protection to the extent that your services will be continued and you will be paid the salary as in the rules. What is to be paid in respect of an unrated teacher? That is at least the minimum of the basic pay, not the regular pay scale.
Yes.
My lord, that order, my lord, is challenged by the management in the other petition. There, my lords, the order is passed, which is challenging, not the.
ಏನು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವ್ರು ಏನಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಮಾಡಿಸ್ತೀರಾ ಹೆಂಗೆ?
ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಕೈಂಡ್ ಇದು ಸ್ಕೂಲು
ನೀವೇ ಹೇಳ್ಬೇಡಿ, ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ.
ಅಲ್ಲಲ್ಲ ಹಾಗಲ್ಲ, ಟೆಂಪ್ರರಿ ಆಗಿ ಇವನ್ ಮೇಲೆ ಇನ್ 19 ದೇರ್ ವಾಸ್ EAT was filed and it was rejected. ಹಾಗಾಗಿ ಅಲ್ಲ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಇನ್ಕಮ್ ಮೇಲೆ ಸ್ಕೂಲು ಒಂದು ಹಳ್ಳಿನಲ್ಲಿ ಇರೋದು.
ಈಗ ಇದೇನಾದ್ರು ನಾವು ಅಲೋ ಮಾಡಿದ್ರೆ ಜೈಲ್ಗೆ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. ಕಾಸು ಕೊಡಕ್ಕಾಗದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಟು ಜೈಲ್.
ಅಲ್ಲ ಅದು ನಾನೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ, ನಾನು ಇರೋದು
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಸೋಗಿದ್ರೆ
ನನಗೆ ಮೆಟೀರಿಯಲ್ಸ್ ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ. ಇಫ್ ದಿಸ್ ಅನುಭವ ಕೋರ್ಟ್ ಇಸ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ದಿಸ್ ಇನ್ಕಮ್ ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಎನಿ ಅವಾರ್ಡ್. ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಅಪ್ ಟು ಡೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಫೈಲ್ ಆಲ್ ದೋಸ್ ಆಡಿಟ್ ರಿಪೋರ್ಟ್.
ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್ ಏನ್ ತೋರಿಸ, ಬಿಕಾಸ್ ನೌ ಇಟ್ ಇಸ್ ಅನ್ ಏಡೆಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಗೌರ್ಮೆಂಟ್ ಸ್ಯಾಲರಿ ಹೋಗುತ್ತೆ.
ಮಾವ ಹೇಳಿದಂಗೆ ಫೋನ್ ಮಾಡುವಾಗ ಕಾಗದ ಎತ್ತಿದ್ದಾಳೆ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಓಕೆ, ಬಟ್ ದೆನ್ now until your appointment is approved, now it can't be approved, so it has to be paid through their nose.
Yes, my lord. That's why, my lords, I gave them a calculation. I said this is going to be the salary as per the my lords orders of the director. You tell me how much you will pay. For that they say we'll pay nothing. This is where, my lord, the difficulty is.
Yes.
My lords,
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಎಂಟೈರ್
Income tax ಸರಿ sir.
ದುಡ್ಡಿಲ್ಲ. ಲಕ್ಷ್ಮಿ ಖಂಡಿಸಿ, ನಾನು ಬೆಂಗಳೂರು ಸ್ಕೂಲ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಏನು ದುಡ್ಡು ಮಾಡ್ತಾರೇನೋ?
ಎಲ್ಲಾ ಕಡೆ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲಿ ಇಲ್ಲಿಲ್ಲ.
ಏನ್ ಇಲ್ಲಿಲ್ಲ ನೀವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿರೋ ಕಡೆ ನಾವು ಮಾಡಿರೋದು.
ಅಲ್ಲಿ
ವಿ ನೋ ಹೌ ದಿಸ್
28 ಅಲ್ಲಿ ನೋಡಿ ಅದು ಅವರು
ಸರ್ ಒಂದು ಕೆಲ್ಸಕ್ಕೆ ಸೇರಿಸ್ಕೋಬೇಕು ಅಂದ್ರೆ ದುಡ್ಡು ತಗೋತಾರೆ, ಸ್ಯಾಲರಿ ಗ್ರಾಂಟ್ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ದುಡ್ಡು ತಗೋತಾರೆ.
ಅಲ್ಲಿ ಇರ್ಬೋದೇನೋ,
ಎಲ್ಲಾ ಕರ್ನಾಟಕದಲ್ಲಿ ನಡೀತಿರೋದು.
ಅಲ್ಲಿ ಇರ್ಬೋದು. ನಾನು
ನೀವು ಕಲಬುರ್ಗಿಗೆ ಬನ್ನಿ, ಇನ್ನ ಬಿಲ್ಡಿಂಗ್ ಇರಲ್ಲ ಬಟ್ ಸ್ಕೂಲ್ ನಡೀತಾ ಇರ್ತದೆ.
ಇಲ್ಲ, ಇದು ಹಾಗಲ್ಲ, ಇದು
ನಡೆಯುತ್ತೆ ಸರ್, ನಮ್ ದೇಶದಲ್ಲಿ ಎಲ್ಲ ನಡೆಯಿಲ್ಲ.
ಇನ್ಕಮ್ ನನ್ನ ಪ್ರಕಾರ ಸ್ಕೂಲ್ ನಲ್ಲಿ ಇಲ್ಲ ಇನ್ಕಮ್.
ಬಟ್ ದೆನ್ ಇಫ್ ಸಿ
ಅಲ್ಲ, ಅವ್ರು ಕೇಳಿರೋ ಸ್ಯಾಲ್ರಿ ಕಿತ್ಕೊಡಿದ್ರೆ ಸ್ಕೂಲ್ ಮಾರಿದ್ರು ಆ ದುಡ್ಡು ಬರೋದಿಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ, EAT ಆರ್ಡರ್ ಸೇರ್ಸ್ ಇಸ್ ಎ ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯಿ ಅಂತ ಒಂದ್ಸತಿ ಆಯ್ತು.
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಆಗಿದೆ, ಯಾಕಾಗಿದೆ?
ಇಲ್ಲ, ಇಲ್ಲ,
ಆಗಿದೆ.
ಇಲ್ಲ, ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಆಗಿದೆ ಸರ್. EAT 8 ಅಲ್ಲ ಇದೆ ನೋಡಿ.
ಅದೇನು ಹೇಳ್ತೀನಿ.
EAT 8 of 95 ಅಲ್ಲಿ court has held he is a regular employee.
Page 21 minute of my writ petition.
Both.
But the appellant has merely prayed for setting aside the order impugned and for allowing the appeal. It is pertinent to see that by well settled precedent law, it is clear that the courts of law function in an adversary system of administrative justice, strictly in accordance with law, and the tribunal has been empowered to pass orders as contemplated in section 10 of the act. And in view of the prayer of the appellant, the tribunal is of the opinion that it would not be proper to grant any other relief other than the one claimed by the appellant. Possibly, if the appellant had been interested in reinstatement or for claim of back wages, the appellant could have come out with such a case. In the absence of the appellant coming out with such a case, in my opinion, it would not be proper for this tribunal to go off the track and assume jurisdiction and grant any other relief which has not been prayed for.
ಈ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಡಿಗ್ರಿನಲ್ಲಿ
ಆಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಅಲ್ಲಲ್ಲ, ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಡಿಗ್ರಿನಲ್ಲಿ ಬರೀ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಕೇಳಿರ್ತೀರಿ, ಪೊಸಿಷನ್ ಕೇಳಿರಲ್ಲ.
ನಿಜ, ಅದು ಪ್ರಾವಿಷನ್ ಸೆಕ್ಷನ್ 16C ನಲ್ಲಿ ಇದೆ, ಅದನ್ನ ತಾವು ಮಾಡಬಹುದು.
ಆಮೇಲೆ 16C ಅಲ್ಲ ಸರ್, ಪೊಸಿಷನ್ ಕೇಳಿರಲ್ಲ,
ಕೇಳಿರುತ್ತಿಲ್ಲ.
ಕೊಡ್ಸಿ ಪೊಸಿಷನ್ ಕೊಡ್ಸಿ ಅಂತ ಕೇಳಿರಲ್ಲ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕೋರ್ಟ್ ಪವರ್,
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದೇ ಆರ್ ಎಂಪವರ್ಡ್.
ಸೊ ಹಿ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ದಿಸ್ ಆರ್ಡರ್.
ಅಲ್ಲ, ಆಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೋದು, ರಿಟ್ ಪಿಟಿಷನ್
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಸರ್ ಅದು. ನಿಮ್ಗೆ ಐ ಥಿಂಕ್ ಯು ಆರ್ ಮಿಸ್ಸಿಂಗ್ ದ ಪಾಯಿಂಟ್. ಸರಿಗೆ ಬ್ರೀಫ್ ಮಾಡಿಲ್ಲ ನಿಮ್ಗೆ.
Annexure B ಮೇಲೆ
The briefing council has not properly briefed you. 95 ಒಂದು ಆರ್ಡರ್ ಇದೆ.
ಹೌದು.
ನೀವು ಹೇಳ್ತಿರೋದು 2007 ಆರ್ಡರ್ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು. 2001 ಆರ್ಡರ್ ಓದ್ತಾ ಇದ್ದೀರಾ.
ಹೌದು.
95 ಅಲ್ಲಿ it is already declared that he is a permanent employee. ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋವಾಗ ಒಂದು ಲೆಟರ್ ತಗೋತೀರಿ, ಟೆಂಪ್ರರಿ ಎಂಪ್ಲಾಯಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋತಿದ್ದೀನಿ ಅಂತ. ಟೆಂಪ್ರರಿ ಎಂಪ್ಲಾಯಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋತಾರೆ, ಕೆಲ್ಸಕ್ಕೆ ತಗೋತಾರೆ. Then he files one more EAT, that is this one, saying that my rank is reduced. This appeal is dismissed on the ground that ನೀನು ಅದನ್ನ execute ಮಾಡಬೇಕಾಗಿತ್ತು.
ಹೌದು.
ಇದನ್ನ dismiss ಮಾಡ್ತಾರೆ. That is confirmed in revision bench.
ಹೌದು.
So therefore, the fact that his appointment was declared to be a regular appointment is confirmed because ನೀವು ಅದನ್ನ EAT of 8 of 95 challenge ಮಾಡಲಿಲ್ಲ.
ಹೌದು. True, my lord.
So therefore, if that order has to be executed, if that order is to be executed, then ಏನಾಗುತ್ತೆ? 8 of 95 order execute ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ?
Can you see page 76 in WP number 28495? Page 75, my lord. Page 75, in the middle, my lord. This court in the course of the order, page 75. This court in the course of the order observed that the appellant has not sought for any such relief. Therefore, no such relief could be granted. It is not the case of the appellant that pursuant to the order passed by this court in EAT, the appellant was reinstated by the respondents as permanent teacher. On the other hand, it is the contention of the appellant that after this court disposed of this appeal, he issued a notice as per the original exhibit P1, calling upon the respondents to reinstate him in the post of permanent teacher and to pay all the monetary benefits. However, the appellant has not produced acknowledgements for having served the said notice. Nevertheless, the appellant has produced copy of letter dated 21/12/2001 written by him to the Honorary Secretary of the respondent seeking an opportunity to serve the institution as a temporary teacher. A copy of the said letter has been marked as Exhibit P3. Though in this letter, the appellant refers to the orders passed by the court in EAT number so and so, he seeks an opportunity to serve the institution as a temporary teacher. On the basis of this request, the Honorary Secretary of the first respondent has passed an order that the appellant has been appointed as a temporary teacher with effect from 31/12/2001, and he was asked to report for duty. He has also produced copy of the letter dated nil written by him to the Honorary Secretary of the first respondent as per Exhibit P4. In his letter, he has stated that his services have been utilized from 31/12/2001 to 24/2022 as assistant teacher, and thereafter he has been relieved from services, and therefore he has requested the Honorary Secretary to furnish him the reliever order. The appellant has also produced copy of the letter dated 1/6/2002 addressed to the Honorary Secretary of the first respondent institution requesting to provide him an opportunity to serve the institution as a temporary teacher during the academic year 2002 and 3. No doubt, the appellant has contended that he was forced to give such letters. However, such contentions cannot be accepted. When the appellant was armed with the order of this court passed in EAT 8 of 95, wherein this court has made certain observations with regard to the nature of his services in the respondent institution, and in fact, the order passed by the headmaster relieving him from duty has been set aside. There is no occasion for the appellant to give such letters as per Exhibit P3 and P4. If the appellant was forced to give such letters as a condition precedent to take him on duty, he could have refused and could have enforced the order passed by this court. Therefore, the evidence placed by the appellant itself clearly indicates that he was appointed in the respondent institution on 31/12/2001 as a temporary teacher. As there was no order passed by this court directing the respondent to reinstate the appellant as a permanent teacher, there was no obligation on the part of the respondent to appoint the appellant as a permanent teacher. Under these circumstances, it cannot be said that the appellant was appointed as a permanent teacher against a clear vacancy. If, according to the appellant, he is a permanent teacher and he has a right of reinstatement pursuant to the orders passed by this court in EAT 8 of 95, he could as well execute the said order, and in that event, it is not open to the appellant again come before this court with another appeal contending that he has been reduced in rank. The appellant has not produced any document to show that he was reinstated by the respondent institution pursuant to the orders passed by this court in EAT 8 of 95 as permanent teacher, and thereafter he has been reduced in rank as contended in his appeal. Therefore, I am of the considered view that the appellant was neither appointed as a permanent teacher against clear vacancy, nor he was reduced in rank. On the other hand, the evidence clearly establishes that after this court disposed of EAT 8 of 95, the appellant requested the respondent to give him an opportunity to work as a temporary teacher in the institution, and accordingly his services were utilized as a temporary teacher initially from 31/12/2001 to 24/2002, so and so. There is no.
ಆಯ್ತು ಸರ್, ಇವಾಗ 88 of 1995 ಆರ್ಡರ್ which is challenged in WP number 10811
ಹೌದು
of 2012.
ಹೌದು.
If this is upheld, this is dismissed, sorry.
8 of 95 notes was not
ಅದನ್ನೇ
challenged at all.
ನಾನು ಓದಿದ್ದು
What
ಇವಾಗ
is challenged in 10811?
ನಾನು ಫಸ್ಟ್
Notes
ಓದಿದ್ದು
that
88
after
of
that, my lords,
95.
the director
ಅದು ವಜಾ ಆಗಿತ್ತು.
considers and my lords passes the order, saying that I should be continued as a teacher, my lords, and I should be paid the salary in accordance with.
Like the appeal number 8 of 2010 ಎಲ್ಲಿದೆ?
Is the subject matter of WP Annexure B in my writ petition, my lord. 10811.
Yes, 8 of 2010. ಸರಿ, ಇವಾಗ ಇದು ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ ನಿಮ್ದು?
ಏನು?
Suppose if 10811 of 2012 is dismissed, what happens?
Num writ petition. ಆದರೆ then I may have to pay salary in terms of the government order. According to my lord, the second respondent to give salary in terms of these rules ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈ rules is applicable only insofar as the private unaided primary and secondary and pre-university education institution. This is an aided institution. It is not applicable ಅಂತ ತಮ್ಮ ಮುಂದೆ ನನ್ನ ವಾದ.
Right. Suppose we assume, you assume for the sake of argument that the order passed with the E18 8 of 1995 is upheld by this court and we direct reinstate. ಏನಾಗುತ್ತೆ?
ಕೊಡ್ಬೇಕಾಗ್ತದೆ ತಾವು ಮಾಡಿರೋದು ಏನು?
ನಾನು ಹೇಳ್ತಿರೋದು. Because the fact is
ಫೈನಾನ್ಸಿಯಲ್ ಕಂಡೀಷನ್ ತುಂಬಾ ಪೂರ್ ಕಂಡೀಷನ್ ಇದೆ ಈಗಂತೂ. ಆಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಗೌರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ಸ್ಗೆ ಬರ್ತಾ ಇಲ್ಲ ಹುಡುಗರು. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಎಂಟೈರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಕೊಡ್ತೀನಿ.
ಮಾಡೋಣ ಸರ್, ದುಡ್ಡು ಕೊಡಂಗಿದ್ರೆ ಮಾತಾಡೋಣ, ದುಡ್ಡು ಕೊಡಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸೈಡ್ ಮಾಡೋಣ ಅಷ್ಟೇ. Don't want to pay, we'll decide.
And I will summon the secretary management. I will ask my calculator any day next week. ಅವ್ರು ಕೊಡೋದಕ್ಕೆ ನಂದೇನು ಅಬ್ಜೆ, I will try to persuade.
ಇದು ಮೊನ್ನೆ ಬಂದಿತ್ತಲ್ಲ, ಇದಾಗ್ಲೇ ಒಂದ್ಸತಿ ಕೇಳಿತ್ತಲ್ವ ಇದು?
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು what is the condition of my institution ಅದನ್ನು ಹಾಕಿದ್ದೀನಿ ನಾನು.
Sir, if you are willing to pay, then we'll consider that. If you are not willing to pay, we'll decide the case.
Ask my kindly, it is up to my lord.
Huh?
ಅಲ್ಲ, ನನ್ನ ಪ್ರಕಾರ ಕೊಡೋ ಪರಿಸ್ಥಿತಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. That is I can pass on the instructions that I have received.
ಆಯ್ತು, ಹಂಗಿದ್ರೆ then we'll allow this petition. ಏನಾಗುತ್ತೋ? Because that order, we are losing sight of one fact. The order dated the EAT 8 of 1995 order, it has not been challenged.
ನಾನು ಚಾಲೆಂಜ್
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ.
ನನ್ನ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಲ್ಲ.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ ಸರ್.
ನಾನು ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ ನಾನು. ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. Where was the need for me?
ಯಾಕೆ
ವಜಾ ಆಗಿದೆ ಅಷ್ಟೇನೆ.
ವಜೆ ಎಲ್ಲ ಆಗಿದೆ ಸರ್, ಅಲ್ಲೂ ಆಗಿದೆ ಸರ್. ಏನ್
ಅಲ್ಲೂ ಆಗಿದೆ? ವಾಟ್? ಹೌ?
The order setting aside is.
Has it given any, has it considered it as a permanent employee? No. Has it directed to pay the arrears of salary? No.
ನೀವೆಲ್ಲ ಸರಿ ಓದಿ, ಫೈಲ್ ಓದಿ.
ಅಲ್ಲಿ ನಾನು ಓದಿ ಹೇಳ್ತಾ ಇರೋದು.
ಅಲ್ಲ, ನೋಡಿ ಅದನ್ನು.
ಆಯ್ತು.
ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 11, ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಬನ್ನಿ, annexure A. Page 16 ಬನ್ನಿ, para 10.
From the materials and record, it is seen that the appellant has placed on record the order of appointment and the same source that that had been appointed as assistant teacher for the year 91-92, and the material record also shows that he had been serving in his set capacity for subsequent 3 academic years till 94-95. At this stage, it is necessary to place on record Section 2B of the Act, which Act defines the term employee as a person employed by a private education institution, either as teacher or in any other capacity. I also feel it necessary to place on record Rule 9 of the Private Education Institution Rules, which runs as follows. An employee appointed under Rule 6 may resign from service by giving 1 month's notice in writing to the appointing authority or 1 month's salary in lieu thereof. A copy of such notice shall be sent to the head of the department. The head of the department or a person authorized by him shall call the employee to appear before him for verifying the contents of the resignation noticed and shall forward it to the appointing authority for acceptance. If the resignation is found to be voluntary, the appointing authority shall not accept the resignation until the notice is forwarded to it by the head of the department. In view of the statutory provisions, it is clear that the appellant has not been appointed for a period of less than 3 months or as a part-time employee, as could be seen from the order of appointment. This document also shows that, as stated earlier, he had been appointed as assistant teacher in arts for the year 91-92 and continued to in the said capacity for 3 more subsequent years till 94-95, as could be seen from the service certificate issued by the headmaster on 6/7/95. From these, it is clear that the appellant has not been appointed either for a period less than 3 months or as a part-time employee, or so as to attract Rule 9, in which event the management had all the right to terminate services without assigning any reasons. That is not the situation on this on hand. The appellant, who had been working as a teacher for nearly 4 years, has been discharged from service, as could be seen from the other impugned order. The appeal date is so and so, stating that he had been a temporary teacher. The act or the rules does not make any provision in respect of temporary employee, but Rule 9 states only to the effect that if a person is employed for a period of less than 3 months or a part-time employee, his services could be terminated without assigning any reason. Having regard to the facts and circumstances, and in view of the fact that the appellant had not served in the capacity of-
Had not served.
Had served in the capacity of the assistant teacher in the respondent institution for 4 years. In my opinion, it cannot be stated that the appellant had been appointed only as a part-time teacher or for a period of not exceeding 3 months, so as to attract Rule 9. From these, it is clear that the respondent management cannot take shelter under the Rule 9 and substantiate the order impugned. Admittedly, the respondents have not participated in the proceedings and have not resisted the appeal at all. The needless to say that the respondents have not produced any documents before the tribunal to show the contrary. Moreover, from the material record, it is seen that nothing has been placed on record by respondents to show that any inquiry had preceded the impugned order. The statutory provision of Rule 8 enables an employee aggrieved by an order of management to come up with an appeal, being aggrieved by the order of dismissal or removal. From the tenor of the order impugned, it is clear that though it is stated that the appellant has been relieved from service, it has the legal effect of removal of the appellant from services of assistant teacher in respondent management, as rightly contended by the learned counsel for the appellant. At this stage, it is necessary to place on record that the provisions of Section 6 of the Act clearly lays down that no employee shall be dismissed or removed unless.
Therefore, the finding of the tribunal is that he could not have removed him.
Removed him.
Is because he is not a temporary employee. That is a finding. That finding is not challenged by you. That finding is not challenged by you. If that is the case, you are challenging an order passed on an appeal filed by him before the director in this writ petition. Suppose your writ petition is dismissed, then if I were to hold that this order is executable and that he can seek for reinstatement, which is consequential, what happens?
But the ultimate operative portion is dismissed. Since
Sir,
there is no relief.
sir, operative portion is allowed, sir. ನೀವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊ 2 ಅಪೀಲ್ ಇದೆ ಅದಕ್ಕೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೋತಿದ್ದೀರಿ.
Sorry, it is allowed.
This is allowed.
It is allowed, my lord.
ಮತ್ತೆ ಈ ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
ಅಲ್ಲ ಅಲೋಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ರಿಲೀಫ್ ಕೊಡ್ಲಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ದ್ರೆ ಇಟ್ ಇಸ್ ಎಕ್ಸಿಕ್ಯೂಟಬಲ್. He is a permanent employee then.
They were under the impression that since it has, there is
ಅದೇ
no.
ತಪ್ಪು, ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ. ಅದಕ್ಕೆ ಹೇಳ್ತೀವಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ವಿಲ್ ಬಿ ದಟ್ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಹಿಮ್ ಟು ಎಕ್ಸಿಕ್ಯೂಟ್ ದಿಸ್ ಆರ್ಡರ್.
Next week last weekend ದುಡ್ಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. I will try to pursue them.
ಎಲ್ಲಿ ನೀವು ಹೇಳಿ ಜೈಲಿಗೆ ಹೋಗ್ತೀರಾ ಅಂತ ಹೇಳಿ ತರ್ತಾರೆ ಎಲ್ಲಿಂದ ಆದರೂ. Yes. After hearing the learned counsel for the petitioner and the learned counsel for the respondent, learned senior counsel for the respondent management, comma, ಇದು WP number.
10811 ನಂದು.
After hearing the learned senior counsel for the petitioner in WP number 10811 ಅಲ್ಲಿ ಮಾಡಿ. After hearing the learned senior counsel for the petitioner and the counsel for the respondent, comma, this court felt that this is a fit case where the party should work out a settlement. The learned senior counsel for the petitioner sought time to secure instructions for an amicable settlement. List on yavat?
Next week, any date, next week.
Next Guruvara. Yes, all of them will come back at 2:30.
ಸರ್ ಯಾವ ಡೇಟ್ಗೆ ಹೋಯ್ತು ಸರ್ ಅದು? ಯಾವ ಡೇಟ್ಗೆ ಹೋಯ್ತು ಸರ್ ಅದು? ಸರ್ ಯಾವ ಡೇಟ್ಗೆ ಹೋಯ್ತು
ಸರ್?
ಇದು ಜಸ್ಟ್ ಗುರುವಾರ.
ಸರ್ ಈಗ ಬಂದ ನಂತರ 2:30 ಸ್ಟಾರ್ಟ್
ಹೇಳ್ಬಿಡ್ಬೇಕು ನೀವು ಸರ್ ಬದಿಗೆ ಒಂದು ಮೆಮೊ ಕೊಟ್ಟರು, ಡೇಟ್ ಕೊಟ್ಟಿಯಾರ ಅಂತ ಕೇಳಿ ಅಂದ.
Court officer? Court officer?
ಆನಂದ್ ಇಲ್ಲಿಲ್ಲ ಕೈ ಎತ್ತದು. Court officer. Court officer. ಅದು ಇದು
ಮ್ಯೂಟ್ ಮಾಡೀನ್ರಿ ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಬಿಡ್ರಿ ನೀವು ಹೊರಗೆ
The serial number 3 now. List 2. This was that matter where just Mr. Naganand appeared. CH Prashant. Yeah, facts here, at least facts are ಹೇಳಬೇಕಲ್ಲ ಯಾರಾದ್ರೂ 2012 mat. And give the facts at least. Learned counsel for the petitioner seeks time on the ground that the arguing counsel is otherwise engaged. List on date. Yaut, you pick up a date. Are you sure? Whichever date is convenient. List on next Wednesday, Friday. It's only on Fridays, sorry. These matters will come only on Fridays. Yes.
The petitioner has been, there has been termination proceedings indicated in terms of the, the new interim order transfer to date and
2024 matter, why should you take it up for B group, madam? Even 23 also, you look at the cause list, 2012, 14, 16. He's been removed from service. Apprehension. No, let him be removed. We'll consider it later. Serial number 42. Learned counsel for you are for the learned counsel for the petitioner seeks. Yaru. Learned counsel for the petitioner seeks time. List on. When do you want it? This time. Right.
My lords, list 2, my lords, serial number 5, my lords, kindly have it next week, my lords. I appear for respondents, my lords. List 2, serial
How
number
can
5.
you ask for adjournment, mister?
My lord, senior is on legs in court number 1, my lords.
Early, let him come.
Please, my lords.
Huh? ಆಯ್ತು ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ. Learned counsel for the respondent seeks time. List on. Entry ಮಾಡಿದ್ರೆ ನೋಡಿ, entry ಮಾಡಿದ್ರೆ extend. Huh? 83 ಯಾವ್ದಿದು? ಕಿರಣ್ ಕುಮಾರ್ ನಿನ್ನೆ ಏರ್ ಮಾಡಿತ್ತಲ್ಲ ಮಾಡಿ. ನೋ ಸಾರಿ, ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಯಾಕ್ರಿ ಹಿಂಗೆ? ನೋಡೋಣ, ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಯಾಕೆ ಹಿಂಗೆ ತೊಂದರೆ ಕೊಡ್ತೀರಾ? ಅರ್ಧ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ, ಅಲ್ಲ ಹೋಗ್ ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟ್ರ್.
Kalburgi bench matters for order serial number 1. SS Siri.
Sakri SS, sorry, SS Siri. Yeah, Mr. Mohammed Qayyum.
Muhammad Qayyum for respondent.
Mr. Mohammed Qayyum.
Shivakumar Siri. Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ sir. Shivakumar Siri. Sir, mute ಮಾಡ್ಕೊಂಡಿದ್ರಾ? ಸರ್ ಶಿವಕುಮಾರ್ ಸೀರಿ ಅವರೇ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
My lord, I am review petitioner, my lord.
ಅಲ್ಲ ಅದು ಕೈಯುಮ್ ಅವ್ರಿಗೆ ಇದು ಯಾಕೋ
ಅದೇ
ಬರ್ತಾ ಇಲ್ಲ ಅವ್ರು.
Previous date nu idu ಮಾಡಿ sir. Even otherwise, my lord, the author of the document is already laid evidence before the tribunal, my lord. He is already confronted the document about
No,
the
but this document will have to be verified whether these licenses that you have produced are genuine or not. ಅದು ಮೊಹಮ್ಮದ್ ಕಯ್ಯೂಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ವೆರಿಫೈ ಮಾಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
Yes, my lord.
If it is verified, then I don't mind reviewing this order. Licenses original check ಮಾಡಿ ಇದು genuine check ಮಾಡಿ. Yes, Mohammed Qayyum.
My lord, I am appearing on behalf of Qayyum sir, my lord. 1 week, my lord. Kindly 2 weeks, my lord. As the transport authority, they have received the letter sent by us, but they have not replied yet, my lord.
Madam, this order was passed on 25/7.
Yes, my lords. Immediately on 6th, it was sent, my lords. The letter was sent on 6th of August, and it was received by the office on 12th of August, my lords. But till today, we have not received a reply
Yes.
yet, my lords.
He has given the particulars of the license. If you can't verify it,
There are 2 driving extracts, my lords. For that, they have sought for the clarification. We'll get within a week, my lords.
learn counsel for the respondent number 1 again 6 time. When do you want it list on date?
After 10 days, any date, my lords.
30th August. 30th August.
Please.
Serial number 2, Mahesh Patel.
Mahesh Patel.
Appearing for the additional person.
Sumana Naganand.
I appeal for respondent number 1 and 2. Let's file wakalat. If you receive instructions, file wakalat this week. Awaiting.
So why don't you take out process to the other respondents R3?
R3.
My lord, R3 already served, my lord. Served and even the acknowledgement has been filed, my lord.
Illide.
My lord, it is filed, my lord, on 3/7/24, my lord.
3/7/24. Illide ಅದು ಇಲ್ವಲ್ಲ.
ಇಲ್ಲಿ 3/7/24 ಕಲಬುರಗಿ ಬೆಂಚ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
Ravi Patila.
Yes, my lord.
Who is this respondent number 3? Manjunath Siddappa. Manjunath Siddappa process ಕೊಟ್ಟಿಲ್ವಲ್ಲ.
Ravi Patil was directed to take notice of first and second respondent because we have entered appearance on their behalf. For respondent number 3,
take out process, Mr. Workout. 1 week time is granted to take out process to the respondent number 3 to pay process and deposit other requisites to issue notice to respondent number 3.
May I request for week after next month?
The first process ಕೊಡಿ ಆಮೇಲೆ ನಾವು
Please.
ತಗೊಳ್ಳಿ ಪಾಸ್ವರ್ಡ್ ಇದೆ ತಗೊಳ್ಳಿ. ಈ ಪಾರ್ಥಾರ್ಥಿ ಅವ್ರದ್ದು ಏನಾಯ್ತದು ಡೇಟ್ ಕೊಟ್ಟು ಅದು
Pass door matters, list number 1, serial number 1, Somsekhar.
ನಿಮ್ದೆ.
Yes, my lord.
Connected petition ಕೊಡಿ.
Krishna. Municipal institution run by the But reputation was held by some of the students that are fighting saying that seeking for revaluation of the field. And that reputation was from on 14/8/2009. And rejecting their claim for revaluation. But based on the certain irregularities were not a joint committee was constituted by the director, the chairmanship of joint director of TUT.
He submitted a report. But the particular connection here, my lord, the last week kindly come to page 49. This is on 14/8/2009. Lord, there are serious allegations against both the petitioner as well as the management, not page 49.
Yes.
The allegations were both against the petitioner as well as the management. Page 50, the allegations against the management. But based on this report, it was placed under suspension by the second respondent on 23/9/2009. But a charge memo was issued by the second respondent containing 21 charges. But the petitioner almost the first respondent government in a revision petition under 132 of Education Act. But that revision petition was allowed. Order of at page
28. 28. Annexure B na?
Yes. Next should be, last, can you come to the art portion? Page 38.
Yes.
ಅರ್ಜಿದಾರರು ಆಡಳಿತ ಮಂಡಳಿಯ ತಮಗೆ ನ್ಯಾಯ ದೊರಕುವುದಿಲ್ಲವೆಂದು ಆಕ್ಷೇಪಣೆ ಎತ್ತಿದ ಕಾರಣ ಅರ್ಜಿದಾರರಿಗೂ ಪ್ರತಿವಾದಿ ಆಡಳಿತ ಮಂಡಳಿಗೂ ಅನೇಕ ವರ್ಷಗಳಿಂದ ಕಾನೂನು ಹೋರಾಟ ನಡೆಯುತ್ತಿರುವುದು ಮನಗಾಣಲಾಯಿತು. ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಪರಸ್ಪರ ಆರೋಪ ಪ್ರಚಾರ ಪದೇ ಪದೇ ಮಾಡುತ್ತಿರುವುದು ಗಮನಿಸಲಾಯಿತು. ಆಡಳಿತ ಮಂಡಳಿಯು ಅರ್ಜಿದಾರರು ನಿಯಮಾನುಸಾರ ಅಮಾನತುಗೊಳಿಸಿ 1 ವರ್ಷ ಲೇಖಾಧಿಕಾರಿಗೆ ಪ್ರತಿಷ್ಠಾಪಿಸಿಲ್ಲ ಹಾಗೂ ಅನುಕಂಪ ಪ್ರತ್ಯಯ ನೀಡದೆ ವಿಳಂಬ ಅನುಸರಿಸುತ್ತಿರುವುದು ಕಾಣಬಹುದು. ಇಲಾಖಾ ವಿಚಾರಣೆಗೆ ಅರ್ಜಿದಾರರು ಸಹಕರಿಸುತ್ತಿಲ್ಲ ಎಂದು ಪ್ರತಿವಾದಿ ವಾದಿಸುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪ ಪಟ್ಟಿ ಹೆಚ್ಚಿನ ವಿಷಯಗಳು ಪರೀಕ್ಷಾ ಕ್ರಮ ಮತ್ತು ಹಣ ದುರುಪಯೋಗಕ್ಕೆ ಸಂಬಂಧಿಸಿದ್ದು ಅವುಗಳಲ್ಲಿ ತನಿಖೆ ನಡೆಸಿದ್ದು ಆಡಳಿತ ಇಲಾಖೆಗೆ ಮಾತ್ರ. ಕರ್ನಾಟಕ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ 2006 ನಿಯಮ 28/2ರಲ್ಲಿ ಅಧಿಕಾರವಿದ್ದು ಪರಮಾಧಿಕಾರವಾಗಿರುತ್ತದೆ. ಆಡಳಿತ ಮೇಲೂ ಗುರುತರ ಆರೋಪಗಳು ನಿಷ್ಪಕ್ಷ ವಿಚಾರಣೆ ತನಿಖೆ ಆಗುವುದು ಅವಶ್ಯವಿದೆ. ಪ್ರಾಧಿಕಾರವಾಗಿದೆ. ಮೂರನೇ ಸ್ವತಂತ್ರ ಪಾರ್ಟಿ ಸಂಸ್ಥೆ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ನ್ಯಾಯಬದ್ಧ ಕ್ರಮ ಎಂದು ಈ ಪ್ರಾಧಿಕಾರ ತೀರ್ಮಾನಕ್ಕೆ ಬಂದು ಅರ್ಜಿದಾರರ ವಾದ ಶ್ರೇಣಿ ಎತ್ತಿ ಹಿಡಿಯಲಾಯಿತು. ಆಡಳಿತ ಮಂಡಳಿಯ ಮೇಲೆ ಹಣ ದುರುಪಯೋಗದ ಆಪಾದನೆ, ಶೈಕ್ಷಣಿಕ ಆಡಳಿತದಲ್ಲಿ ಅನಾವಶ್ಯಕ ಹಸ್ತಕ್ಷೇಪ ಮಾಡುವುದು, ಆಡಳಿತಾಧಿಕಾರಿಗಳು ನೇಮಿಸುವ ಪ್ರಸ್ತಾಪ ಕೂಡ ಇರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈಗಾಗಲೇ ಸರ್ಕಾರ ಇಲ್ಲದೆ ಪ್ರಕರಣದಲ್ಲಿ ಸ್ವಯಂಸೋ ಮೂರನೇ ಪ್ರತಿವಾದಿ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆ ನಿರ್ದೇಶಕರಿಗೆ ಇಲಾಖಾ ವಿಚಾರಣೆ ನಡೆಸಲು ಅನುಮತಿ ನೀಡುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಯಿತು. ರಿವ್ಯೂ ಅಪೀಲ್ ಮುಂದುವರಿಸಿ ಈಗಾಗಲೇ ಸರ್ಕಾರ ಆಡಳಿತ ಮಂಡಳಿಯ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಲು ನೀಡಿದ ಆದೇಶವನ್ನು ಭಾಗಶಃ ಮಾರ್ಪಡಿಸಿದೆ. ಆಡಳಿತ ಮಂಡಳಿ ಶಿಸ್ತು ಕ್ರಮ ವಿಚಾರಣೆ ಮುಂದುವರಿಸಲಿಕ್ಕೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಲಾಯಿತು. ಈ ಪ್ರಕರಣದಲ್ಲೂ ಕೂಡ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ನಿರ್ದೇಶಕರು ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಲು ಯಾವ ಹಂತದಲ್ಲಿ ನಿಂತಿದೆಯೋ ಅಲ್ಲಿಂದ ನಿಯಮಾನುಸಾರ ಪ್ರಾರಂಭ ಹಾಗೂ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ನಿರ್ದೇಶಕರಿಗೆ ಆದೇಶಿಸಲಾಯಿತು ಹಾಗೂ ಅರ್ಜಿದಾರರ ಅಮಾನತಿನ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ನಿರ್ದೇಶಕರಿಗೆ ಸೂಚಿಸಲಾಯಿತು. ಈ ಆದೇಶವನ್ನು ದಿನಾಂಕ 22/3/11 ಕೆಳದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಘೋಷಿಸಲಾಯಿತು.
But what was challenged before the appellate authority?
The initiation of inquiry by and the judgment issue on the ground that the allegations relates to examination malpractice and not misappropriation.
Yes.
And therefore, Lord, it is the director who has the power under Rule 28(2) and not the management for the contention taken in the first period. This order was challenged by the management in WP 14885 of 2007. That was disposed of on 21/4/2011 annexure C page 1.
Yes.
Last you can see the short article. It is stated that the petitioner, which is a society, has initiated an inquiry against the fourth respondent after obtaining approval from the state government. However, on the basis of the objection raised by the fourth respondent, the state government has passed an order to content that Rule 28(2) of the Karnataka University Act granting a Reinstatement Act provides that the managing committee shall be competent to initiate proceedings against its employees in accordance with rules. However, the director shall be competent to initiate a civil inquiry and impose punishment on any employee of the private area college whose salary grant the disciplinary government on the ground of misappropriation or utilization of government or charge of examination malpractice. The petitioner itself has classified 21 charges of weight. 8 even according to the petitioner would be covered under sub-rule 2 of Rule 28, and it would be competent for the director alone to initiate disciplinary inquiry and to submit that it would not be averse to deleting the said charges. 1, 2, 8, 9, 10, 11, 12, and 21, each according to the learned sequence, would be the charges in respect of which the director alone is competent to initiate disciplinary, and therefore would submit that the said charges be deleted and proceedings may be directed to continue after such deletion. However, the learned counsel for the respondent would contend that out of the remaining charges, the tenor of many charges is such that it is only the director who will be competent to initiate inquiry in respect of those charges also. This is the question which cannot be addressed by this court, and it would be required, it would require the finding of fact and an examination of charges.
Yes.
It is therefore open for the court respondent to raise any such objection before the inquiry officer, who would be competent to examine whether the charges are such that which only the director would be competent to initiate proceedings and to pass appropriate orders. With this direction, the petition is disposed of, while the inquiry officer shall delete the aforesaid 8 charges in respect of which only the director can initiate the disciplinary proceeding.
Yes.
According to the input of that question. But based on this, I find objection to the inquiry officer, showing that even in respect of other charges also relates to examination malpractice and the misappropriation of government. That the inquiry officer proceeded to hold that no, it does not relate to those charges, and therefore the management has the power to initiate inquiry in respect of those charges. Now, that order of the inquiry officer is under challenge in this case.
Yes.
Now, my lord, during the pendency of this requisition, an inquiry officer was appointed.
So the inquiry is not concluded.
The inquiry initiated by the respondent director is to conclude.
The inquiry initiated by the director in respect to the 8 charges.
8 charges.
That is concluded. What about these remaining charges?
The inquiry officer has proceeded with the inquiry, and there was the interim order directing that subject to.
So inquiry and Agila. Agidya? Agide. Report is not submitted.
I have submitted to this honorable court on 1/8/2013, my lord, by a memo. 1/8/2013 by a memo. I have
Whether
filed
the inquiry officer has considered this request of the petitioner.
That has not been considered in my specific contention, that is first thing. Secondly, my lord, when they appointed an inquiry officer, my lord, I again approached the first respondent government, my lord, under 132 of the Education Act on the ground. That's section rule 28(3), my lord, which categorically says that even the inquiry officer has to be appointed only by the director and not the management.
Yes.
But that revision petition was allowed by the government. Against that, my lord, the management has filed this requisition 13/658 of 2004. So in this, my lord, there is an interim order not to release the pensionary benefits of the petitioner.
No, but still the management has not taken any decision.
Management has already, my lord, concluded the inquiry and have submitted the report also.
No, but based on the report, no steps are taken.
Government has to take steps, my lord.
Let us see what our petition, no, what is the ground on which they say that the inquiry officer has no power? Has power rather. Yes, sir. Nimden case ಹೇಳಿ.
My lord, let me.
28(3), my lord.
ಕೊಡಿ. Collegiate education rules, huh? ಕೊಡಿ.
Karnataka PMSD academic registration, etc. rules. 2006.
Yes.
Rule 28, procedure. Procedure for conducting disciplinary inquiry. The managing committee shall be competent to impose penalties specified in Rule 27. provided that in case of employees working in the managing committee shall obtain prior approval of the director of pre-university education for imposing legal penalties on any employer. Number two, a managing committee shall be competent to initiate disciplinary proceedings against its employees in accordance with these rules. However, the director shall be competent to initiate disciplinary inquiry and impose punishment on any employees of the private aided pre-university college whose salary grants are released by the government on the grounds of misappropriation or misutilization of government funds or on charge of examination malpractice. The director is also competent to initiate domestic inquiry against the employees whenever the managing committee gives up the right in favor of the director in accordance with the pre-university course state level examination rules 1997. This is in respect of examination malpractice and misutilization of the government fund. It is only the director who has the power to initiate it. Now, suppose three. In all the disciplinary proceedings, the director shall be competent to appoint the inquiry officer either suo if the inquiry is ordered by him or under sub rule or on a proposal by a managing committee if the charges are framed by the managing committee.
Yes.
On this ground, I had approached the first respondent government under 132 stating that the management has no power to initiate power to appoint the inquiry officer. That revision petition was allowed. Against that, the petition has been filed. That is WP 1365.
Yes, sir.
Malad, let me kindly in the other writ petition to 13658. Let me kindly directly I will request my lord to para 22 of my writ petition, Malad. Para 22 of my writ petition. 13658 of 2014.
Yes. Para 22.
Though other paras are also relevant to, but this is main matter. The respondent or the respondent number 3 have not examined whether the 7 charges 3, 14, 15, 16, 17, 19 and 20 pertain to misappropriation and misutilization of government funds and examination malpractice resulting in miscarriage of justice. The petitioner for convenience has examined the same as detailed below. Regarding charge number 3 indicate that the respondent number 1 as a principal did not permit one student, Sri Preetham, to write examination though he had paid the fees. The student had filed a petition before the District Consumer Forum, Mysore. The Consumer Forum imposed a fine of 25,000 and also 10,000 for mental agony payable by the respondent number 1 and imposed 5,000 on the petitioner institution, including rupees 2,000 cost of the proceedings along with 10%. Thus, it is clear that this charge number 3 does not come under Rule 28(2) of the Karnataka Pre-University rules pertaining to examination malpractices. 22B, Malad. The charge number 14, the respondent 1 had purchased almiras at cost of rupees 9,851 without calling for quotation, and delivery of the almiras are not recorded in the stock registers and the almiras are not found in the college. The respondent 1 has misappropriated 9,851. This charge is about irregularity misappropriation of college fund. Therefore, charge number 14 does not come under Rule 28(2) of this so and so pertaining to misappropriation. 22C, Malad. The charge number 15 pertains to non-remitting of 40,930 and 14,580, which is shown as remitted in the challan counterfiles as deposited in the bank. But above amount is not recorded in the bank passbook. Therefore, this is misappropriation amount belonging to petitioner management. This also does not come under Rule 28(2) of Karnataka pertaining to misappropriation and misutilization of government fund. 22, para 22D, Malad. The charge number 16 is in respect of respondent number 1, remaining absent unauthoritatively without permission in spite of repeated instructions. The OPD slips produced by the respondent 1 are all concocted as per the reply received from the Care Hospital, Mysore. Therefore, it is clear that this charge number 16 also do not come under Rule 28(2) of the Karnataka of the 22E, Malad. The charge number 17 pertains to inaction on the part of the first respondent in getting account inspected and audited, further destroying documents pertaining to examination held during 2005-6 and 2007-8. Thus, this charge does not come under Rule 28-2. 22F. The charge number 19 pertains to illegally demanding rupees 40,000 in respect of a lecturer M. Mahesh. This is also a complaint that respondent 1 had demanded rupees 3 lakhs from commerce lecturer Mr. Swami. Therefore, this charge number 19 pertains to irregularity and does not come under Rule 28-2. 22G. With regard to charge number 20, it is submitted the respondent 1 should have deposited 50% only to the Karnataka Student Welfare Fund, whereas the entire amount of rupees 17,956 has been remitted without utilizing 50% of the amount for the student welfare in the college. Further, for the year 2007-2008, similarly, the entire amount of rupees 22,350 is remitted instead of sending only 40%, and the balance 60% should have been utilized for the welfare fund. This is also an irregularity and does not come under Rule 28. Therefore, in respect of these 7 charges, the inquiry officer has held inquiry and then has submitted the finding holding that he is guilty of these 7 charges. They do not pertain to 28. The authority does not examine these things, my lord, which is explained in the statement of objections and come to the conclusion.
What is challenged in your petition?
Order of the authority, my lord. Annexure. That day I read to my lord. Annexure J, my lord.
Annexure J.
Yes, ma'am. At page 144.
Yes.
The relevant paras are at page 31, page 160, para 31, my lord.
Yes, please.
160, para 31.
Yes, sir.
In respect of the ground urged in view of Rule 28.3, the appointment could have been made by the director and the defense of the second respondent that there was no proposal to appoint inquiry officer by the management committee, and as such the director could not have appointed the inquiry officer. I deem it proper to state that in view of the observation made earlier that the order dated regarding appointment of inquiry officer in respect of 21 charges has remained intact, there is considerable force insofar as the arguments of the petitioner. No doubt the competency of the inquiry officer into the rest of the charges apart from the charges on which an admission is already made by the management that the same is required to be inquired by the director is pending consideration before this honorable court in WP number so and so. As long as the order dated 8/11/2020 is made in respect of all the 21 charges, this is wrong because I have confined only to 7 charges. The order cannot be sustainable in view of the provisions of Rule 28.3 of the Karnataka Education. So as long as para 32, as long as the second does not amend the order by issue of a suitable corrigendum, the appointment of inquiry officer made in pursuance of the order cannot be questioned. As such, I hold that the sufficient ground is made out interfering with the order dated 8/11/2010. In fact, this honorable court permitted me to hold inquiry in respect of certain charges. That was also the inquiry officer said another 8 charges were dropped. Only 7 charges which I read, the inquiry officer held inquiry. That is without examining them whether they come under 28.3. Entire thing is, I have confined only to 7 charges.
Anything else? Ashtena? Alala. Is there any other ground?
Attention of the management is not correct. Can you see the original charge at page 17 of the petition?
Page 17.
Page 17 of my petition. They have added the additional parts there. Can you come to the charge itself? Page 17 of the petition.
Yes.
Charge number 3. See,
Page 17, huh? Page 17.
Of 2280.
22800 code, right? Mr. Yes.
Page 17. Sri K. Shankar Pashupalam Mahajan College Jayalakshmi from Mansur New. Sri Brita member from PUC Vidyarthi. That's all Umakane main and in another purchase Shulka Katitaru Saha. Sadri Vidyarthi. ಸಕಾಲದಲ್ಲಿ ಪ್ರವೇಶ ಪತ್ರ ನೀಡಿರುವುದಿಲ್ಲ. ಇದರಿಂದಾಗಿ ಸದರಿ ವಿದ್ಯಾರ್ಥಿ ಪರೀಕ್ಷೆ ಬರೆಯಲಾಗದೆ ಅವರಿಂದ ಒಂದು ವರ್ಷದ ಭವಿಷ್ಯ ಹಾಳಾಗುವುದಕ್ಕೆ ಕಾರಣರಾಗಿರುತ್ತದೆ. This is an examination malpractice.
Malpracticing ಆಗುತ್ತೆ. Malpractice.
Not been permitted to write the examination.
Malpracticing ಆಗುತ್ತೆ.
It relates to the examination.
Let us see what is the meaning of malpractice.
Please. Initially is not there.
Right.
Therefore, the charge number 1 could not have been inquired into by the management. Then in respect of charge number 19.
Charge number
19. For the charge 15.
15, huh?
100. May read at page 22. Sri K. Shankar Prashupala Mahajanapadi College election from Mysore ನೀವು ತಮ್ಮ ಅವಧಿಯಲ್ಲಿ ಸಂಗ್ರಹಿಸಿದ ಶುಲ್ಕವನ್ನು ಬ್ಯಾಂಕಿಗೆ ಜಮಾ ಮಾಡುವುದು ಹಾಗೂ ಚಲನ ಮುಖಾಂತರ ಜಮಾ ಮಾಡಿದ ಮೊತ್ತ ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ನಮೂದಾದ ಇದು ದ್ರವ್ಯಾಪರಣ ಮಾಡಿರುತ್ತೀರಿ. ಕರ್ನಾಟಕ ಎಜುಕೇಶನ್ ಆಕ್ಟ್ 1983 ಇದರಲ್ಲಿ ಸೆಕ್ಷನ್ 91 ಮತ್ತು 92 1 ಹಾಗೂ ಕರ್ನಾಟಕ ಪ್ರೀ ಯೂನಿವರ್ಸಿಟಿ ಎಜುಕೇಶನ್ ಅಕಾಡೆಮಿಕ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಅಂಡ್ ಗ್ರಾಂಟಿಂಗ್ ಏಡ್ ಎಕ್ಸೆಟ್ರಾ ರೂಲ್ಸ್ 2006 ರೆಡಿಯಲ್ಲಿಲ್ಲ. ನಿಯಮ 25(1)(2)(2)(a 25(2)(b)(1) ಇವುಗಳಲ್ಲಿ ಶ್ರೀ ಶಂಕರ ನೀವು ಉಲ್ಲಂಘಿಸುವುದು ಕಂಡು ಬರುತ್ತದೆ. Then charge number 19.
But ಇದು ಹೆಂಗಾಗುತ್ತೆ ಇದು ಚಾರ್ಜ್ ನಂಬರ್ 15 ಹೆಂಗಾಗುತ್ತೆ?
ಶುಲ್ಕವನ್ನು ಬ್ಯಾಂಕಿಗೆ ಜಮಾ ಮಾಡಿರುವುದು. ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
What else is it?
The fees to be deposited to the government.
Sir, ಜಯಲಕ್ಷ್ಮೀಪುರ ಮೈಸೂರಾದ ನೀವು ತಮ್ಮ ಅವಧಿಯಲ್ಲಿ ಸಂಗ್ರಹಿಸಿದ ಶುಲ್ಕವನ್ನು
ಚಲನ ಮುಖಾಂತರ ಜಮಾ ಮಾಡಿದ ಮೊತ್ತ ಬ್ಯಾಂಕ್ ಪಾಸ್
ಬ್ಯಾಂಕ್ ಶುಲ್ಕ ಗೌರ್ಮೆಂಟ್ ಹೆಂಗಾಗುತ್ತೆ? ಗೌರ್ಮೆಂಟ್ ಶುಲ್ಕ ಹೆಂಗಾಗುತ್ತೆ ಕಾಲೇಜಲ್ಲಿ? It is a fees payable by the students. How can that become government money? Right, next.
Charge number 19. K. Shankar Prashupala Mahajana Pavitra College election from Mysore ನೀವು ಶ್ರೀ ಮಲ್ಲೇಶ್ ಉಪನ್ಯಾಸಕರ ವಿರುದ್ಧ ಕಾನೂನು ಬಾಹಿರವಾಗಿ 40,000 ಹಣ ಪಡೆದು ವೇತನದಿಂದಲೂ ವಿಳಂಬವಾಗಿ ಉಪನಿರ್ದೇಶಕರ ಕಚೇರಿಗೆ ಕಳಿಸಿರುತ್ತೀರಿ. ಶ್ರೀ ಸ್ವಾಮಿ ವಾಣಿಜ್ಯ ಉಪನ್ಯಾಸಕರು ಈ ವಾರ ನೇಮಕಾತಿ ಕಾರ್ಯದರ್ಶಿ ನೀವು 2 ಲಕ್ಷ ಹಣ ಕೇಳಿದ್ದು ಮತ್ತು ಅವರಿಂದ ಜಾತಿ ನಿಂದನೆ ದೂರನ್ನು ನೀಡುವುದಾಗಿ ಬೆದರಿಕೆ ಹೊತ್ತಿರುವುದು ಕಂಡುಬಂತು. The first part is related to the government funds.
ಕೆ. ಶಂಕರ್ ಪ್ರಾಂಶುಪಾಲರು
Yes.
ಆದ ನೀವು ಎಂ. ಮಲ್ಲೇಶ್ ಉಪನ್ಯಾಸಕರು ಇವರಿಂದ ಕಾನೂನು ಬಾಹಿರವಾಗಿ 40,000 ಹಣ ಪಡೆದು ವೇತನ ಬಿಲ್ಲನ್ನು ವಿಳಂಬವಾಗಿ ವೇತನವನ್ನು ವಿಳಂಬವಾಗಿ
Grants are released from the government.
correct, but how this 40,000 is not money of the government.
ಕಾನೂನು ಬಾಹಿರ ಹಣ ಪಡೆದು ವೇತನ ಬಿಲ್ಲುಗಳನ್ನು ವಿಳಂಬವಾಗಿ ಉಪನಿರ್ದೇಶಕರಿಗೆ
ಸರಿ 40,000 ರೂಪಾಯಿ ಅಷ್ಟೇ ಇದು. Charge relates to 40,000 rupees. The charge relates to receiving 40,000 rupees from this man. ಯಾರಿದು ಮಲ್ಲೇಶ್. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಏನು? 20.
ಶಂಕರ್ ಪ್ರಾಂಶುಪಾಲ 2006-7ನೇ ಸಾಲಿನಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳಿಂದ ಸಂಗ್ರಹಿಸಿರುವ ಒಟ್ಟು ಹಣದಲ್ಲಿ ಶೇಕಡಾ 50% ಹಣವನ್ನು ಕಾರ್ಯದರ್ಶಿ ಖಜಾಂಚಿ ಕಚೇರಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಿದ್ಯಾರ್ಥಿ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಶಿಕ್ಷಕರ ಭವನ ಅವರಿಗೆ ಕಡ್ಡಾಯವಾಗಿ ಕಳುಹಿಸಿಕೊಡಬೇಕಾಗಿತ್ತು. ಆದರೆ 9,030 ರೂಗಳನ್ನು ಮಾತ್ರ ವಿದ್ಯಾರ್ಥಿಗಳ ಕಲ್ಯಾಣ ನಿಧಿ ಕಳುಹಿಸದೆ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಅನ್ಯಾಯ ಮಾಡಿರುತ್ತದೆ.
ಇದು ಗೌರ್ಮೆಂಟ್ ದುಡ್ಡಲ್ಲ, ಇದು ಸ್ಟೂಡೆಂಟ್ಸ್. ಆಮೇಲೆ ಮತ್ತೆ
But my contention is that the inquiry officer could not have been appointed to the managing committee because of the allegations being made. But in a report where the joint director has also not made allegations against the management. Now, for that reason, I approach the first respondent. Now, even rule 28 categorically says it is only the director who can appoint an inquiry.
No, but whether the management has given the right to conduct an inquiry to the director.
The order, the rule specifically says that in all cases, last tendency.
Both. In all the disciplinary proceedings.
The director shall be competent to appoint the inquiry officer either so more. If the inquiry officer is ordered by him under sub-rule 2 or on a proposal by a managing committee, if the charges are paid.
So whether disciplinary proceedings managing committee director ಮಾಡಿ ಅಂತ proposal ಕಳಿಸಿದಾರಾ?
Submission was for the first respondent. Then since these inquiry proceedings are initiated and the charges are paid only on the basis of the report submitted to the joint commissioner, joint director of you, not where the allegations were made against the management also. Not that was my specific contention that I will not get any it will not be a fair inquiry.
Sorry, but these allegations are regarding these 7 inquiries, 7 charges.
Yes.
Examination malpractice.
These are also part of the report submitted by the joint director.
ಆಯ್ತು ಈ 7 charge ಮೇಲೆ what is the finding of the joint director? ಈ 7 charges ಮೇಲೆ what are the
Joint director has made allegations in respect of these things.
in respect of the 7 charges?
7 charges.
Source
Source. The allegations made. The report is at page 49.
49, huh? Source.
ಆಚಾರ್ಯ ಆಚಾರ್ಯರು ತಮ್ಮ ಪಿಯುಸಿ ಪರೀಕ್ಷಾ ಕೆಲಸಗಳನ್ನು ನಿಯಮಾನುಸಾರವಾಗಿ ಸಮರ್ಪಕವಾಗಿ ನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಉತ್ತರ ಪತ್ರಿಕೆಯಲ್ಲಿ ಇರುವ ಅಂಕಗಳ ಫಲಿತಾಂಶ ಪಟ್ಟಿಯಲ್ಲಿ ಬದಲಾವಣೆಗೊಂಡಿದೆ. ಅಂಕಗಳನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಅನುತ್ತೀರ್ಣರಾದ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಉತ್ತೀರ್ಣರೆಂದು ಘೋಷಿಸಲಾಗಿದೆ. 2005, 6, 7 ಮತ್ತು 7, 8, 2009 ಆಯ್ಕೆ ನಾಶಪಡಿಸಲಾಗಿದೆ ಎಂದು ಪ್ರತಿಪಾದಿಸಿದ್ದಾರೆ. ಆದರೆ ಆಡಳಿತ ಮಂಡಳಿ 2006, 7 ಉತ್ತರ ಪತ್ರಿಕೆಗಳು ಕಾಲೇಜಿನ ಗೋಡೌನ್ನಿಂದ ತೆಗೆದು ತಪಾಸಣೆ ತಂಡಕ್ಕೆ ನೀಡಿದೆ. ಅದರಲ್ಲೇ 45 ಉತ್ತರ ಪತ್ರಿಕೆಗಳು ಅಂಕಗಳಿಗೂ ಫಲಿತಾಂಶ ಪಟ್ಟಿಗೂ ವ್ಯತ್ಯಾಸವಿದೆ. 2007 ಉತ್ತರ ಪತ್ರಿಕೆಗಳಲ್ಲಿ ಇನ್ನೂ ಹೆಚ್ಚಿನ ವ್ಯತ್ಯಾಸವಿದೆ ಎಂದು ಅನುಮಾನ ದೃಢವಾಗುತ್ತದೆ. ಕಾಲೇಜಿನ ದಾಖಲಾತಿಗಳನ್ನು ಮಾಡುವಾಗ ನಿಯಮಗಳನ್ನು ಪಾಲಿಸಿಲ್ಲ. ದ್ವಿಪತ್ರಿ ವರ್ಗಾವಣೆ ಪತ್ರ ಆಧಾರದ ಮೇಲೆ ದಾಖಲಾತಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ಕೆಲವು ದಾಖಲೆಗಳು ಅರ್ಜಿದಾರಗಳನ್ನೇ ಭರ್ತಿ ಮಾಡಿರುವುದಿಲ್ಲ. ತಾತ್ಕಾಲಿಕ ಯೋಗ್ಯತಾ ಪತ್ರಗಳನ್ನು ಪಡೆಯದೆ ದಾಖಲಾತಿ ನೀಡಿರುತ್ತಾರೆ. ದಾಖಲಾತಿ ಸಮರ್ಪಕವಾಗಿ ಬರೆಸಿಲ್ಲ. ಕಾಲೇಜಿನ ಅತಿ ಮುಖ್ಯವಾದ ತರಗತಿಗಳ ವೇಳಾಪಟ್ಟಿಯನ್ನೇ ಬಿಟ್ಟಿರುವುದಿಲ್ಲ. ಇದರಲ್ಲಿ ಶೈಕ್ಷಣಿಕ ಚಟುವಟಿಕೆಗಳು ಸಮರ್ಪಕವಾಗಿ ನಡೆಯುವುದಿಲ್ಲ ಎಂದು ಕಂಡುಬರುತ್ತದೆ. ತರಗತಿಗಳು ಹಾಗೂ ಉಪನ್ಯಾಸಕರ ಪ್ರಾಚಾರ್ಯದ ಹಿಡಿತವಿಲ್ಲ. ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಸಮರ್ಪಕವಾದ ಬೋಧನೆಯಾಗದೆ ಫಲಿತಾಂಶ ಕುಂಠಿತ ಕಾರಣವಾಗಿದೆ. ಲೆಕ್ಕಪತ್ರಗಳ ಸಮರ್ಪಕವಾಗಿಲ್ಲ. ಬ್ಯಾಂಕಿಗೆ ದಿನ ವಸೂಲಾದ ಮೊತ್ತವನ್ನು ಭರ್ತಿ ಮಾಡುವಲ್ಲಿ ವ್ಯತ್ಯಾಸಗಳಿದೆ. ರಸೀದಿಗಳನ್ನು ತಿದ್ದಿ ದಾಖಲಾತಿ ನೀಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಪ್ರಾಚಾರ್ಯರು ಮೇಲಿರುವ ದೂರುಗಳನ್ನು ಮೈಸೂರು ಜಿಲ್ಲಾ ಉಪನಿರ್ದೇಶಕ ಪರಿಶೀಲಿಸಿ ವಿದೇಶಿ ವಿದ್ಯಾರ್ಥಿ ದಾಖಲಾತಿ ನಿಯಮಗಳ ಉಲ್ಲಂಘನೆ ದಾಖಲಾತಿ ಮಾಡಲಾಗಿದೆ ಎಂದು ಮತ್ತು ಸಾರ್ವಜನಿಕರ ದೂರುಗಳಲ್ಲಿ ಸತ್ಯಾಂಶವಿದೆ ಎಂದು ಪ್ರಾಚಾರ್ಯ ವಿರುದ್ಧ ಕ್ರಮಕ್ಕೆ ಶಿಫಾರಸು ಮಾಡುತ್ತಾರೆ. ಈ ಕಾಲೇಜಿನಲ್ಲಿ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಮರ್ಪಕವಾಗಿ ನಿರ್ಮಿಸಿಲ್ಲ. ಅನುಮೋದನೆ ಆದೇಶ, ಮಾನ್ಯತೆ ಆದೇಶ, ನವೀಕರಣ ಮೂಲ ಪ್ರತಿಗಳನ್ನು ಕಾಲೇಜಿನಲ್ಲಿ ಇಟ್ಟಿರುವುದಿಲ್ಲ. ಕಾಲೇಜಿನ ದೈಹಿಕ ಕೆಲಸ ಕಾರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸುವ ಪ್ರಾಚಾರ್ಯಕ್ಕೆ ಜವಾಬ್ದಾರಿಯಾಗಿರುತ್ತೆ. ಈ ಜವಾಬ್ದಾರಿ ನಿವೃತ್ತಿಯಲ್ಲಿ ಪ್ರಾಚಾರ್ಯರು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಾಗೂ ಫಲಿತಾಂಶದ ಬದಲಾವಣೆ ಸಂಬಂಧವಾಗಿ ಪ್ರಾಚಾರ್ಯರ ಮೇಲೆ ಕ್ರಮ ಜರುಗಿಸಬಹುದು.
ಎಲ್ಲಿದೆ ಈ 7 ಚಾರ್ಜಸ್ ಮೇಲೆ?
ಸಮರ್ಪಕವಾಗಿಲ್ಲ. ಬ್ಯಾಂಕ್ಗೆ ದಿನ ವಸೂಲಾದ ಮೊತ್ತಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವಲ್ಲಿ ವ್ಯತ್ಯಾಸಗಳಿವೆ. That is what is the allegation made against me. That the bank receipt, the fee collected has not been properly accounted.
ಅಷ್ಟೇನಾ?
For that reason only, the inquiry officer appointed noticing whatever the defense I had taken, he has proceeded towards the charges as proved.
Yes.
Therefore, the very inquiry initiation was contrary to rule 28(3).
ಬರ್ಕೊಳ್ಳಿ.
May submit only one thing, Mela.
ಹೇಳಿ.
ಇದು ಇದರಲ್ಲಿ ಈ ಅವ್ರ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀನಿ. ಅದ್ರಲ್ಲಿ ಪ್ಯಾರಾ 18 ಒಂದು ತಾವು ನೋಡಿ, ಯಾಕೆಂದ್ರೆ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಅಲಿಗೇಷನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀನಿ. ಅದ್ರಲ್ಲಿ ಪ್ಯಾರಾ 18 ಒಂದು ತಾವು ನೋಡಿದ್ರೆ ಅವ್ರ ರಿಟ್ ಪಿಟಿಷನ್, ನಮ್ದಲ್ಲ, ಅವ್ರದ್ದು ಶಂಕರ್ 13 to 22,800. ಅದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ಅದ್ರಲ್ಲಿ ಪ್ಯಾರಾ 18 ಒಂದು ರೆಫರ್ ಮಾಡ್ತೀನಿ ತಮಗೆ. Annexure F ಅಲ್ಲಿ it was pointed out.
ಬಂದೆ. Objection. Para 18
ಪ್ಯಾರಾ 18. ಯಾಕಂದ್ರೆ ಅವ್ರು ಹೇಳಿದ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ಸ್ ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಇದು ಅಂತ. ಅದಕ್ಕೆ ಪ್ಯಾರಾ 18 ಮೇಲೆ the contents in para 10 of the writ petition is untenable in respect of Annexure F dated 14/8/2000 of the Joint Director Administration. The government has examined the same and has sent a reply dated 8/10/8/2011 holding that the petitioner as principal was responsible for all the irregularities in the PU College of Maharaj Education Society, and therefore there is no necessity to appoint administrator. Copy of the said letter dated 8/10/8/2011 is produced annexure R2B. Page 89 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ಪೇಜ್ 89 ಅಲ್ಲೇ ಒಂದು R2B ಅಂತ I have produced. Because they are all directed that the administrator should be appointed, irregularities ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಅದಕ್ಕೆ ಅವರೇ ಸರ್ಕಾರದ ಸೆಕ್ರೆಟರಿ ಬರೀತಾರೆ ನಿರ್ದೇಶಕರಿಗೆ, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ಮಹಾಜನ ವಿದ್ಯಾಸಂಸ್ಥೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಿವಿಧ ಶಾಲೆ ಕಾಲೇಜುಗಳ ಪೈಕಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜಿನಲ್ಲಿ ಮಾತ್ರ ಸಮಸ್ಯೆ ಉಂಟಾಗಿದ್ದು ಇದಕ್ಕೆ ಪ್ರಾಂಶುಪಾಲರೇ ಕಾರಣರಾಗಿದ್ದು ಅವರ ವಿರುದ್ಧ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿದ್ದಾರೆ. ಈ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮೈಸೂರಿನ ಉಪವಿಭಾಗದ ಸಮ್ಮುಖದ ಚರ್ಚೆಯಾಗಿದ್ದು ಕಾಲೇಜಿನ ಆಡಳಿತ ಮಂಡಳಿಯು ಕಾಲಕಾಲಕ್ಕೆ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಂಡಿದ್ದು ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ವಹಣೆಯಲ್ಲಿ ಯಾವುದೇ ಮೋಸ ಮಾಡುವುದು ಕಂಡು ಬಂದಿಲ್ಲವರುವುದರಿಂದ ಸದರಿ ಸಂಸ್ಥೆಗೆ ಆಡಳಿತ ಅಗತ್ಯವಿರುವ ಅಂಶವನ್ನು ತಮಗೆ ತಿಳಿಸಲಿದೆ. That's all my submission.
But in respect of the inquiry, have been told there were examination malpractice.
Yes.
Have been exonerated by the department.
ಅಲ್ಲ ಆಯ್ತು, ಇಲ್ಲ ಆಗಿಲ್ವಲ್ಲ.
My husband is reading about the exoneration of the society by the management, by the registrar of cooperative society. Then secondly, not when the buildings of this petition, the inquiry petitions have been included. That a report was submitted to me. Now I did not support my explanation in the second local notice for the reason that the petition was pending.
I will permit you to file a reply.
Please.
Barcode. The petitioner is the petitioner in WP number 22800 of 2011 has challenged the correctness of the disciplinary proceedings initiated by the respondent number 3 against the petitioner. On 20/10/2009, the petitioner also has challenged the correctness of the order dated 11/6/2011 passed by the respondent number 3 in the disciplinary proceedings initiated against him on 29/2009. Next paragraph. The petitioner was employed as the principal of the respondent number 2, an aided institution. Full stop. The petitioner was placed under suspension on 6/10/2009 pending a departmental inquiry. Please sit down. AG. On 6/10/2009. On the basis of a report submitted by the Joint Director of Pre-University. Full stop. On 20/10/2009, a charge memo was issued alleging 21 charges against the petitioner. Full stop. Being agreed by the order suspending him as well as the articles of charge. The petitioner filed review petition 13/2010 under section 131 of the Karnataka Education Act 1983. Full stop. The petitioner primarily contended that the initiation of disciplinary proceedings by the respondent number 3 was contrary to Rule 828(2) of the Karnataka Pre-University Education Academic Rules 2006. Full stop. The respondent number 3 the review authority was pleased to allow the petition by way of an order dated 22/3/2011, holding that the inquiry had to be held by the respondent number 1 in view of the alleged charges relating to misappropriation of government funds and examination malpractice. Full stop. Being agreed with the said order, the respondent number 2 and 3 filed WP number 14885 of 2011. Full stop. During the course of hearing the writ petition, the respondent number 2 stated that amongst the articles of charge, charge number 1, 2, 8, 9, 10, 11, 12, and 21 related to misappropriation of government funds and examination malpractice, and that the remaining charges alleged against the petitioner related to misconduct, and that it had the jurisdiction to hold an inquiry as the disciplinary authority. Full stop. The writ petition was disposed of in terms of the order dated 21/4/2011. Full stop. The relevant portion of the order reads as follows. Page number 42, inverted comma. Page 42 and 43. This court disposed of the writ petition and directed the inquiry officer to delete the aforesaid 8 charges in respect of which only the director could initiate the disciplinary proceedings. Full stop. The petitioner, following the order passed by this court, submitted a representation before the inquiry officer on 28/5/2011 to drop charges 3, 14, 15, 17, and 20 on the ground that they too related to misappropriation of government funds, and that the competent authority to conduct a disciplinary proceedings was the director and not the respondent number 2. Full stop. The respondent number 2 and 3, however, proceeded with the inquiry in respect of 7 charges in terms of the order dated and date is 11/6/2011. Full stop. The petitioner, therefore, being agreed by the said proceedings initiated by the respondent number 3, has filed this writ petition. Next para. The writ petition is opposed by the respondent number 2, who contends that the charges, namely charge number 1, 2, 8, 9, 10, 11, 12, and 21, were given up before this court in WP number 14885 of 2011 as It was the respondent number 1 who was the competent authority to initiate proceedings under Rule 28(2) of the Rules 2006. Full stop. It is contended that after considering the order passed by this court in the writ petition referred above, the inquiry officer, after hearing the petitioner as well as the presenting officer, had ordered that 7 charges did not pertain to misappropriation or misutilization of government funds or examination malpractices. Full stop. Therefore, the inquiry, thereafter the inquiry officer proceeded with the inquiry. Full stop. It is contended that of the 21 charges framed against the petitioner, 6 charges were dropped by the management, of which and of the remaining 15 charges, a submission was made before this court that 8 charges would be deleted, and the inquiry was restricted to 7 charges, which did not relate to misappropriation or misutilization of the government funds and examination malpractice. Full stop. It is contended that the competent authority to conduct an inquiry in respect of the remaining 7 charges was the management itself and not the respondent number 1. And therefore, the inquiry officer rightly proceeded with the inquiry to conduct, proceeded with the inquiry into the 7 charges. Full stop. It is therefore contended that there is no merit in the contention of the petitioner, and there is no requirement in law that the 7 charges had to be inquired into by the therefore contended that it is not the respondent number 1 who has to initiate disciplinary proceedings and appoint an inquiry officer in respect of the 7 charges. Full stop. The learned counsel for the petitioner invited the attention of the court to the 7 charges and contended that one of the charges related to the petitioner not depositing the amounts collected from the students, and therefore that too was a charge relating to misappropriation or misutilization of the funds of the state government. He also submits that charge number so and so related to receipt of a sum of rupees 40,000 from a co-worker for delaying the submission of the salary bill. So he contends that this too was nothing but misappropriation of funds of the government, and therefore the inquiry officer, without realistically considering the gravamen of the charges, had held that he is competent to inquire into it. Full stop. Per contra, the learned counsel for the respondent number 2 invited the attention of the court to the 7 charges, which are as follows. So, page number WP number 13658 ಅಲ್ಲಿ paragraph number 22 A, B, C, D, E and F, G. Full stop. He contended that none of the charges referred above related to misappropriation or misutilization of the government funds or examination malpractice. and therefore was outside the scope of Rule 28(2) of the rules of 2006. Thus, he contends that the impugned order passed by the respondent number 2 to proceed with the inquiry is just and proper and does not call for any interference. Next, I have considered submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 2. Next para. It is not in dispute that the petitioner was employed as a principal in the respondent number 2, which is an aided institution. Full stop. Insofar as the procedure for conducting disciplinary inquiries against employees working in aided posts, a detailed procedure is set out in Rule 28 of the Rules 2006, which is extracted below. Copy mount. Full stop. A perusal of Rule 28(2) leaves no doubt that whenever there are any allegations of misappropriation or misutilization of government funds or on charges of examination malpractice, it is only the director/respondent number 1 who would be competent to initiate a disciplinary inquiry and impose punishment. Full stop. In respect of all other charges which are not relating to misappropriation or misutilization of government funds or charges of examination malpractice, it is the management which is alone entitled to initiate a disciplinary inquiry and impose punishment on any employee, subject, however, to reserving the order of punishment for approval before the competent authority. Full stop. A perusal of the 7 charges into which the inquiry officer has conducted an inquiry shows that they remotely did not concern to misappropriation or misutilization of government funds or on charges of examination malpractice. Consequently, the order of the respondent number 2 to continue the inquiry against the petitioner is just and proper and does not call for any interference in this petition. Consequently, this petition is does not merit consideration. Next para. It is now stated at the bar that the inquiry officer has concluded his inquiry and has submitted a report to the disciplinary authority. Full stop. However, the disciplinary authority has not passed any order on the inquiry report. Madidara?
The authority has communicated the inquiry report to me.
But however, has not passed any, however, no action is taken by the disciplinary authority on the, but has forwarded a copy of the inquiry report to the petitioner for his comments. Full stop. The disciplinary authority has not issued the second show cause notice to the petitioner proposing the action that it intends to take against the petitioner. Bandidel report nimge. Bandidena. So you give your explanation. To be taken on the action that it intends to take on the inquiry report. Full stop. Therefore, an opportunity deserves to be granted to the petitioner to offer his comments on the inquiry report as well as to the show cause notice that may be issued by the respondent number 2 to the petitioner. In view of the above, this writ petition is disposed of, upholding the action of the respondent number 2 and 3 in proceeding with the inquiry into the 7 charges mentioned above, Full stop. Hence the impugned, hence the order impugned is upheld. However, the respondent number 2 shall now issue a second show cause notice to the petitioner, putting him on notice about the action that it intends to take based on the findings of the inquiry authority. Full stop. The petitioner is at liberty to submit his comments on the inquiry report as well as to reply to the second show cause notice that the respondent number 2 may issue. Full stop. After the receipt of the reply of the petitioner, the respondent number 2 is directed to proceed in accordance with law. This shall be complied within a period of 3 months. 3 months. 3 months alagata, sir.
We had to send it to the government, my lord, after his explanation.
Punishment ಆದ್ಮೇಲೆ ನೀವೇನ ಕಳಿಸಿ ಗವರ್ಮೆಂಟ್ಗೆ
ಅಪ್ರೂವಲ್ಗೆ, ಯಾಕಂದ್ರೆ ಅವ್ರ ಅಪ್ರೂವಲ್ ಇಲ್ಲದೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇದು ಏಡೆಡ್ ಎಂಪ್ಲಾಯ್.
ಪನಿಷ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಅಪ್ರೂವಲ್ ಕಳಿಸಬೇಕಲ್ಲ.
Yes, my lord. That we can do within 3 months, my lord, depending on his reply.
Second show cause notice ಕೊಡಿ ಅವ್ರಿಗೆ.
Yes, my lord.
Now that he has received a copy of the inquiry report, you need not submit or
Yes,
enclose a copy of the report.
Yes, ma'am.
Second show cause notice ಕೊಟ್ಟು conclude ಮಾಡಿ.
Yes, ma'am. Yes.
Within a period of 3 months from the date of receipt
Yes,
of a copy of this order.
Yes, ma'am.
This is the idral WP number 13658 of 2014. The petitioner has challenged the correctness of an order dated 25/2/2014 passed by the respondent number 3 in revision petition 52 of 2011, by which he set aside a memo dated 8/11/2010 issued by the petitioner to the respondent number 1. Next part. The petitioner contends that the respondent number 1 was employed as a principal at one of its aided institutions. Full stop. It is alleged that on 16/12/2008, the students of the college went on strike because of certain irregularities, malpractices indulged in by the first respondent. Full stop. The petitioner therefore was constrained to issue a show cause notice dated 25/4/2009 to the respondent number 1. Full stop. The respondent number 1, however, did not reply to the show cause notice. Full stop. The respondent number 2, after looking into the allegations against the respondent number 1, by letter dated 21/8/2009, recommended to the Secretary to the Government of Karnataka, Primary and Secondary Education, to grant approval to keep the respondent number 1 under suspension. Full stop. The Secretary to the Government of Karnataka, by letter dated 23/9/2009, granted permission to place the respondent number 1 under suspension pending an inquiry. Consequently, the respondent number 1 was placed under suspension and a articles of charge was issued on 20/10/2009. Full stop. The petitioner thereafter appointed an advocate as an inquiry officer on 8/11/2010. Full stop. The respondent number 1 filed Revision petition 13/2010, challenging the order of suspension as well as the order proposing to conduct an inquiry, a disciplinary inquiry. Full stop. In the meanwhile, the respondent number 2 submitted a report dated 10/11/2010 requesting the authority to dismiss the petition filed by the respondent number 1. Full stop. After hearing the parties, the reviewing authority passed an order dated 28/3/2011 and allowed the revision petition and directed the respondent number 2 to continue the inquiry from that stage. The petitioner, being aggrieved with the said order, filed WP number 14885 of 2011. And this court, in terms of the order dated 21/4/2011, held that out of 21 charges framed against the respondent number 1, the petitioner was competent to hold an inquiry only in respect of 7 charges. Full stop. Therefore, this court reserved liberty to the respondent number 1 to raise such contentions as against the 7 charges that were pressed into service by the petitioner. Full stop. The petitioner contends that in the meanwhile, an inquiry officer was appointed by the government of Karnataka. Retired district judge was appointed as the inquiry officer by the government of Karnataka to conduct an inquiry in respect of the 8 charges which related to misappropriation and misutilization and examination malpractice allegedly committed by the respondent number 1. Full stop. The petitioner proceeded with the inquiry in respect of the 7 charges which did not relate to misappropriation / misutilization / examination malpractice and did not fall within the ambit of Rule 28(2) of the Rules 2006. Full stop. When things stood thus, the respondent number 1 by a representation dated 28/5/2011 requested for dropping the 7 charges. Full stop. The representation of the petitioner of the respondent number 1 was considered, and the presenting officer considered by the inquiry officer, who, after considering the 7 charges, concluded that they did not relate to or pertain to misutilization, misappropriation of government funds or examination malpractice. Full stop. The inquiry officer appointed by the management thereafter conducted an inquiry and submitted a report on 30/8/2012. While the inquiry officer by the retired district judge, who was appointed as an inquiry officer to inquire into the 8 charges, also submitted his report. Full stop. When things stood thus, the respondent number 1 filed a review petition number 52/2011 challenging the memo dated 8/11/2010 contending that the appointment of inquiry officer by the petitioner is contrary to Rule 28(2) and 3 of the Rules of 2006. Full stop. This petition was contested by the petitioner. Nonetheless, the respondent number 3 passed an order dated 25/2/2014, setting aside the memo dated 8/11/2010, appointing the inquiry officer by the petitioner. Full stop. Being agreed by the ಏನಾಯ್ತು ರಿಟ್ ಅಪೀಲ್ ಏನಾಯ್ತು? What happened to this writ appeal? 5779 of 2013. Sir, para 13 of your writ petition.
I know my lord, but
ಗೊತ್ತಿಲ್ವಾ? ನೋಡಿ ಇದನ್ನು 5779 of 2013 ಏನಾಗಿದೆ ನೋಡಿ writ appeal. Madam, ಬನ್ನಿ. Based on the above, the petitioner, respondent number 1, filed WP number 31725 of 2013, challenging his suspension full stop. A coordinate bench of this court in terms of the order dated 13/1/2014 directed reinstatement of the petitioner, which was then challenged by the petitioner in writ appeal 5779 of 2013. Full stop. ಏನಾಯ್ತು? Which is dismissed on 4th December 2014. Full stop. The petitioner contends that the basis on which the respondent number 3 has passed the impugned order is that all the seven charges that were inquired into by the inquiry officer also related to misappropriation, misutilization of government funds and examination malpractice. He also proceeded to hold that a separate inquiry ought to have been conducted in respect of the 7 charges. Full stop. He submitted that when the allegations, when the charges did not relate to or pertain to misappropriation / misutilization of government fund or examination malpractice, the petitioner was entitled to pursue the inquiry. Full stop. He also contended that when the petitioner had appeared in WP number 14885 of 2011, petitioner, he contended that when the respondent number 1 had appeared and contested WP number 14885 of 2011, the respondent number 1 did not challenge the order passed by the coordinate bench of this court, permitting inquiry in respect of 7 charges subject to satisfaction by the inquiry officer. He contended that the respondent number 1 is therefore stopped in challenging the memo appointing an inquiry officer to inquire into the 7 charges. Full stop. Per contra, the learned counsel for the respondent number 1 contended that a perusal of charge number 3, charge number 3 related to examination malpractice, while charge number 15 related to non-remitting of certain amounts which were belonging to the state government. He also contended that charge number 19 also related to financial misappropriation of funds of the state government. Full stop. He therefore contended that the impugned order passed by the respondent number 3 is just and proper and does not warrant any interference. He, however, submits that when once the petitioner had conceded before this court that of the 21 charges, only 7 charges did not relate to examination malpractice or financial misappropriation or misutilization of the government funds. It was incumbent upon the petitioner to frame a fresh articles of charge. Full stops. He contends that since that was not done, the respondent number 3 was justified in passing the impugned order. Next, I have considered submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent number 1. Next para. As rightly contended by the learned counsel for the petitioner, this court had examined the 15 charges that were framed against the respondent number 1 and found that 8 charges related to misappropriation / misutilization of government funds and examination malpractice, and therefore held that it is the director of respondent number 2 who alone is competent to conduct an inquiry in view of Rule 28(2) of the Rules 2006. Full stop. Insofar as the remaining 7 charges are concerned, it reserved liberty to the respondent number 1 to file appropriate representations before the inquiry officer who was directed to determine whether it related to or pertained to misappropriation / misutilization of government funds and examination malpractice. Full stop. The respondent number 1 did not challenge this order passed in WP number 14885 of 2011. However, accepting the order, the respondent number 1 filed a representation before the inquiry officer. The inquiry officer, after perusing the contentions urged by the respondent number 1, as well as the contents of the article of the charges of the 7 charges, held that it did not in any way relate to or pertain to misutilization / misappropriation of government funds or examination malpractice, and proceeded to hold an inquiry. Full stop. The review authority who entertained a review petition filed by the respondent number 1, has proceeded to unsettle the appointment of the inquiry officer on the premise that WP number 22800 of 2011 is pending consideration before this court relating to the question whether the director alone is entitled to inquire into the allegations, into the charges framed, and therefore the inquiry has to be conducted by the director in view of Rule 28(3). Full stop. He also held that unless the petitioner amended the order by issuing a suitable corrigendum authorizing the inquiry officer to inquire into 7 charges, the appointment of the inquiry officer made pursuant to the memo dated so-and-so issued by the petitioner is not sustainable. Full stop. Next para. A perusal of Rule 28(2) of the Rules 2006 shows that an inquiry against an employee of a aided institution should in all cases be conducted by the management of the said institution However, when the allegation relates to misappropriation / misutilization of government funds or examination malpractice, it is the director of the pre-university education board who alone is entitled to initiate a disciplinary action and pass an order of penalty against the employee. Full stop. As rightly contended by the learned counsel for the petition, petitioner, of the 15 charges that were framed against the respondent number 1, 8 charges related to the above, and therefore the said charges were given up by the management, and the inquiry was restricted to 7 charges which did not in any way relate to financial misappropriation, misutilization of government funds or examination malpractice. The inquiry insofar as the 8 charges which related to misappropriation, misutilization of government funds and examination malpractice was instituted by the respondent number 2 by appointing a retired district judge. Full stop. Full stop. Who has now submitted a report. Similarly, the inquiry officer who was appointed to conduct an inquiry in respect of the 7 charges which did not relate to so and so funds and examination malpractice, has, after carefully considering the charges, has returned a finding that it did not relate to misappropriation, misutilization, so and so. Full stop. The review authority committed an error of sorts in holding that all the charges had to be inquired into by the direct respondent number 2. Full stop. A perusal of Rule 28.3 shows that 28.3 of the Rules 2006 shows that in all disciplinary proceedings, it is the director who shall be the competent authority to appoint the inquiry officer, either suo motu if the inquiry is ordered by him under sub-rule 2, or on a proposal by a managing committee if the charges are framed by the managing committee. Full stop. In the case on hand, insofar as 7 charges that were framed against the petitioner, the managing committee has not proposed to the respondent number 2 to conduct an inquiry. Therefore, it is the petitioner alone who is entitled to conduct an inquiry and pass and impose the prescribed punishment on the respondent number 1. Full stop. The respondent number 3 therefore committed an error in holding that all the charges had to be inquired by the director. In that view of the matter, the order passed by the respondent number 3 warrants interference and consequently deserves to be set aside. In view of the above, this writ petition is allowed. The impugned order passed by the respondent number 3 dated so and so is set aside. The the petitioner is permitted to proceed with the consideration of the report of the inquiry in the manner known to law and in accordance with law, which shall be done within a period of 3 months from the date of receipt of a copy of this order.
Much obliged.
Inquiry report mele.
Much obliged.
ಅದೇನೋ ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ವಂತಲ್ಲ ಯಾರೋ ಅಲ್ಲ ಇದು ಸೋಮಶೇಖರ್ ಸರ್ ಕಟ್ಟಿದಿರಾ?
No, not me. Your lordship, because they sought the adjournment last week.
Order sheet ಅಲ್ಲಿ ಬರೆದ್ಬಿಟ್ಟು learned counsel for the respondent has paid the cost of ₹5,000 as per the order dated 14/8/2024 and has furnished a receipt. The same is taken on record.
Much obliged.
Yes, sir.
Serial number 80.
ಶಿವರಾಜು MK. ಯಾರು ಹೇಳ್ಬೇಕು? ನಾಗಯ್ಯ? Is not ನಾಳೆ ಇಲ್ಲ ಮಾಡಿ ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ ಅವ್ರು ನಾಗಯ್ಯ ನೋಡಿ ಯಾಕೆ ಚೆಕ್ ಮಾಡಿಸಿ ಯಾಕೆ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಲ್ಲ ನಾಗಯ್ಯ ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ ಈ ಕೋರ್ಟರ್, ಅದಕ್ಕೆ ಲೆಟ್ ಅಸ್ ಗೆಟ್ ಇಟ್ ವೆರಿಫೈಡ್. ಏನ್ ಇದಾರ ಊರಲ್ಲಿಲ್ವಾ, ಹುಷಾರಿಲ್ವಾ? ಲಿಸ್ಟ್ ಟ್ಯೂಸ್ಡೇನಾ? ಟ್ಯೂಸ್ಡೇ. ಕರೀರಿ ಯಾವ್ದು?
List number 2, serial number 1.
I submitted in the morning, they've all retired, so nothing will survive. But my lord, my learned friend just now, my lord, passed on a memo.
Huh? ಆಯ್ತು, but senior counsel is saying that this has become infructuous. Yeah, financial implication ಇದೆಯಾ?
We are seeking super time scale. The officers were promoted by accelerated promotion. They were placed above them. So super time scale has been denied. So that is the issue. We have furnished notes also with citation.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕೇಳ್ತೀನಿ, ಬೇಕಂದ್ರೆ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ. ವಾಟ್ ಎವರ್ ಮ್ಯಾಟರ್ ಇಸ್ ಟೇಕನ್ ಅಪ್ ಟುಡೇ. ಬೆಳಿಗ್ಗೆ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರಿ, ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ದೀನಿ. ವಾಟ್ ಎವರ್ ಏನು ನಾಳೆ 5,000, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 5,000. ಕಾಂಟ್ ಹೆಲ್ಪ್ ಇಟ್ ಸರ್, ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಎಲ್ಲರಿಗೂ ಒಂದೇ ಏಟು. Otherwise, these fine learning matters will remain like this.
Is not to seek an adjournment, but his interview court was there.
ಇಲ್ಲ 5,000 ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ. ಇಲ್ಲ ನೀವು ಶುರು ಮಾಡಿ ಹೋಲ್ಡ್ ದ ಫೋರ್ಟ್ ಫಾರ್ 2.5 hours, no cost. But if you want to adjournment, 5,000 ಆಯ್ತು ಮಾಡಿ ಕೊಡಿ. Yes. ತಿರುಗೇ ಇಲ್ಲ ಏನ್ ಡಬಲ್ ಕೊಟ್ಟಿರೋದು ಒಂದ್ ಸೆಟ್ ಕೋರ್ಟ್ ಫೀಸ್. Senior will start where you leave. Petitioners sir.
1.1 and only appearing.
1.1. ಕೊಡ್ರಿ. ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡ್ಬಿಡಿ, ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡು. ಹಾ
Working as a senior civil judge and was promoted as a ad hoc district judge fast track on 27/6/2009.
27/6/2009. as ad hoc fast track judge.
On 29/7/2009 by virtue of another notification. Petitioner was made as a regular district judge. After he was promoted as an ad hoc district judge, the first respondent had conducted the examination for accelerated promotion.
ಯಾವಾಗ?
First respondent high court.
ಯಾವಾಗ? Which year at least?
2009 itself.
2009.
subsequently, on 1/7/2009, the respondent 3 to 33 were promoted as district judges. And they were placed above the petitioner in respect of the seniority. The petitioner had also challenged the examination process that came to be dismissed. There is on vision which was on my lord, the
You ready, let us not waste time. You are not ready. Let us not waste time.
act have not been correct.
Finally, ನೀವು ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. You are coming now and saying that facts with 2,000, 5,000, 2,000 to the Advocates Library Fund. This tomorrow.
State of hearing, I would argue myself.
Illa sir. Sorry.
What has happened is that, but I understand I should not be taking an adjournment in 2016 matter. But senior is engaged, he set up in court or
ಏನ್ ಮಾಡ್ಲಿ ಅವ್ರನ್ನು ಪಾಪ ಬೆಳಿಗ್ಗೆ ಅಂತ ಕಾಯಿಸಿದೀವಲ್ಲ ಅವ್ರನ್ನು ಕಾಯಿಸಿದೀವಲ್ಲ ಬೆಳಿಗ್ಗೆ ಅಂತ. He has lost lakhs of money rupees by waiting in the court unnecessarily. ಅವ್ರಿಗೆ ಆಕ್ಚುಲಿ ನೀವು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕು. ಆಯ್ತು ಫ್ರೈಡೆ 2,000 ಕಟ್ಟಿ ನೀವ್ 2,000 ಆಮೇಲೆ ಅವ್ರು ಯಾರು 1.1. ನೀವು ರೆಡಿನಾ? ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯು ಆರ್ ನಾಟ್ ಅಪಿಯರಿಂಗ್. ಮತ್ತೇನ್ ಮಾಡೋದು ಇನ್ನೊಂದ್ರಲ್ಲಿ?
ಅವ್ರು ಯಾರು ಇಲ್ಲ ಬರ್ತಾ ಇಲ್ಲ.
ಮತ್ತೇನ್ ಮಾಡೋದು ಹೇಳಿ? DL ಸಂಜೀವ್, ಸತೀಶ್ ಕೆ, SG ಭಗವಾನ್. Non-filing of wakalat on behalf of all. Kavita. No. Somebody by name Kavita has entered, has agreed to appear. Whom do you represent, madam?
Kavita has represented.
Then we'll dismiss it, Justin.
Please.
There is no representation for the petitioners in WP number 55994 of 2016. Hence the petition is dismissed for non-prosecution. Yes.
Serial number 2.
Kishan GS.
This will come up next week, not or any
Next
date.
Friday.
Please.
These matters will come up only once in a week.
Great.
Kishan GS, MS Devaraj. Huh?
Respondent.
Yes, Devaraj.
In this case, first round ಅಲ್ಲಿ randomous consider ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರೆ ಸರ್ವಿಸ್ ಅವಧಿನಲ್ಲಿ ಸಮ್ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಆಗಿದೆ, ಅಮೌಂಟ್ ಅನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸಮ್ ಅಮೌಂಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮಿಕ್ಕಿದ್ ಕೊಡ್ಬೇಕಲ್ಲ,
ಕೊಡೋದಕ್ಕೆ
ಮಿಕ್ಕಿದ್ ಕೊಡಿ. ಡಿಡಕ್ಟ್ ಮಾಡೋದು ಡಿಡಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಮಿಕ್ಕಿದ್
ಅಲ್ಲ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಮಿಕ್ಕಿದ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಖಂಡಿಸಿದ ಆರ್ಡರ್ ಆಫ್ ದಿ.
No, what he says is within 4 years ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕಾಯ್ತು, ಮಾಡಿಲ್ಲ. ಮಾಡದೇ ಇದ್ರೆ you don't have right to conduct an inquiry. ಹೆಂಗ ಅಡ್ಜಸ್ಟ್ ಹೆಂಗ್ ಮಾಡ್ಕೋತೀರಾ without an inquiry?
One thing, right? It's the annexure header of page number 29. For what reason they have withheld, my lord? They're saying for transit loss, I have been made responsible, my lord. For Punjab ಇಂದ 100 ton ಮಧ್ಯದಲ್ಲಿ 30 tons ಎಲ್ಲ ಲಾಸ್ ಆಗ್ತಿದೆ. I cannot be held responsible for that.
I think your challenge this order annexure H. Purpose.
Initially, they have not challenged, subsequently amendment ಮಾಡಿ challenge ಮಾಡಿದ್ರು.
I think challenge ಮಾಡಿದಾರಲ್ಲ ಒಟ್ಟು. The petitioner has challenged.
My objection may taken on record.
The office order dated 13/7/2023 passed by the respondent number. Passed by the respondent holding that the petitioner is liable for the transit loss which is valued at a sum of rupees 4,26,000. 32,31,137.
One submission, only transit loss on the one, 4 item, one transit loss of rupee April 2014, 4,74,000.
ಆಯ್ತು ಬಂದೆ ತಾಳಿ ಎಲ್ಲ ಟ್ರಾನ್ಸಿಟ್ ಲಾಸ್ ಅಂತಾನೆ ಬರೀತೀನಿ.
ಅಲ್ಲ ಲಾಸ್ಟ್ one storage loss for the so on so storage ಕೂಡ ಅದು ಕೂಡ ಲಾಸ್ ಆಗಿದೆ.
ಆಯ್ತು ಟ್ರಾನ್ಸಿಟ್ ಲಾಸ್
ಗವರ್ಮೆಂಟ್ ಗೆ ಲಾಸ್ ಆಗಿರೋದ್ರಿಂದ
ಬಂದೆ transit loss between 2014, April 2014 till May 2016 and storage loss between 2000 September 2017 and February 2018.
Yes.
Next para. The petitioner has also sought for a direction to the respondent to release the retirement benefits along with interest at the rate of 18% per annum from the date of his retirement till the date of actual payment. Next para. The petitioner contends that he was employed with the respondent as a technical assistant on 30th of August 1997. And after putting in 22 years of service, retired on 31/10/2019. Full stop. Even after 4 years from the date of his retirement, the respondent had not settled the service retirement benefits. Full stop. The petitioner therefore submitted a formal representation. And after 31/12/2021. Retired on 31. Full stop. Since the respondent did not consider the same, the petitioner filed WP number 14766 of 2022, which was disposed of in terms of the order dated 17/3/2023, whereby the respondent was directed to consider the representation dated 31/12/2021. Full stop. The petitioner furnished a copy of the order as well as a copy of the representation dated 31/12/2021. Full stop. Nonetheless, despite the above, however, the respondent released only a sum of rupees 4,26,330. Full stop. The petitioner, being shocked at the paltry sum of retirement benefits released, filed WP number 14766 of 2022. Full stop. ಏನಿದು WP 14766 ಏನಕ್ಕೆ ಹಾಕಿದ್ದು? ಮತ್ತೆ ಏನು?
Only for the mandamus knowledge. Respondent is not upstairs.
ನೀವು ನೆರೇಟ್ ಮಾಡುವಾಗ ನೀವು ಇದು ಡೇಟ್ ವೈಸ್ ಜೋಡಿಸ್ಕೊಳ್ಳಲ್ವ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಹೌ ಡು ಯು ಪ್ರಿಪೇರ್ ರಿಟ್ ಪಿಟಿಷನ್? ಇಲ್ಲೊಂದು ಬಿಸಾಕಿರ್ತ ಅಲ್ಲೊಂದು ಬಿಸಾಕ ತಗೊಂಬಂದು ಜೋಡಿಸೋ ಅಳ್ಳಾಡಿಸ್ಬಿಟ್ಟು ರಿಟ್ ಪಿಟಿಷನ್ ರೆಡಿ ಮಾಡ್ತಿರೋ ಅಥವಾ ಡೇಟ್ ವೈಸ್ ಜೋಡಿಸ್ಕೊಂಡು ರೆಡಿ ಮಾಡ್ತಿರೋ? ಹೆಂಗ್ ಬರುತ್ತೆ ಮತ್ತೆ 23 ಆದ್ಮೇಲೆ 22 ಹೆಂಗ್ ಬರುತ್ತೆ? ಮಿಸ್ಟರ್ ಕಮ್ ಟು ಪ್ಯಾರಾ 6. ನೀವು ಕೋರ್ಟ್ ಮೇಲೆ ಗೌನ್ ತಾನೇ ಹಾಕೊಳ್ಳೋದು? ಗೌನ್ ಮೇಲೆ ಕೋಟ್ ಹಾಕೋತೀರಾ ಅಥವಾ ಕೋರ್ಟ್ ಮೇಲೆ ಗೌನ್ ಹಾಕಂತೀರಾ? ಸೀರಿಯಸ್ ಇರ್ಬೇಕಲ್ವಾ? 23 ಆದ್ಮೇಲೆ 22 ಹೆಂಗ್ ಬರುತ್ತೆ? Go to page 6 and then to page 7. Go to page 7. para 7, sorry. ತಿರ್ಗಾ ಯಾಕೆ ಹೇಳ್ತಿಲ್ಲ 22? ಇಲ್ಲಿ 4 ಲಕ್ಷ ಕೊಟ್ಟರು ತಾನೆ, ಕೊಟ್ಮೇಲೆ ತಿರ್ಗಾ 22 ಬಗ್ಗೆ ಯಾಕೆ ಹೇಳ್ತೀರಾ? Therefore, be precise, mister. 23 ಆದ್ಮೇಲೆ 22 ಯಾಕೆ ವಾಪಸ್ ಹೋಗ್ತೀಯ? ಎ ಆದ್ಮೇಲೆ ಬಿ, ಬಿ ಆದ್ಮೇಲೆ ಸಿ, ಸಿ ಆದ್ಮೇಲೆ ಎ ಬರುತ್ತಾ? After will you get C after? It's left to you. Correct yourself. It's a request. Please correct yourself. ನೀವೇನಾದ್ರು ಡ್ರಾಫ್ಟ್ ಮಾಡುವಾಗ ಒಂದು ಸೀರೀಸ್ ಮೇಂಟೈನ್ ಮಾಡಿ, ಡೇಟ್ ವೈಸ್. Full stop. The petitioner contends that there is no justification for the respondent to release a paltry sum and withhold a large amount of the retirement benefits, that too without conducting any inquiry. Full stop. He contends that he retired on 31/10/2019 and by virtue of Rule 214 of the KCSR rules, the respondent was entitled to conduct an inquiry within 4 years from the date of retirement. And as 4 years have elapsed, the respondent cannot withhold any money belonging to the petitioner. Full stop. During the pendency of this writ petition, the petitioner has amended the writ petition to seek for an order to set aside an order passed by the respondent number 2 dated 13/7/2023, in terms of which, the respondent had purportedly deducted a sum of rupees 32,31,137, being the transit loss as well as the storage loss. Full stop. The petitioner contends that the petitioner cannot be held responsible for the transit loss and also cannot be held responsible for the storage loss unless an inquiry is conducted where it is held that the petitioner is responsible for the same. He therefore contends that this order passed by the respondent may also be set at naught and suitable directions be issued to the respondent to release the retirement benefits. Next para. The learned counsel for the respondent submits that the petitioner was the
objection file ಆಗಿದೆ. Objection file ಮಾಡಿದ್ವಿ.
Objection ಹಾಕಿದಿರಿ?
ಹಾಕಿದ್ವಿ.
Submits that.
para 6 ಅಲ್ಲಿ ಹೇಳಿ.
Submits that the petitioner, while working as the warehouse manager at SWH Bangarpet, had caused financial loss to the respondent as per the audit report dated 30/3/2021. It is contended that there was transit loss of the commodities which were not justified but were abnormal. It is contended that it is a duty of the petitioner to obtain sanction order write-offs from the FCA authorities with justifiable reasons for the transit loss. It is contended that the petitioner did not take any steps in this regard and was therefore directly responsible for the financial loss suffered by the respondent. Full stop. It is contended that a sum of rupees 32,31,137 was the transit/storage loss, and the same was recovered at transit loss. Full stop. It is contended that the Food Corporation of India had recovered a total sum of rupees 21,56,627, being the storage charge bills payable to the respondent. Full stop. Therefore, the respondent had calculated the total loss suffered by it and deducted the amounts from the retirement benefits payable to the petitioner and released the balance sum of rupees 4,26,330. Full stop. It is therefore contended that the petitioner is not entitled to the release of all the retirement benefits. Next para. I have considered submissions made by the learned counsel for the petitioner and the learned counsel for the respondent. The fact that the petitioner retired from service of the respondent on 31/10/2019 is not in dispute. Full stop. The respondent, which had adopted the KCSR rules as well as the KCS bracket CCA rules 1957, was bound to conduct an inquiry into any misconduct alleged against the petitioner within 4 years from the date of the petitioner retiring from service. Full stop. If the respondent has not chosen to take any action, it has lost its right to proceed against the petitioner. Full stop. Therefore, the unilateral action on the part of the respondent in determining the loss suffered by it on alleged acts of misconduct, is not justified. And the full stop. The respondent cannot contend that it had suffered loss and therefore it is entitled to recover it from the retirement benefits of the petitioner. Full stop. In view of the above, the impugned order passed by the respondent deducting a sum of rupees so and so is wholly unjustified and warrants interference. Consequently, this petition is allowed. The impugned order passed by respondent dated so and so, bearing number so and so, is quashed. The respondent is directed to release the retirement benefits of the petitioner in full within a period of 3 months from the date of receipt of a certified copy of this order. If the amount is not released within 3 months, the petitioner shall be entitled to interest at the rate of 12% per annum from the date of his retirement till the date of payment and shall be recovered from the officer responsible for the delay.
Now, my lord, from last 5 years, my lord,
Hello.
due amount has not been released, my lord.
Yes.
It's 5 years, my lord.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಕ್ಚುಲಿ
4 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ಅಲ್ಲ ಈಗ ವಿತಿನ್ 3 months ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ಸೆಕೆಂಡ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
5 ವರ್ಷ
ನನಗೆ ಅಡ್ವೈಸ್ ಕೊಡ್ತಾರೆ ಆಸ್ ಪರ್ ದಿ ಆರ್ಡರ್ ಪ್ರಕಾರ ವಿತಿನ್ 3 months ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಮೇಡಮ್
ಆಯ್ತು.
ಇಂಟ್ರೆಸ್ಟ್ ನನಗೆ ಡಿಫಿಕಲ್ಟ್
ಕೆಲಸ ಮಾಡಿ ಮೇಡಮ್ 9% ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಟಿಲ್
ಅಲ್ಲ
ದ ಡೇಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಅಂತ ಮಾಡ್ಬಿಡಿ. 9% ಕೊಡಿ. Yes, next. 6% ಮಾಡಿ. 9% ಅಷ್ಟು. Yes.
Mood matter 230 mood matter. Fresh
ಅಯ್ಯೋ
matter.
ನಿಮ್ದು ಮಿಸ್ಟೇಕ್ ಇದೆ.
Therefore,
ಡೋಂಟ್ ಸೇ ದಟ್ ನೀವೇನು ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ನಿಮ್ ಮಿಸ್ಟೇಕ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ you're required to obtain appropriate declaration or confirmation or sanction or whatever.
They have only issued circulars saying that corporation cannot be responsible for transit loss. ಅಲ್ಲಿಂದ ಕಳಿಸುವಾಗ ನಾನು ಎಷ್ಟು ಮಾತ್ರ goods ತಗೊಂಡಿನಿ I can write down that.
ಆಯ್ತು, ಎಷ್ಟು ಬಂತು ಎಷ್ಟು ಇಲ್ಲಿದೆ ಅಂತ ರಿಸೀವ್ ಮಾಡ್ತಿರಲ್ಲ, ರಿಸೀವ್ ಮಾಡಿದಾಗ ಸರ್ಟಿಫೈ ಮಾಡಿಸ್ಕೋಬೇಕಲ್ವ? ಹ್ಯಾವ್ ಯು ಗಾಟ್ ಇಟ್ ಡನ್? ಅಲ್ಲಿಂದ ಪಂಜಾಬ್ ಇಂದ ಬೆಂಗಳೂರು ಬರೋಷ್ಟೊತ್ತಿಗೆ ಇಷ್ಟು ಟ್ರಾನ್ಸ್ಮಿಷನ್ ಲಾಸ್ ಆಗಿದೆ, ನಮ್ಮ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಬಂದಾಗ ಇಷ್ಟಿದೆ, ಇದನ್ನ ಸರ್ಟಿಫೈ ಮಾಡಿ ಅಂತ ಕೇಳ್ಬೇಕಿತ್ತು. ಕೇಳಿದಿರ? ಮತ್ತೆ ನೀವ್ ಮಾಡೋದು ಮತ್ತೆ ತಪ್ಪಲ್ಲ, ಅವ್ರು ಮಾಡೋದು ಮತ್ತೆ ತಪ್ಪು. ಎಸ್, ನೆಕ್ಸ್ಟ್.
230 mood matter fresh serial number 1 Akkamadevi Hiremat.
ಪಾಸ್ ಓವರ್ ಎಲ್ಲಿ ಮೇಡಮ್? ಪಾಸ್ ಓವರ್ ಕೊಡಿ, ಯಾವ್ದೊಂದು ತಗೊಂಡಿದೆ ಕಾಸು ಅಲ್ಲೇ ಹೋಯ್ತು. ಇದು ಬಂತು ನೋಡಿ. ಎಸ್, ಕರಿ.
List number 1 for final hearing matter serial number 33 Kiran Kumar.
ಕಿರಣ್ ಕುಮಾರ್. ಕಿರಣ್ ಹೇಳಿ, ಏನಿದೆ? ವಾಟ್ ಇಸ್ ದಿಸ್ ಕೇಸ್? Bill collector. Other side, Vishwanath Kane. Huh? No, what is the relief sought for? Is the unauthorized absence? Nene argument ಇರಲಿಲ್ಲ. ಏನಿದು ಕೇಸು? ಇನ್ನೊಂದ್ಸತಿ ಹೇಳಿ. Please use the mic. 80?
Of Panchayat Act under the old Act of 1983. And he was suspended in the year 2009. That suspension order was challenged by me. And it was allowed. And I was asked to go and join. I was not allowed to join. Again, I make a representation. The EO again directs the Gram Panchayati to take him back. And he also directs to, on deputation, go to another respondent number 4 Panchayat. I work there from June to November. In November, that Panchayat again says that you cannot come here, you have to go back to your original Panchayat. Accordingly, I was relieved from that Panchayat and come here. In the meantime, the Panchayat has filed an appeal. That appeal has been allowed. And I have been dismissed from service at annexure A.
Panchayat filed an appeal against what?
A EO order mele. I was suspended first. I filed an appeal before EO.
That was allowed.
That was allowed.
Adin challenge ಮಾಡಿದ್ರ?
Adin challenge ಮಾಡ್ತಾರೆ ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ. In the meanwhile, I filed a writ petition also. I read the writ petition order also yesterday. Wherein I was not given any wages. I was not allowed to work also on the ground that my place has already been filled up.
What happened to the writ petition?
Writ petition was allowed. Annexure C.
Yes. Writ petition file ಮಾಡಿದ ಯಾದ್ರ ವಿರುದ್ಧ?
They were not giving me the salary. 6 months period though, salary ಕೊಟ್ಟಿರಲಿಲ್ಲ ಮತ್ತೆ ನನಗೆ ಕೆಲಸ ಮಾಡಕ್ಕೂ ತಗೋತಾ ಇರಲಿಲ್ಲ. Panchayat or because they say that somebody has been appointed.
You came before this court.
ಅದಕ್ಕೆ I came before the court. The court has directed the respondent, Panchayat, to take back and also pay the wages.
Yes.
ಈ ಆರ್ಡರ್ ವಿರುದ್ಧ ಅವರು to nullify this order.
The petitioner has challenged an order dated 2/1/2012 passed, 4/1/2012. ಇದು 4/1 ಅಂತಿದೆ, 2/1/2012 ಈಗ ಆದೇಶವನ್ನು ಘೋಷಿಸಲಾಯಿತು ಅಂತಿದೆ. Order bearing number so and so dated 4/1/2012 passed by the respondent number 1. By which the services of the the resolution of the respondent number 3 dated 17/2/2011 was upheld, and the petitioner was and the order terminating the service of the petitioner was upheld. Next part. The petitioner was appointed as a bill collector on 1st of January 1988. Full stop. Under the provisions of the Karnataka Panchayat Raj Act 1983, Karnataka Jilla Panchayats, Taluk Panchayats, and Mandal Panchayats and Nyaya Panchayats Act 1983. Full stop. While so working as the bill collector, the president of the respondent number 3 kept the petitioner under suspension on 15/1/2009 in exercise of the power under section 62 of the Act 1993. So feeling aggrieved with the said order, the petitioner filed an appeal before the respondent number 2 in appeal number 5/2008-9. Full stop. The respondent number 2, after considering the contentions urged by the petitioner as well as the respondent number 3, allowed the appeal in terms of the order dated 15/12/2009 and directed the respondent number 3 to reinstate the services of the petitioner. Full stop. This was followed by a letter dated 19/12/2009 addressed by the respondent number 2 to the respondent number 3, directing the respondent number 3 to take back the petitioner to work. Full stop. Despite the above, the respondent number 3 refused to accept the services of the petitioner till April 2010. Full stop. The respondent number 2 therefore again addressed a letter dated 26/4/2010, directing the respondent number 3 to reinstate the petitioner. Full stop. It was only on 27/4/2010 that the petitioner was permitted to resume duties at the respondent number 3. Full stop. When things stood thus, the respondent number 2 passed an order dated 30/4/2010 deputing the petitioner as a bill collector at the respondent number 4. Consequent thereto, the petitioner reported to duty at the respondent number 4 and worked there till April 2010. However, on 20th of November 2010, the respondent number 4 passed a resolution to return the services of the petitioner as he was not a localite, as he was not a person residing within the limits of the respondent number 4. Full stop. The petitioner was therefore repatriated to the respondent number 3. Full stop. He was relieved from duties at the respondent number 4 and reported to duty at the respondent number 3. However, the respondent number 3 addressed a letter to the respondent number 4 that the power to repatriate the services of the petitioner lay only with the respondent number 2, and hence the resolution of the respondent number 4 cannot be valid. Full stop. Based on this, the petitioner was again not permitted to report for duty at the respondent number 3. Full stop. The petitioner, therefore, left with no other remedy, approached the respondent number 2 for appropriate orders. In the meanwhile, the respondent number 3 passed an order dated 9th of February 2011, directing the respondent number 2 passed an order dated 9/4/2011, directing the respondent number 3 to take back the petitioner to duty. Nonetheless, the respondent number 3 refused to permit the petitioner to resume his duty, which forced him to submit a representation dated 19/2/2011. Full stop. He contends that the respondent number 3 never paid the salary to which the petitioner was entitled to. Though, when the petitioner was serving the respondent number 4, the salary was paid by the respondent number 3. But after the deputation to the respondent number 4, the respondent number 3 had stopped paying the salary to the petitioner. Therefore, the petitioner contends that he was neither allowed to work as a bill collector nor was salary paid to him. Full stop. The petitioner therefore approached this court in WP number 11219 of 2011, seeking for a direction to accept his services, a direction to the respondent number 3 to accept his services and also to pay the salary and arrears. Full stop. This court in terms of the order dated so and so allowed the writ petition. Allow it, allowed the writ petition and order dated 18/7/2011 allowed the writ petition directing the respondent number 3 to accept the services of the petitioner and to settle a due still to that. And the respondent number 2 was directed to issue appropriate direction to the concerned panchayat was liable to pay the salary arrears of the petitioner. Full stop. Next para. Petitioner contends that in order to harass him, the respondent number 3 challenged the order passed by the respondent number 1.
2. You order ಮಾಡಿದ್ನ
ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಅದನ್ನ
ಗ್ರಾಮ ಪಂಚಾಯತ್ R1 ಮುಂದೆ
before the respondent number 1. Challenge the order passed by the respondent number 2 before the respondent number 1. Who
earlier revocation of suspension order was challenged before R1.
ಇದೇನಾಯ್ತು appeal ಏನಾಯ್ತದು? What happened to the appeal?
Appeal was allowed. ಅದೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
But ಇದು we challenge the order passed by the respondent number 2. Full stop. The respondent number 1 has passed the impugned order terminating the services of the petitioner on the ground that the petitioner did not possess the requisite qualification to hold the post of bill collector and that he was involved in several cases of forgery and criminal activities and was an accused in crime number 169/2003 and PCR 12/2009. Full stop. The respondent number 1 thus passed an order upholding the order of suspension of the petitioner dated 17/2/2011 and consequently terminated the petitioner from the services of the petitioner of the respondent number 3. Being agreed with the said order, the petitioner is before this court. Next para. An objection ಹಾಕಿದಾರಾ?
ಹಾಕಿಲ್ಲ sir.
The respondent number 3 has contested the writ petition and claimed that contended that the respondent number 2, in terms of the order dated 26/4/2010, had set aside the order of suspension without taking it into confidence and without following the principles of natural justice. Contended that the respondent number 2 unilaterally held that the petitioner had not committed any act committed any acts alleged against him and blindly ordered reinstatement, blindly set aside the order of suspension and directed restoration of his services at the respondent number 3. Full stop. It is contended that the services of the petitioner were deputed to the respondent number 4, who also was not willing to accept the services of the petitioner and therefore sent him back to the respondent number 3. Full stop. It is contended that the petitioner is involved in several criminal cases and therefore is not a desirable person to continue in the services of the respondent number 3. It is contended that the respondent number 3 has already appointed another suitable candidate who is discharging her duties punctually. It therefore contended that it was advised to challenge the order passed by the respondent number 2 and the respondent number 1, after considering the track record of the petitioner, held that the petitioner was not entitled to, was not qualified to hold the post of bill collector, and besides was also accused in several criminal cases and was therefore not a fit person to be continued as a bill collector in the respondent number. Next, for learned counsel for the petitioner as well as the learned counsel for the respondent number 2, respondent number 3, reiterated the above contentions and contended that the petitioner is not entitled to continue as the bill collector at the respondent number 3. Next, I consider submissions made with them so on. Next para. The petitioner was suspended from service on 15/1/2009, which was set at naught in an appeal filed before the respondent number 2 in appeal number 5/2008-2009. Full stop. The respondent number 2 directed the respondent number 3 to restore the services of the petitioner. Full stop. After a protracted process, the petitioner was taken back into service by the respondent number 3. In the meanwhile, the respondent number 2 deputed the petitioner to the respondent number 4 to work as a bill collector, and the petitioner worked in the respondent number 4 from April 2010 to November 2010. Full stop. When things stood thus, the petitioner was the respondent number 4, refused to continue the service of the petitioner on the ground that he was not a person residing within the limits of the respondent number 4 and was therefore not conversant with the residents. Full stop. The respondent number 3, which was supposed to accept back the services of the petitioner, claimed that the order returning the services of the petitioner by the respondent number 4 was improper and invalid. Full stop. The petitioner was therefore constrained to report back to the respondent number 3, which however was not accepted by the respondent number 3. Full stop. The respondent number 3, long after the petitioner retired, had resumed duty, challenged the order passed by the respondent number 2, by which the order of suspension was set aside. So the respondent number 1, instead of restricting the examination to the question whether the suspension was just and proper, proceeded to terminate the services of the petitioner without following the due process of law. Therefore, due process of law, full stop. It is seen that The petitioner was appointed as a bill collector in the year 1983. When the appropriate rules, what do you do? When the appropriate rules, namely the Gram Panchayat, Karnataka Gram Panchayat staffing pattern and pay scale and procedure for appointment of employees rules did not prescribe that a bill collector should possess a pass in SSLC. Full stop. This apart, comma, when once the petitioner was appointed petitioner was appointed against a sanctioned post through the regular process, comma, the respondent number 1 could not have terminated the services of the petitioner without conducting an inquiry in the manner provided under the provisions of the Karnataka Panchayat Raj Act 1993. In that view of the matter, the impugned order passed by the respondent number 1 warrants interference. Consequently, this petition is allowed and the impugned order is set aside. The respondent number 1, 2 are directed to ensure that the services of the petitioner are restored in the respondent number 3.
Retired. Superannuation back wages.
Notionally, and award all consequential benefits in accordance with law. The same shall be complied within a period of 3 months from the date of receipt of a copy of this order. Cost and ಕಟ್ಟಿದಿರಾ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರೆ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟು ಆಯ್ತಾ? A1 or 2 of 24 are recalled and ಎರಡು ಅಲೋ ಮಾಡಿ ರಿಕಾಲ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್
34 urgent serial number 35 M Nagarajan.
M Nagarajan.
This not a petition. Not in this matter, challenging the validity of the rule of the special court's conditions of service. Not that may. There may proceed not. It may take some time, 10 to 15 minutes. Like.
ಮಾಡ್ತೀರಾ ಈಗ ಇಲ್ವಾ?
ಮಾಡ್ತೀನಿ ಸ್ವಲ್ಪ ಟೈಮ್. Unless it is convenient to your lordship.
Ready?
If they start, AAG will answer it. Next.
Yes, madam.
He will answer next statement.
Next date and
Tuesday.
Shall we proceed?
ಮಾಡಂಗಿರ
Yes, sir. Yes, under the provisions of the Karnataka Land Grabbing Prohibition Act 2011, a special court was constituted not conduct rules. Rule 8 under the provisions of Rule Section 18, the source of power, they framed the rule condition of service of the chairman and the members of the special court.
Yes.
The special court consists of the chairman, who is a high court judge, retired high court judge, and the members of the judicial members are either a serving district judge or retired district judge. The revenue members are a All India service officer who is serving or a retired serving. Or retired judicial member, retired district judges, they were appointed as judicial members. Petition number 3 is a All India service officer, revenue officer issued that. Now, why the annexure F, page number 43, that page number 43, a rule called the Karnataka Land Grabbing Prohibition Special Court Condition of Service and Chairman 2017 came to be issued on 27/2017. Now, as per this rule, that the pay for a retired, pay for a judicial member is fixed at rupees 1,50,000 minus pension he is receiving. Now, when things stood just when the rule was and the rule 11 of the page number 45, what are the allowances what they are entitled? That is prescribed on par with the members of the Karnataka Administrative Tribunal. Now, when things stood just that, and they issued a GO. The government issued a GO under Article 162 of the Constitution of India, dated 17/4/2017. It is wrongly printed as 70, this to 17 for 2018, not page number 40, annexure G. I have challenged this GO when the rule is occupied by a rule, when the field is occupied by a rule, court cannot, the government cannot issue a GO.
What is the GO? What does it say?
Yes, the GO says that not that instead of this 1,50,000, my pay is fixed on as per the last pay drawn when I was holding the post before my retirement, minus pension. Original, or as per the rule, the pay is fixed 1,50,000, special amount, minus pension what I was receiving. Under the GO,
Is it a case of re-employment or fresh employment?
it's not a re-employment, that's right. It's not, it can't be re-employed. It is, you will not may kindly see that how the appointment shall be made.
It's a case of fresh employment.
It is a fresh appointment. It is not re-employment. They cannot invoke, they invoke rule 313B of the whether for the purpose of issuing the GO, then now this GO not again resulted in amendment of the rule. That is annexure P and Q. Annexure P. So the facts are undisputed, not that.
ಇಷ್ಟೇನಾ ಕೇಸು?
1,50,000 ನಾನು change ಮಾಡಿ whether for that the reason assigned by them in the reply is rule 313 of the KCSR. Now can they invoke rule the main question that in your reply filed by them, Lord, that the main question that arises for your lordship kind consideration is whether for the purpose of issuing the amendment rule, can they invoke the provisions of KCSR? Your lordship may kindly refer to the applicability of the KCSR under rule 2. Rule 2 formula, please. Rule 2 deals with the application of these rules, not please.
Yes.
Rule 2 formula, you will also may kindly come to 4. 1, 2, 3, 4. 4 is applicable. Persons for whose appointment and other matters covered by these rules, special provisions are made by or under any law for the time being in force or any contract in regard to the matters covered by such rules or such contract. These rules of the condition service are passed in exercise of the power conferred under section 18 of the land grabbing prohibition code. So therefore, one of my main conditions, they cannot refer to this rule. For the purpose, KCS 313, KCS re-employment, they cannot apply this rule that only on that for one of the main conditions that goes wrong. The other condition is that if an amendment is made, how that amendment shall be effected, that rule condition of service that is prohibited, that is also said under section 18 of this act.
Land grabbing.
Section 18 of the act, section 18 Karnataka land grabbing prohibition.
Land grabbing prohibition rules.
Prohibition act.
Act.
Section 18.
Yes.
That confers power upon the government to make rules, that power to make rules, subsection 2, that every rule made under this rule shall immediately after it is made be laid before the house of the state legislature if it is in session, and if it is not in session, in the session immediately following for a total period of 14 days, which may be comprised in one session or in two successive sessions, and if before the expiration of the session in which it so laid, or the session immediately following both houses agree in making any modification in the rule or in the annulment of the rule, the rule shall from the date on which the modification or annulment is notified have effect only in such modified form or shall stand annulled as the case may be. So however, that any such modification or annulment shall without prejudice to the validity of anything previously done under this rule. Now, my lord, the last, I'm placing emphasis on the last part, without anything validity on the done under these rules. And by the present amendment rule, they give retrospective effect to this, my lord. Annexure Q, you will also make kindly this annexure Q. Annexure Q, page number 74 of the amended petition, I filed a copy of this. I filed this because I brought out an amendment. I'm sorry, Milord, that amended copy of the petition I filed that.
Annexure Q, no?
Annexure Q, Milord, page number in page 74. Well, now the amended rule is annexure P, Milord. Then they issue a corrigendum to that, categorically mention that in notification number so and so, they shall come into force from the date of their publication in the official gazette. The words and figures, these rules shall deem to have come into force from the date on which the chairman and members have assumed charge of the office of the Karnataka Land Grabbing Prohibition Special Court shall be substituted. Your Lordship is well aware, substitution relates back to the commencement of the rule. Now, in view of the section 18, as proposed, can they amend the rule which has been already done? So mainly of my two contentions, my lord, is that
no, you can't say the rule can't be amended.
Rule can be, they have the power. I don't come in, the rule can be amended. I'm not coming there. Rule is amended, but what is the source of power of the rule is that under section 18 of the Act. Section 18 of the Act, they say that no amendment can effect to things which has been already been done.
Your argument is that this could not have been given effect from a retrospective date.
Retrospective, it can't be done. Then second thing is that their main contention is under Rule 313 of the KCSR. It is re-employment. Can it be called as re-employment?
What are the service rules which govern these officers?
Service commission.
What are the service rules?
This is what are their qualifications, how they shall be appointed. That is provided in section 7 of the Act.
There are substantive provisions. What about the service rules relating to these officers who are appointed to the tribunal? Or service rules and pay, leave, allowance,
Service rules are in the same system. Allowance will be annexure FLE. Annexure F, they say that the service rule, what are the other allowances they are entitled than annexure F, page numbers. Additional perquisites, page number 45, Lord, in page 45.
Discipline rules, which are the discipline rules and idea?
Discipline rules, discipline rules, there is no separate discipline.
Which will, you must fall back upon some rules.
That's service conditions of this rule.
These conditions are there, sir, but how service, rules have they relating to leave, allowances,
everything is provided under the annexure F, Lord. Annexure F, that is the rule which is originally framed.
Sure.
Which is called, these rules may be called like Karnataka Land Prohibition Special Court Condition of
provide, sir. What does it provide? What does it provide?
Yes, Rule 2 provides the definition last. Rule 3 pay. How the pay of the chairman, members of the revenue members and the judicial members shall be paid. Rule 4 deals with leave.
Rule 4 deals with leave.
Leave. Page number 44. Rule 5, leave sanctioning authority. Rule 6, leave travel concession. Rule 7, traveling allowance and daily allowance. Rule 8, subscription to general provident fund. Rule 8, medical reimbursement. Rule 10, official car and telephone facility. Rule 11, additional perquisite. During the term of office of the chairman and the members of the special court, the chairman and member shall be entitled for the following perquisites, namely sumptuary allowance, free water and electricity, co-model allowance, guidance and allowance, governance allowance, five newspapers and journals as applicable to chairman and members of the Karnataka Administrative Tribunal. Now, under the amendment rule, this has been done. This has been already done. This is by.
Yes, Mr. AG.
Please, my lords, in this matter, if my lords may see, in the land, page 34, my lords. Rule section 18, my lords. Power to make rules. The government may by notification after previous publication make rules for carrying out the purpose of this act. Now kindly see, my lords, 2 is not applicable. Every rule made under this section shall immediately after it is made be laid before each house of the state legislature if it is in session, and if it is not in session, in the session immediately following for a total period of 14 days, which may be comprised in one session or in 2 successive sessions. And if before the expiration of session in which it is so laid or the session immediately following, both houses agree in making any modification in the rule or in the annulment of the rule shall, from the date on which the modification or annulment is notified, have effect only in such modified form or shall stand annulled as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule. This applies only if, after the rule is made, if it is placed before the legislature, and my lords, there is any changes that legislature seeks to make between the operation of the rule and the change, my lords, that is made by the legislature, if there is anything done, that cannot be, that is the purport.
Correct, but when, how can you take back the salary that is fixed?
No, my lords, what happened was, kindly see, my lords, I'll just point out, page 43, my lords may come to page 43. Immediately after the Land Grabbing Act, my lords, was
43, no?
43. And amended, my lords, have annexure F, my lords.
Yes.
Annexure F. My lords, this was the rules. I'll just, my lords, title and commencement. These rules may be called the Karnataka Land Grabbing Prohibition, Special Code, Conditions of Service of Chairman and Members Rules 2017. Now, kindly see, my lords, Rule 3 is what is in issue. The chairperson, if he is serving judge, shall be paid a salary and other admissible allowances equal to the salary and allowances of a sitting judge of the High Court. If he is a retired judge, he shall be paid a salary and other admissible allowances equal to the salary and allowances of a judge of a High Court. 2, my lords, and 3 we are concerned with because they are revenue members and judicial members. A member who is a serving judicial member, district judge, he shall be paid salary drawn in the cadre of district judge immediately before his appointment as such. In case of retired district judge appointed as such, he shall be paid a pay of rupees 1,50,000 per month after deduction of pension he is drawing out of the said pay. 3. In case of a serving revenue member who is an All India Service Officer, he shall be paid the salary drawn in the post held by him immediately before his appointment as member. In case a retired officer is appointed as revenue member, he shall be paid a pay of rupees 1,50,000 per month after deduction of pension he is drawing out of the said pay. Provided that if the chairperson or a member at the time of his appointment is in receipt or being eligible to receive any pension, has elected to draw or receive the pension other than disability or invalid pension in respect of previous service as a judge of a High Court or district judge or an All India Service Officer in the service under the state, as the case may be, his salaries in respect of the service as chairperson or member of the court, as the case may be, shall be reduced by the amount of that pension and the pension equivalent of gratuity. The dearness allowance admissible on the pension shall be kept in abeyance during the period he hold the post of chairperson or member, as the case may be. He shall be entitled to dearness allowance, HRA and CC admissible from time to time as per rules on the pay admissible as allowed. Now, my lords, to this rule, once we, my lords, constituted the land grabbing court, my lords, judicial member, my lords, as well as administrative members were appointed. Yeah. Then immediately there was an objection, my lords, with regard to this on the ground, my lords, that it is leading to disparity, my lords, of pay of the administrative members and the judicial members. Then, my lords, at that point in time, my lords, they were the pay and allowances were not settled. Then, my lords, kindly see next page, page 46. Till this government order was issued, page 46, my lords, at page 47 is operative portion.
No, what is the date of these rules?
This rules is dated 27/2017. My lords, this is actually 17/4/2018, my lords.
Yeah, 17th is July.
Alla 17 alli that's a typo. My lords, on the right side 48 alli signature atra date is. It's a typographical error. Lords, this was subsequent to the
Lords, after the rules came into force, the pay and allowances, my lords, were not settled. It was kept in abeyance, in fact. And my lords, kept in abeyance in the sense it was not given effect to, because there was an objection also with regard to how these pay and allowances have to be regulated. Now, government, what it did was, it issued a government order, my lords, on 17/4/2018. It said this: ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಸುವರ್ಣ ನಿಷೇಧ ನ್ಯಾಯಾಲಯದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಮಾನ್ಯ ಸದಸ್ಯರುಗಳವರು ಸೇವಾ ಅವಧಿಯಲ್ಲಿ ಪಡೆಯುತ್ತಿದ್ದ ಅಂತಿಮ ಮೂಲ ವೇತನ, ಪರಿಷ್ಕೃತ ಕಾಲ್ಪನಿಕ ವೇತನ ಮತ್ತು ನಿವೃತ್ತಿ ವೇತನದಲ್ಲಿ ಇದರಲ್ಲಿ ಪಡೆಯುತ್ತಿರುವ ನಿವೃತ್ತಿ ವೇತನ ಮತ್ತು ಸೋಅನ್ನು ಕಡಿತಗೊಳಿಸಿ ಪರಿಷ್ಕೃತ ಮೊತ್ತ ಹಾಗೂ DA ಸೋ ಇತರ ಭತ್ಯೆಗಳನ್ನು ನಿಯಮಾನುಸಾರ ನಿಗದಿಪಡಿಸಿ ನೀಡಲು ಮಂಜೂರು ಮಾಡಿ ಆದೇಶಿಸಿದೆ. So this government order, my lords, was brought about pending an amendment only in order to facilitate, my lords, that payments could be made. In fact, my lords, I have statistics. I'll just pass on, my lords, how much all of them, my lords, have completed their term now. All the 3 petitioners. And what was paid from day one, my lords, in terms of this government order only was paid. It was never paid, my lords, on the basis of the earlier rules. Then, my lords, what happened was a rule we brought about, my lords. Then they filed a writ petition challenging this government order, stating that this government order, that they should be paid in terms of the rule and not the government order. During the pendency of the writ petition, my lords, the rule has, kindly see, my lords, the impugned rule, which is at page number 69.
72, my lords.
Draft rule, 76.
72. 72, my lords, amendment of Rule 3. In the Rule 3 of the Karnataka Land Grabbing Prohibition Special Court Conditions of Service of Chairman Members Rules 2017, in Sub-Rule 1 for the words, if he is a retired judge, he shall be paid a salary and other admissible allowance equal to the salary and allowance of a judge of a high court. The words, brackets and letters. If he is a retired judge, he shall be paid the last pay drawn in the service, revised notional pay and pension if any, minus pension revised if any, and PEG with admissible allowance like DA, HR and CCA thereon shall be substituted. In Rule 2 for the words, figures and brackets, he shall be paid a pay of rupees 1,50,000 per month after deduction of the pension he is drawing out of the pay. The words, brackets and letters, he shall be paid the last pay drawn in the service, revised notional pay and pension if any, minus pension revised if any, and PEG with admissible allowance like DA, HRA and CCA thereon shall be substituted. In Sub-Rule 3 for the words, figures and brackets, he shall be paid a pay of rupees 1,50,000 per month after deduction of pension he is drawing out of the said pay. The words, brackets and letters, he shall be paid the last pay drawn in the service, revised notional pay and pension if any, minus pension revised if any, and PG with admissible allowance like DA.
This is applicable only if it's a case of reappointment.
Lords,
how can it be if it's a fresh appointment?
Please, my lord.
How can you say that I'll apply the amended
in respect of all tribunals, even my lords, in respect of consumer courts, in respect of all the tribunals, my lords, even administrative tribunals, the standard, my lords, we have 2 kinds of members, that is administrative members, judicial members, even with regard to the administrative tribunals. In so far as the pay and allowances is concerned, my lords, anything that he is actually drawing, the last drawn pay, because even appointment, my lords, is an administrative member is a person, my lords, who has served in an
no, but who appoints these people?
My lords, under the act itself, my lords, the state government.
The state government.
The state
but
government.
What about the district judges?
Lords, the state government itself. My lords, there are 2 kinds of, here we have administrative members, judicial members. I'll just give an analogy, my lords, with regard to the administrative tribunal, the Karnataka state administrative. The selection committee there, my lords, comprises, my lords, of the Chief Justice, and it is to be in consultation with the Chief Justice. And my lords, in so far as
who appoints?
State government. Appointment is by the
case
state.
in the case of members of the tribunal.
Please, my lords.
The land grabbing prohibition tribunal.
Please.
The appointment is made by the state.
Please.
By the state government.
By the state government, but these are all, my lords, specially.
How do you say it's a case of reappointment?
No, my lords, in so far, conceptually, my lords, kindly see, my lords, the act itself for a moment. Kindly see, my lords, the act. Who is to be appointed as the member?
I think the same question arose for consideration in another case.
Lords, in fact, I have the statistics which show, my lords, that all the members, both administrative and judicial, my lords, from the date.
Very same issue as arranged for consideration.
Please, my lords.
Yadav one case where question whether it was a case of reappointment of a district judge or it's a case of fresh appointment was considered.
I will.
ಯಾವ್ದು ನೋಡಿ check
I look
ಮಾಡಿ.
into
We'll
that.
check it.
Sorry, I did not do that. I look into that.
You're ನೀವು ನಾಗರಾಜನ್ ಅವ್ರು ಎಲ್ಲ ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ, ಅದು that question you are not.
ನಾವು ಕೇಸ್ ಇಲ್ಲ ಪ್ರಾಕ್ಟೀಸ್
ಇಲ್ಲ,
ಮಾಡುವಾಗ ನಮ್ ಜೀವನನ ಹಾಳು ಮಾಡ್ಬಿಡ್ತಿದ್ರಿ ನೀವು ಎಲ್ಲ ಕೇಸ್
ಹಾಗೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಹಾಗೆ ಇಲ್ಲ. ಇದರಲ್ಲಿ
ಎವ್ರಿ ಪಾಯಿಂಟ್ ಯೂಸ್ ಟು ಪುಲ್ ಔಟ್ ಒನ್ ಜಜ್ಮೆಂಟ್.
ಇಲ್ಲ, it is only.
ಅದ್ ನೋಡಿ, the law is
Really?
settled. I remember distinctly, I remember in respect of an appointment to a tribunal, the question whether it's a case of reappointment or a fresh appointment is already considered and settled.
We'll place it before my lords. I'll just.
It's already settled, ನೋಡಿ. ಸಾಹೇಬ್ರನ್ನ ಕೇಳಿ ಹೇಳ್ತಾರೋ.
One more submission, not that only one submission. An identical question arose before the Andhra Pradesh High Court. High Court. They said that not that of course not, there was no order on merits, and the Chief Justice of the High Court held that. When the matter is pending, it's the registrar of the High Court, the Special Court raised the issue. They reduced the pay. Same thing has been done. Ultimately, when the matter was issued from the High Court, why, on what basis you have done it, means that they have changed, restored the original rule, 1,50,000.
I think it must be the Human Rights Commission ಇರ್ಬೇಕಂತ ಚೆಕ್ ಮಾಡಿ.
I'll check it.
But it is settled.
The judgment, one of the Andhra Pradesh High Court judgment, I may be permitted to place it.
ಯಾವತ್ತು ಅಂತ ಹೇಳಿ.
Please, next week.
ಯಾವತ್ತು?
It's Wednesday or second minutes. Yes.
Yeah, second.
ನೋಡಿ ಯಾವತ್ತು?
Second.
Second.
ಇಲ್ಲ, that is not in respect of ಇದು ಕಮಿಷನ್ ಅಲ್ಲ. It's a commission of inquiry.
Please.
It's
Under the Commissions of Inquiry Act.
Commission of Inquiry Act ಅಲ್ಲಿ it is settled.
Please
have a look at it.
I'll have
Only one submission. Under the Commission of Inquiry, it is only commission. That is not a court alone.
So therefore, the question in that case was whether the officers appointed in a commission were erstwhile members of a what do you call
Reappointment or
whether
fresh
it's a case
appointment.
of reappointment ಅಥವಾ fresh appointment ಅಂತ ಕನ್ಸಿಡರ್ ಆಗಿದೆ.
Commission of Inquiry.
ಕಮಿಷನ್ ಆಫ್ ಇದಲ್ಲಿ
Please.
Two.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ.
Second is too long.
No. Next week there is some.
ನೀವು ನೋಡ್ಕೊಂಬನ್ನಿ ಸರ್, ನೋಡ್ಕೊಂಬಂದ್ ಸೆಕೆಂಡ್ ಒಳಗೆ ಏನ್ ಟೂ ಲಾಂಗ್ ಏನಿಲ್ಲ, ಎಲ್ಲ ರಿಟೈರ್ ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇನು.
ಇಲ್ಲ, ರಿಟೈರ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಪಾಪ ಅವರೆಲ್ಲ ಇದು ವರ್ಕ್ ಮಾಡಿದ್ವಿ. 2018 ನಾನು ಮಾಡಿದ್ದೆ ಇದು. You asked me kindly see the order sheet, how many times it was heard? More than 15 times it was ultimately.
6 ವರ್ಷ ಆಗಿದೆ, 6 ದಿನದಲ್ಲಿ ಏನಾಗುತ್ತೆ?
ಏನಾಗಲ್ಲ, ಪ್ಲೀಸ್.
ಸೆಕೆಂಡ್
Please.
ಗರೇಟ್ಫುಲ್. 230 ಕೊಡಿ.
230 men.
The matter pertaining to.
ಯಾರು ಸೋಮಶೇಖರ್ ಅಂತ ಇಲ್ವಲ್ಲ, ಅವ್ರೆ 230 ಯಾವ್ದೋ ಮೂವ್ ಮಾಡಿದ್ರು ನಿಮಿಷ.
Amendment copy on
the transfer of autonomous institution, annexure A and B. Annexure A is a transfer order, my lords,
Yes, madam.
from Chamarajanagar Institute.
I didn't get you. Please come back.
Yes, my lords, annexure A
Ah.
is a transfer order at page number 25, 24.
Annexure ಏನು?
Annexure A 24.
Ah.
This is Dr. Shivanda, my lord. She is associate professor. He has been now transferred midway in the during the academic year to Atal Bihari Vajpayee Institute in Bangalore. My lords, this is in violation of again, my lords, transfer guidelines which have been set out by the government that I have produced even as in violation of bylaws of the institute. Kindly see, my
Who are
lords.
you? You are Krishnamurthy.
I am Krishna. Yes, my lords. Now my promotion is due. As per the guidelines, my lords, they cannot bring in someone and block my promotions, my lords. Promotion to the next post. There is only one vacant post now, associate professor, and
Really?
he has been blocked. He has been brought here and he is transferred and he has blocked my promotion. Therefore, my lords.
Similar question was.
Yes, my lords.
that
Your
case
lordships
also.
heard. Yes, my lords. It is happening, my lords, without even NOC from both the institutions. In fact, the guidelines at annexure, kindly see, my lords, annexure J, page number 77. These are all backdoor transfers, my lords. They get appointed in some institution, autonomous institution, and they want to come to the prominent cities and blocking promotions of the doctors who are due for promotion. Kindly see, my lords, page 77 and annexure J. My lords, in the preamble itself, it is very clearly given, my lords. that they have to follow the conditions. Kindly see, my lords, relevant clause is at 79 page number. At the bottom, my lords, point number 2, ಈ ವರ್ಗಾವಣೆಗೆ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರಗಳನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಸಂಸ್ಥೆಗಳ ಆಡಳಿತ ಮಂಡಳಿಗಳ ಪೂರ್ವಾನುಮೋದನೆಯನ್ನು ಪಡೆದು ನೀಡತಕ್ಕದ್ದು, which is in violation. Again, at page number 80, clause 6, ನ್ಯಾಷನಲ್ ಮೆಡಿಕಲ್ ಕಮಿಷನ್ ನಿಯಮಾನುಸಾರ ಯಾವುದಾದರೂ ಹುದ್ದೆಗಳಿಗೆ 2 ವರ್ಷದೊಳಗೆ ಪದೋನ್ನತಿಗೆ ಅರ್ಹರಿರುವ ವೈದ್ಯರುಗಳು ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಇದ್ದಲ್ಲಿ ಅಂತಹ ಹುದ್ದೆಗಳಿಗೆ ಬೇರೆ ಸಂಸ್ಥೆಗಳಿಂದ ಯಾವುದೇ ವರ್ಗಾವಣೆಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸುವ ಪ್ರಸ್ತಾವನೆಗಳಿಗೆ ನಿರಾಪೇಕ್ಷಣಾ ಪತ್ರಗಳನ್ನು ನೀಡುವಂತಿಲ್ಲ. Not only getting NOC is compulsory, that is compulsory, my lords, but they
Where
cannot
have you
give,
said that the NOCs are not received or not issued? ಎಲ್ಲಿ ಹೇಳಿದಿರ?
grounds ಅಲ್ಲಿ ಹೇಳಿದೀನಿ.
ಎಲ್ಲಿ ಹೇಳಿದಿರ?
Yes, my lords.
Where have you said that your department or your hospital has not issued NOC?
Both, my lords,
Ele?
page number
Some-
19. Page number 19, my lords. The transfer is effected without obtaining NOC from both the institutions, which is in violation of transfer guidelines. At para 727 in my petition, my lords. There is no NOC issued by both the institutions. In fact, before that itself, they are supposed to take NOC from both the institutions, my lords.
He's coming in as assistant professor.
He is assistant professor. He is now due for promotion to associate professor,
No,
which
but
is
he's
only
not-
one
The
post.
transfer is associate professor or assistant professor?
No, transfer is associate professor has come now here and he has blocked my post, my promotion to that post. He is associate professor, my lords. He is.
ಶಿವಣ್ಣ ಸಹ ಪ್ರಾಧ್ಯಾಪಕರು.
He is associate professor only.
ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಏನಂತಾರೆ?
That is assistant ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು.
There is only one post.
There is only one. There are 2 posts of associate professor. One is already filled. Another one is vacant and for which I am due for promotion.
AG has directed to accept notice for respondent number 1, 2, 3, 5. 1, 3, 1, 2,
1,
3 and
2.
5. What about Vajpayee?
My lords, it is, I'll take Amazon
They
notice.
have a separate panel?
Yes, yes, ma'am.
What about
4,
Chamaraj?
5, 6, I'll take Amazon.
ಚಾಮರಾಜನಗರಕ್ಕೂ ಬೇರೆ ಇದಲ್ಲ?
Yes, my lords.
So 1, 2 and 3. Issue emergent notice to respond number 4, 5 and 6. Next para. It is seen that the respondent number 6 is transferred to the post of associate professor from Chamarajnagara Medical College to Atal Bihari Vajpayee Medical University and Research Center, Bangalore. Full stop. It is stated by the petitioner that due to the posting of the respondent number 4, respondent number 6, the petitioner who is awaiting promotion to the post of assistant professor is deprived of an opportunity. Besides this, it is contended that the transfer of the respondent number 6 to the Atal Bihari Vajpayee Institute has resulted in a vacancy at Chamarajnagara Medical College, and that no objection certificates are issued either by Chamarajnagara Medical College or the Atal Bihari Vajpayee Institute. Full stop. Since the order of transfer of the respondent number 6 would result in a vacancy at Chamarajnagara Medical College, it is appropriate to look into the matter. It is appropriate that the said issue is considered in detail. Consequently, the impugned order of transfer of the respondent number 6 as associate professor from Chamarajnagara Medical ಏನು ಚಾಮರಾಜನಗರ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನಗಳ ಸಂಸ್ಥೆ, Institute of Medical
Institute
Sciences.
and Research Center.
To Atal Bihari Vajpayee Medical
College and Research. Center.
Medical
College and Research.
College and
Center.
Research Center, Bangalore.
Yes.
Bracket Annexure A, East State. Till the next date of hearing, list down on date. Put.
7th September.
Obliged.
Here is a serial number 36, you know.
Well, at 36, this is a matter where matter is remanded from the division bench. Subject matter is not non-teaching staff, whether they should be payable as per the state pay scales or not. That's the question. They're all working in private state university and engineering colleges,
No.
but unaided. Whether they should be paid state pay scales or not. The UGC has framed the regulation. Their pay scale should be as per the state pay scales.
Whichever date you want.
Thou-
Except any Monday or Tuesday, my lord, we have labor matters. When any Wednesday, Thursday, Friday, it's all right. now.
ಆಯ್ತು ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ, whichever date. All of both of you decide whichever date.
Well, senior council, whatever date is
ಹೇಳಿ ಯಾವತ್
decided.
ಬೇಕು ಅಂತ ಹೇಳಿ ಸರ್ ಅವತ್ತು ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ.
ಸೋಮಶೇಖರ್ ಯಾವ ಡೇಟ್ ಹೇಳಿದ್ರೆ
ಅಲ್ಲಲ್ಲ ನೀವ್ ಹೇಳಿ ಸರ್, ನಮ್ಗೇನಿಲ್ಲ, ನಮ್ಗೆ ಎಕ್ಸೆಪ್ಟ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬಿಟ್ರೆ ಎನಿ ಅದರ್ 3 days.
ವೆಡ್ನೆಸ್ಡೇ
4th September.
Yes, next.
4th ಅಲ್ಲ 5th ಕೊಡಿ.
With your lordship's kind leave.
Ah.
Serial number 48, my lord, can it come up again next week? My lord?
You will please ask a date,
My lord,
whichever date.
Serial number 52, matter was heard by your lordship wanted to find out from the government advocate whether the letter given by the chief minister is a genuine.
ಅದೇನಾಯ್ತು?
Preliminary list ನಲ್ಲಿ ಬರೆದೆ 57 ಆಗ್ತದೆ.
Letter ಕೊಟ್ಟಿದ್ದಾರೆ. Then we'll have to comment on the chief minister. Well, we have to comment on the chief
transfer
minister
is
issue
not
this
based-
kind of letters casually. ಒಬ್ಬ ಪ್ಯೂನ್ಗೆ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಲೆಟರ್ ಕೊಟ್ರೆ ಏನು?
Court officer. 48 next week. Thank you.
ಆಯ್ತು. ಮ್ಯಾನೇಜರ್ ಇನ್ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್ ಈಸ್ ನಾಟ್ ದ ಮ್ಯಾನೇಜರ್ ಇನ್ ಟೌನ್ ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಮ್ಯಾನೇಜರ್ ಆಗಲ್ಲ. Not on that. Manager in city municipal corporation Shivamogga. Madikeri. He is transferred to Mysuru. Mysuru city corporation. ಅಲ್ಲಿ ಆಫೀಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಆಗಿ.
ಮಾಡಲಿಲ್ಲ ಅವರಿಗೆ. ಇನ್ನೊಬ್ಬರ ಜಾಗದಲ್ಲಿ ಪೂರ್ತಿ ಅವರು ಇನ್ನೊಬ್ಬರು ಚಾಲೆಂಜ್ ಮಾಡಿದಲ್ಲ, ಪೆಟಿಷನರ್ ಜಾಗದಲ್ಲಿ ಹಾಕಿರೋದು.
ಕರೆಕ್ಟ್ ಸರ್, ನಾನು ಕೇಳ್ತಿರೋದು how can a chief minister give letters to office manager, office assistant, peon ಅವ್ರಿಗೆಲ್ಲ ಲೆಟರ್ ಕೊಡೋದು? What is small? Chief minister gives-
Class 12 of the GO itself say no political.
Political influence.
Hello, but I'm amazed how the chief minister gives a letter to transfer an office assistant, CMLA office assistant. And he directs the minister to post him.
Small submission in the same matter. I'm for
Huh?
R4.
ನರೇಂದ್ರ ಸಾಹೇಬ್ರು ನಾಗಪ್ರಸನ್ನ ಬೆಂಚ್ ಇದೆ. ಕ್ಲಾಸ್ 12 ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ.
Correct.
ಟ್ರಾನ್ಸ್ಫರ್ ಕಾಂಟ್ರಾಕ್ಟ್.
Correct. Yeah. In fact, I have directed some disciplinary inquiry to be done against petitioner and respondent for bringing political pressure. But still, how can the chief minister write a letter taking sides with the peon, with the office assistant? Yaro IAS officer, okay, I can understand.
It is beneath the dignity of the chief minister.
Beneath dignity.
Officer.
Issue of the letter. ಆ ಲೆಟರ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿಲ್ಲ.
Sir, whatever is a letter correct, as the chief minister issued that letter.
ಬಟ್ ಆ ಲೆಟರ್ ಮೇಲೆ
Transfer
ಆ ಲೆಟರ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋದು ಬೇಡ. ಆ ಲೆಟರ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋದು ಬೇಡ. ವೆದರ್ ಲೆಟರ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಆರ್ ನಾಟ್. ಮತ್ತೆ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಲೆಟರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಹೂ ವಿಲ್ ನಾಟ್ ಕಂಪ್ಲೈ ವಿತ್ ದಟ್?
casual transfer to the.
I will consider ಯಾವತ್ತು
Tuesday preliminary hearing ಬರಲಿ ಸ್ವಾಮಿ.
Week.
B group ನಲ್ಲಿ ಆಗ್ಬಿಟ್ಟೆ preliminary hearing ಬರ್ಲಿ.
Maybe any week, first week, my lord.
ಯಾವ್ದು ಬೇಕು ಹಾಕ್ಸ್ಕೊಳ್ಳಿ.
Any date in the first week.
First
Serial number 50 for
First
interim
week
order
was
may be
only.
extended, my
Is
lord.
the second
Twice.
or third?
Court officer interim order extend. Court officer?
Sir, 52. Sir, serial number 52.
Sir, 40.
Sir, 52. 37, sir, serial number 37.
Sir,
Serial number 37, anybody?
sir, second list to
37
number
Serial number carried, list number 1. Serial number 37.